Thank you. The Joint Ad Hoc Committee on Family Court Orders is called to order. Will the secretary just note the roll, please? So, ladies and gentlemen, there's a couple ground rules that we're going to put out again today. This is the third out of 5 scheduled hearings dealing with family court orders. Above all, this is not an opportunity to relitigate something that's already been adjudicated in court or is in the process of being adjudicated in court. In other words, we do not want to hear your ex-spouse's name. This is not about them. This is about the court orders and the court's behavior and those things that affect everything from visitation to severance of parental rights, okay? So please put your phones on silent. And we are going to ask that those of you that are speaking, you're going to be given a time limit. We know of a couple of people who have got some rather long presentations. We have roughly 39 individuals who were here at the last hearing. Thank you for coming back. I know some of the people on this list have not been able to return because of travel restrictions, but we will give you first preference in giving your testimony. We're going to try and limit this to about 7 minutes a person. It's going to be a long day. So let me kind of give you what things are looking like. The Senate has been called back into session to begin deliberation on our budget, which means at about 12:30, between 12:30 and 12:45, we will recess for lunch. Members of this panel on the Senate side need to go upstairs onto the floor at 1 o'clock for us to gavel in. There will be some brief business done, and then we'll come back down here and restart the hearing, and we'll go as long as we possibly can to see to it that as many people as possible have the opportunity to testify. Now, there are a couple of people in the room who have to catch a flight back to their city of origin. They are going to be the folks that are testifying first. Just one of those mechanical things that we've got to get done, okay? So, show of hands, how many of you are not from Arizona? Okay, it looks like 5. That's a fairly manageable number. All right. So with all due respect for you, thank you for making the trip. But Arizona residents will be testifying first, and then we will take the out-of-staters, okay? Except for one exclusion. All right, so the first person up on the list is Master Sergeant Stacy Ross. Good morning. If you would, please get the microphone as close to your mouth as you can. And if you, yeah, it bends down. And if, by the way, there's a switch on the desk there to your, I guess it'd be to your right. You can move it up or down to, so you don't have to crane your neck about the. All right, if you would, please give your name, just so that we have it in the record. And you've got about 20 minutes.
My name is Stacy Ross.
By the way, you're going to have to really speak up because you have a soft voice.
Yes, sir. My name is Stacy Ross. I'm so sorry. Despite extensive documentation, I'm sorry. Can I just have a minute? Can I speak next, sir?
You're fine.
I'm not ready. I just need a minute.
I need to have you get close to the microphone. That's not close enough.
Can I have a minute to gather my thoughts again? I need a minute. I'm not ready. I didn't know I was going to be first one. Sorry.
Okay.
I just want to turn in this paper though to somebody.
The gentleman right in front of you, he'll take that slip to you. Or that guy.
Can I go next? Yeah.
Okay. The next one up then, if you're going to take a minute, Adrian, I'm going to butcher your name, Adrian. Breck?
Yeah, it's
Okay. And if you would, Adrian.
it's Adrian Polkorbeck.
Okay, so that you don't have to do what you just did, raise the desk up a little bit so that you can speak directly into the microphone.
Is that good?
Okay, that's good.
Can you hear me?
Yeah, and Adrian, you have 10 minutes.
Okay, thank you. Good morning, senators and representatives. I've spoken with many of you, including Frank Carroll, Lisa Fink, Rachel Kessel, Corrine Warner, and even Shauna Bullock. So thank you for meeting with me there. Now, I have special interest in your subcommittee. By the way, can everyone hear me? Okay, great. My direct experience is what's going on in the family courts. Now, I've had to deal with 11 years of family courts going back and forth. Everything from false allegations and everything from allowing the children to participate in sports. I've had to go to the court. And I can tell you from firsthand experience, the Arizona family courts are a complete clown world. Now, I'm not here to relitigate like Senator Fincham has said, but I just want to let you know that the system is broken. Arizona families are hurting right now because the Arizona judicial system, the family court judges are using and have an abuse of discretion going on. Now, I've got 2 boys. They're lucky to come here with me. I'm on my vacation with them, but I took time out of my vacation because I wanted to come here and speak. Now, my boys are 12 and 14. But what happens right now in the family courts, we have a system that perpetuates financial rewards and perpetuates false allegations against the opposing party. And what that happens is those financial rewards allows the other person to get more custody, and the way that they configure the custody is that whoever has more time with the children, they get more custody and they get more money. And right now, like I say, we're not here to relitigate, but I have an ex that does not want to participate in a 50-50 custody. I've had false allegations against me. I've had to deal with, like I said, I'm not here to relitigate. I just want to let you know what I'm experiencing. I've had to deal with an ex that has parental alienated my kid. He, in 2020, he told my son to run away from my house, where she was waiting down the street, picked him up. And when the police came to her doors, pounded on her door, she refused to open up. Now, if the shoe was on the other foot, I'd be in jail right now. But it's a broken system. Right now, the family courts, they lack objectivity. And they have their own little system of, and they create biases.
Excuse me, Adrian?
Yes.
Are you under a temporary order right now?
No, I'm not.
Okay.
No temporary
I
order.
just needed to have some clarification.
Yeah,
Okay.
no problem. That's all I'm going to talk about. I've spoken to many other parents, and right now we supposedly are under a 50-50 custody state, but there's a lot of parents out there that are going through divorces, and they are
Okay.
not.
Forgive me, I'm going to interrupt you again.
Sure.
Are you currently under a 50-50 parenting order?
No, I only see my children every other weekend.
Okay. And is that as an outcome of some kind of Kobe-related influence or order that has been submitted to the court?
It's under like several false allegations that were
No,
made against me, or
hold
what
on.
are you
We're not
asking?
going to get into the truth or the falsity. I'm looking for fact.
Okay.
Is there a document that a therapeutic interventionist or some psychologist has submitted to the court that the court is acting on to award less than 50-50 custody?
No.
Okay. Please proceed.
Okay. So my focus is on the family courts and specifically the family court judges. Like I said, I've spoken to many parents, and I've spoken to several of you on the panel, and the family court judges are not following the ARS 25403. Unfortunately, the children are suffering. Arizona families are suffering. There's abuse of discretion from these family court judges. Now, it really wouldn't surprise me, obviously it's speculative, but really wouldn't surprise me if these attorneys and the family court judges have a country club together. But right now, 2 judges in particular that have dealt with my case, Rhonda Fisk, who I understand is even the head of the family court division, and Michelle Carson. They work with impunity. They allow false accusations to occur, and what happens when one parent does a false accusation, the other parent gets cash prizes and rewards. So right now, it's incentivized for the one parent to make false accusations against the other. Now, even the appeals judges are no different. There's a free pass for abuse of discretion. Several of the appeals judges that I've had to deal with, like O'Neill, Judge Bearcleft, and Judge Guard, they just allow abuse of discretion. So, what needs to change? I would say a lot of things need to be changed. Well, first of all, this is a bipartisan issue. This isn't a Democrat or Republican issue. This is for their children.
Adrian, if you,
Yes, sir.
if you don't mind, you've made a very broad claim,
Okay.
abuse of discretion.
Sure.
Can you provide a specific example?
Yes. A specific example is, right now we have ARS 25403, Section 6. Which parent is more likely to allow the child frequent, meaningful, and continued contact with the other parent? This paragraph does not apply if the court determines that a parent is acting in good faith to protect the child from witnessing an act of domestic violence, being or a victim of domestic violence or child abuse, end quote. Now, the very fact that my case is void of domestic violence, it's void of child abuse, the fact that my ex has been, and currently, preventing me from getting 50-50 custody, shows that my ex is violating that law. And judges like Rhonda Fisk and Michelle Carson are ignoring your laws that you make. I was actually fined $10,900 by Rhonda Fisk and $15,000 by Michelle Carson for attempting to see my own biological kids 50% of the time. You know, most parents out there would have given up emotionally, monetarily by now because it's well apparent how corrupt the family courts are. We could say we live in a free country, but when we, the people, allow biased judges like Fisk and Carson to rule on the fate of our own biological children in such deleterious manner, what does that say about our country? And that includes those appeals judges too, like Bearcleft, O'Neill, and Guard. Now, if something isn't done in the wording of the law, and something isn't done to regulate judges not following the law, what does that say about the state of our laws in general? Now, there's other states that are having some issues too with family courts. Texas has recently passed Senate Bill in Texas 718 and 2794. Those are to punish the false accusers. The quotation is time taken away, time given back. And also they have a 3 strikes law for false accusations. First accusation of a false accusation is a $500 fee. Second is another $500 fee. The third false accusation is that person goes to jail. And these were authored by Robert Garza, who had spent 14 years in family courts, $750,000 in attorney fees. He had to deal with 43 false accusations. And he persevered, and he got their Senate to pass those 2 laws. Those laws go into effect, my understanding, in September of 2025.
And I'm sorry, Adrian, what state is that in?
That's in Texas.
Texas. All right,
Yes.
thank you.
So having identical bills in Arizona would definitely drastically cut down on false accusations, court time, court expenses, family expenses, and continued infighting within the divorced families and the children's stress. Now, I'm not going to be talking about this at all. I'm just going to say just briefly, I mean, my kids are older, but it's still something that's important. And Tennessee are something that should be considered as well. Now, getting back to ARS 25403, the current law regarding our children, changes need to be placed because family court judges are ignoring the words of and meaning of the law. What we need to do, we need to eliminate judicial discretion. Place the exact phrase, 50-50 custody is the standard for custody. Like I had a really nice meeting with Rachel Kessel and Lisa Fink, and I said to both of them, I said we need to have these laws, and Lisa said something that kind of struck me in the heart. She said, you know, we already have those laws. And I go, you know, they're not following those laws. So if
Yeah,
we
but
already
Bob-
have those laws, they're not following them.
In about 30 seconds.
Okay, yeah, I'll wrap this up. Thank you, sir. So my hope is that we can copy the SB 718, the SB 2794, and require present judges to follow current laws, as well as be held accountable with sanctions or fines of those judges if they don't. And to ending, I don't think we should punish parents who want to be in their children's lives.
All right. Thank you,
Thank you.
Adrian. Members, any questions?
Appreciate
for
the
this
time.
gentleman? No? No questions? All right, thank you very much. And by the way, if you don't mind, if you have the information about the Texas statute that this gentleman is promoting,
Yes.
keep in mind, this body is a fact-finding body.
Mm-hmm.
We're taking testimony. We're trying to gather as much information as we can
Yes.
for legislative solutions.
Mhm.
To answer your question, you're familiar, I'm sure, with separation of powers.
Yes.
The court, as it was so astutely observed in one of our first meetings, is they're going to do what they damn well please. That's why we have an appellate court system. Now, I happen to disagree with that because we all need to follow the law. So that's where we have a little bit of a conundrum between the judicial branch and the legislative branch. But thank you for
The
bringing it
appeals
up.
do the same thing.
Thank you for bringing it up.
Okay.
Appreciate
yes.
it.
Thank you. Where would you like me to leave that? Those?
You can give that to this young man right here,
Okay.
who will give it to that young lady right there,
Will
and
do.
we'll see to it that it's part of the record. Thank you, sir. She's not back yet. Okay, Veronica Baez. Hello again, how are
Good
you?
morning. Good, thank you for having
If you would please give your name for the record.
me. Just gotta go way down.
Because you have come in from afar, you got 15 minutes, okay?
I won't even take that much time. Thank you.
All right. Your
Um,
name for the record?
Veronica Baez.
And you are from?
I'm from Idaho.
Right.
Good afternoon, Chair Fincham, Chair Keschel, and members of this courageous committee. My name is Veronica Baez. I am not from Arizona. I am here because your state has dared to do what so many others will not. Look directly into the eyes of a system that is destroying families under the banner of justice and say enough. I come to you as a mother, excuse me, who has not had her two little boys, Oliver, who's now 8, and Charlie, 6, sleep under her roof in a year this very month. Not because of abuse, not because of neglect, but because I dared to attempt to protect them against those very things. Because of the weaponization of the bench, because of local judges who used sealed documents, closed-door decisions, and weaponized labels to silence the voices of children crying out for help and punish the safe parent who dared to protect them. I am also a doctoral candidate, a Latina, a U.S. Army veteran with over 10 years of honorable service, and a chief operating officer in a successful health tech company. And yet, despite all that, when I entered the upside-down world of family court, I found myself working 3 jobs, and at times still unable to afford groceries. That is what family court has done to me, and I'm not alone. Despite my education, my stability, and my resources, I have barely survived this process, and I am not out of it yet. Most importantly, my little boys are not out of this yet. The opposing party in my case has been emboldened by unchecked judicial power. And if I, with every advantage, am struggling to survive, what hope is there for the everyday parent without my means? Let me say this very plainly. Not even the judges themselves, based on the salaries granted to them by this very Senate body, could afford the third-party experts, therapists, evaluators, and professionals they appoint in the lives of the families before them. That's not an access to justice issue. That is systemic cruelty disguised as legal process. This is not family law. This is judicial terrorism. This is the political weaponization of ambiguous rules and court-appointed cronies used to erase constitutional rights, eliminate due process, and exile children from the care of the very parent who shields them. You, the people before me, and the people working relentlessly behind the scenes are making history today. Not just for Arizona, but for every parent across America who walked into family court to resolve a marriage or domestic contract and found themselves in a battle for their very lives, their physical and emotional well-being, their homes, their savings, and most excruciating, their children's youth and innocence, without cause, without competent counsel, and without end. You are standing against bureaucratic bullying, against weaponized accusations, and against the silencing of safe parents who love their children more than they fear retaliation. Idaho is watching, and I call on my home state Senate to follow your example, to open the doors, to investigate the bench. We must not pretend that silence is neutrality, because neutrality in the face of suffering is complicity. To Chair Fincham and Chair Keschel, thank you. Your presence, your attention, and your courage in holding this space, especially when there is nothing to politically gain, speaks to your integrity. You are standing for the people, and I am certain the others before me are as well. Arizona is being watched, not just by Idaho, but by the nation. Please let this be the moment the tide begins to turn. Thank you.
Thank you, ma'am. Okay, don't walk away quite yet. I got a couple questions for you. Nice try.
Of course.
And I'm not going to put this question so delicately because at this point I don't really care.
Understood.
Would you say that your children's civil rights have been abrogated?
Absolutely.
How so?
They have been put into some of the most deplorable situations that nobody here in this room would think is reasonable. Their voices through their mother, through professionals, has been completely cut off. And there are things that have occurred that if the public could know, if the entirety of my case was not sealed, would cause an uproar.
Okay. Can you tell me in your home state, are the judges mandatory reporters for child abuse?
Yes, they are. It's my understanding.
Okay. If you don't mind, if you could look up that statute in Idaho and send it to us,
Yes,
that would be very helpful.
absolutely.
Ms. Keschel.
Yes, I thank you so much for coming. It's just been an honor to meet you and to begin to work with you in Idaho, and I do think that's very important. And I know Senator Fincham agrees this is a national problem, and so starting to band together to fix this is kind of hopefully what is, as you said, starting here. But my question specifically to his point about your children's civil rights, in Idaho, do they have a guardian ad litem? Do they have a child's best interest attorney? Have your children had the chance to speak to someone outside of the parents, and how has that been?
They have not. There has not been an appointment of a guardian ad litem to our case. They're too young, is what I was told, for them to be spoken to. And I think that there's something that has to be noted is that many times people think when someone gets their parental rights terminated, there's a hearing and there's counsel and there's a process to that. But when you take away legal custody and you put it at 0, and you take away physical custody and you put it at 0, you're essentially terminating parental rights without due process and without it being able to be appealed, argued, etc. And that is quite often what happens. So many people are shut out without actually having a termination hearing or what have you.
Yeah. Senator Fincham, just one follow-up. Because I've heard different things about the guardian ad litems and the best interest, that they're really not helping anyway. And a lot of the times, even if they are speaking with the children, then it's just being disregarded. Do you think that that would help in your situation, or are you with the group of people that, because as we start to think about legislation to push forward with this, we want to do what's best for the families and the kids involved. So what is your opinion on that?
From my research, I don't believe that anybody could help. You know, I've had other third parties, police officers, medical reports. I've taken a polygraph and passed that. There's been a lot, and I will say that everything you could bring in all of the documents. You know, I've paid over $200,000. I've lost my home through the process. I've paid literal kids for cash, and then it still goes to the same judge. And when you put in, I've done an appeal, and I've also done what's called an interlocutory appeal, which is saying that a temporary order, if it is allowed, would have such detrimental harm to what is happening, which is my children in this case, that I would like to go immediately to the Supreme Court. Well, that order, or that request, I'm sorry, I'm not legalese, but that request goes directly to the judge who's bullying me. And so it would have to, I mean, at this point, if everything is saying that it's blue and you go in front of a judge and that judge says, no, it's red, and everybody in the room can see that it's blue, but because she slams her gavel and says that it's red, you don't have a chance. You're spinning your wheels. You're paying for parenting time evaluations that cost you $20,000 just to get started. I believe that was about the amount that I paid for ours, and it doesn't do anything. And so, I really do go back to the reason that I started to speak out and look at other ways is, for a little while there, I was making over $300,000 a year and could barely afford groceries, and that's a true statement. And so if someone like myself can't get through this, the everyday parent just has no chance. And it does. It has to do with that judge's discretion. And that's really, I do believe that if something could be had, I don't know if it's education. Maybe for some judges it is, because I don't believe that all judges are bad. I've worked with some wonderful judges outside of the family court. I was actually a mediator for the courts outside of family court. But you do seem to have some judges that are willfully, I don't know if it's malicious or just plain evil.
I have a couple follow-up questions for you. So in Idaho, because it was formed later in the Union, do you have citizens initiatives as part of your Constitution?
I will have to look at that. I would believe we do.
Okay. And do you have a judicial, do judges have to run for election, or do they have to run for retention?
In the magistrate, it's run for retention. They're appointed to the bench. I did run a retention campaign, a vote no, if you will. And it's people knew that it's not really, I don't know the numbers, I'm not the mathematician behind that, but it's very difficult to get someone out and off the bench. What it did was raise awareness.
Okay.
Mr. Chair.
Representative Fink?
Thank you again for coming all the way down here to Arizona in the heat. I just had some questions because you said it was bankrupting you. We see it here where the court is mandating all of these, interventions and all that. Was that your case as well, that you had a lot of court-mandated expenses?
Yeah, we had a psychologist, or I believe he's a psychologist, who does a parenting time evaluation. I believe that I seen him for a total of 4 to 6 hours, and the bill was in the 20,000s. Mm-hmm.
Okay.
Yeah.
I'm sorry. 4 to 6 hours, $20,000.
Yes. And I'm not the only parent. There's, yeah. So.
Do you have any more questions, Ms. Fink?
No, I'm in the wrong profession.
Okay. I'm sorry, did you say you're in the wrong profession? No, I'd say you're in the right profession. So I guess one of the other questions that I have, and it sounds like you're a pretty astute young lady. When you talk about probably a 14th Amendment consideration,
Mm-hmm.
due process, is there any provision in Idaho law that allows a grievant to bypass a judge who is standing in their way to provide due process? Or, and if you're unaware, I get it, we'll reach out to the Idaho Senate and see what they can give us.
The only thing, and again, it goes back to competence of counsel and the willingness of counsel. The only thing that I was able to push for is the interlocutory appeal, which goes to that judge, and then you ask that judge for permission to go tell her boss, and she says no. And so I'm not sure if there's another way. If there is, it's not being utilized, or I'm unaware of it. And I do know there's the judicial committee, which you can enter in complaints, but they don't help with the actual civil rights process
Okay.
or due process.
Do you have compulsory mediation in your state?
We do, but it's not, I've never actually been to mediation with my opposing counsel, and we've been in this 3 years, or my opposing party.
Okay, and do you want to give the judge's name? If you don't, I understand.
I have 2 judges who were on my case. One of them who has come after me she put in a civil complaint against me. Her name is Judge Diane Walker. And then the secondary judge on our case at the end was Judge Kyle Scow.
I'm sorry. Did you say that a judge has brought a civil case against you because you were in that judge's court?
No, she put in a sunshine. We have sunshine laws that deal with campaign finance, and she put in a complaint against me for me speaking out during the voting season.
Okay, so that was a judicial, non-retention election, and that's the pathway that she used. Okay, I get
Yes.
it. Members, any other questions? No. All right. Thank you very much, ma'am. I appreciate your testimony. We'll probably
you.
be in touch with you for some more research.
Okay, great.
All right.
Thank you.
Very good. Ms. Keschel, next on the list is?
Well, is Stacy back or not?
I do not see Stacy back yet.
Okay, are we just gonna start at the top of our
She
previews?
was asked to go last.
Okay, so thank you, Senator Fincham. We have a list of those of you who were here to testify last time. I don't know if you're present is the problem. So can you raise your hand if you were on the list to testify last time? Okay, because we're going to have quite a few probably that aren't here. Yep, so I'm just going to start at the top. Kyle Killebrew.
Good morning. It's funny, I thought my case was unique
No.
because my ex works in the court system. I thought I was being singled out, and apparently that's not the case at all.
Go ahead and state your name just for the record
Kyle
to start.
Killebrew. Kind of where I just wanted to start was in 2018. My ex-wife put my daughter through a lot of evaluations claiming that she was autistic. We finally ended up going to Phoenix Children's Hospital, and both mother and I had to take some tests, and then obviously they did an autism spectrum on my daughter. Mom's score was a 16. Mine was a 1. Phoenix Children's score was a 1. I presented this to the court along with other evaluations that were very similar from Jewish Family Christian Services and from the kid's school therapist. I honestly felt like the court should have stopped this back in 2018. They left mom with final decision making, but still allowed her to keep on pushing until she got the diagnosis that she wanted. She clearly, this is very clearly Munchausen by proxy traits. During the time, mother also had the kids enrolled in New River, where she lived. So I was driving 100 miles a day, and there was no before or after care. This was very costly and disruptive to my work and all of our mental health, being in the car for hours every day. Appeal court ruling, because she appealed the original decision, stated that although family court's orders gave mother presumptive decision-making authority if the parties could not agree, after a good faith effort, It did not provide mother with unfettered sole decision-making authority. Anyways, for 3 years, mom did what she wanted. I drove 100 miles a day. She at one point was ordered to provide transportation if they were going to be in school in New River. She did that for 6 months and then told me that was a temp order. I don't have to follow it anymore. So eventually, with my son begging to go back to his original school that mom put him in, where they were for 3 years, I filed a motion in 2023 for a school change and for this final decision-making authority. At the time, I also had learned mom was making 4 times what I was, which I had no idea and didn't really care, to be honest. Literally 5 weeks after I filed for the school change and found her income, 5 weeks later, mom took my daughter out of school during my week and put her in Quail Run Mental Hospital, claiming that she was suicidal because of me. More orders that she broke. Literally took her on my parenting time, never discussed any of this with me, kind of stole her out from under me, put her in that hospital, and they wouldn't give her back.
Okay, excuse me. So was that done under a court order, or was that done
No.
arbitrarily by the mother?
Mother did this on her own,
Okay.
which basically took, I mean, she made comments a week or two ago at another hearing we just had, that the only reason we ended up back in court was because I filed for the school change. Well, then how did my daughter end up in a mental hospital? Now she's on Zoloft, she's on Vyvanse. I haven't seen her in almost 2 years.
And do you have a 50-50 parenting time agreement?
Yes.
So how is it that if you have a 50-50 parenting time agreement that the judge has permitted a situation to exist where you have not spent time with your daughter?
Mother claimed I was dangerous to her and that she couldn't make her come to my house.
Okay, be that as it may,
Yes, I know. This is
The
what I'm dealing with
judge-
because my son actually did the same thing. When he saw all this, he didn't want to go back to mom. So my son, for the last year, has been staying at my house.
okay.
And I was just ordered. It turned into a mess. She came to pick him up. He assaulted her. She had him arrested.
Okay, is this a Maricopa County Family
Yes.
Court case? And what's the judge's name?
William Wingard.
Okay,
So my son went to juvenile court. I was hoping that they would take control of the situation. The guardian ad litem that they appointed never spoke with me. I still haven't heard from him. My son begged the juvenile court judge to please let me go back to dad's. He was in tears. I don't want to go to my mom's. She had just had him arrested. They ordered that he went back to mom's. We
Sorry,
had 50-50 custody. I should be clear. We had 50-50 custody up till
just a
2
minute.
months ago.
slow down a second. This
Sorry.
is a question and answer period, okay?
Okay.
So there is no order by the court requiring co-parenting, shall we say, co-parents to behave and be within like a 5225 plan or anything like that? Or is there an underlying order that is just being disregarded?
There's a bunch of them. This
okay,
particular
just a minute.
order for the
There's a
custody
bunch of what?
orders that she disregards for the
Okay.
driving to school, for there's multiple things. My daughter, I found out there was sexual assault on my daughter at her mom's boyfriend's house that was hidden from me. There were
Okay.
police reports I was never even told about.
Okay, so just a minute. Was that reported?
Yes, I have 2 police reports that were hidden from me.
Okay, reported by whom?
Mom and my daughter.
No. To the police.
Yes.
Was reported by the mother
Yes.
to the police?
Yes.
Okay.
I showed the judge all of this. None of it mattered.
Okay.
All the judge went by was Dr. Mellon's testimony, who mom paid to testify. She's a therapist for the court. I never even talked to Dr. Mellon. Never met her.
Uh-huh.
That's basically the judge's testimony in our last court hearing. They took away my 50-50 custody. This was a couple months ago. Now I'm only to see my son 4 days a month.
And this is in family court,
Yes. Yes.
not? Okay.
I'm only to see my son 4 days a month now. My daughter apparently gets to choose at 14, but my son at 13 does not.
Okay.
Obviously because my son's not choosing what mom wants.
All right.
But mom works with the court system. She knows all these judges, and when I asked for a change of venue due to conflict of interest, I was ordered to pay her attorney fees. I kind of took that as a shut the hell up. Literally, I said, you know, she knows these judges, she works with these people, I wanted it out of Maricopa County. What I was told was, you think we can't do our job, pay her fees. So I was charged $2,400 for a response. In total, I think I'm at about $40,000 now that the judge keeps telling me to pay her attorney fees. I don't even have my own attorney. I made $47,000 last year, and she made a couple hundred. It's amazing. It's discouraging. It doesn't feel like I live in the United States of America. I was raised to think you do right, then you're not going to be punished. You would think that I did something wrong. I've had full custody of my oldest since she was 7. I've had 50-50 custody of my 2 with my ex for 10 years.
Okay.
Somehow I lost all my rights, and I didn't do anything wrong. All I
Is
did
there-
was ask my son gets to choose a school.
Has there been any court hearing where testimony has been taken from you to the judge regarding any of this, or
Oh,
is
all
this
of
simply
it. All of
pleading
it.
by?
No, the
the
last hearing
opposition
we had
attorney.
with William Wingard, everything that I presented from the police reports, from the schools, her own father testified on my behalf.
I'm sorry, whose father?
My ex, her father testified, her own dad testified on my behalf that mom is dangerous to
Now
these
I'm following
children.
All right.
None of it was mentioned in the final court ruling. None of it. All they mentioned was that Dr. Mellon suggested that I only see my son every other weekend, and that Kylie gets, which is weird, my daughter gets to do what she wants. So if she chooses to come live with me, is that okay? Heck no. So when they made my son go back to his mom's, he actually got out of the car when she came and picked him up, and he ran to a bank and asked to call the police for help. All they did was come and make him go with his mom, which, like the gentleman said earlier, if that was a woman or a girl that got out and ran and asked for help,
Okay.
they would not have sent her back with the person. It feels extremely biased. And like I said, I thought this was because my ex worked with the court system, but apparently it's not just me.
I'm sorry, your ex works for the court system?
Yes, Miss.
Well, that's an interesting tidbit.
Yeah,
Okay.
we all know who she is.
Okay. Members, any questions for this gentleman?
Mr. Chair?
Ms. Fink?
All right, Mr. Killebrew, thank you for coming. First of all, I wanted to ask just some clarification. You went to the Phoenix Children's Hospital, and was it your daughter that got a 16 with your wife, but you got a 1 with you?
Yes, what was happening was Miss Alcott was telling, she took her to Jewish Family Christian and did a half-hour, intake and told him a bunch of lies and told him that she was autistic. Well, and then put her on Zoloft, all behind my back. When I found out, I went and took the evaluation from the school at Coyote Hills. It was a week long with 4 different people, and showed it to the guy at Jewish Family Christian, and he immediately reversed it. He said, I wasn't given any of this information. This is all contradictory to what mom is telling me. So then we ended up at Phoenix Children's. Same thing. Both of us had to take an exam that kind of led to a number at the end of where Kylie would be. Our daughter would be on the spectrum. From a 1 to a 3 is considered non.
Yeah.
She was literally a 1, which was the same that I came up with. Mom was a 16, which had her on the extreme autistic side.
Mr. Chair, could I have a follow-up?
Sure.
But also, you said that your ex put your daughter into the mental health hospital without your knowledge. If it's 50-50, did you not have shared legal and medical decision-making?
Yes, with her only having final decision after we have a good faith mediation. She didn't follow any of this, and the judge also didn't acknowledge.
Okay.
Like I say, I have a good 4 to 5 orders that were specifically broken, like the one you mentioned with her not telling me and just doing it at her own will. There's many, many instances that she's done this with different things, from schools to doctor's appointments to medications she puts my children on that I didn't agree to.
So, point of clarification, do you have 50-50 medical authority with your ex?
Yes.
And your children had been put on medication without your approval?
Yes.
Okay.
Zoloft, to be exact, and then now Vyvanse also,
Understood.
which is confusing Zoloft for,
Yeah, I get
and
it.
then the other one, like,
I get it.
instead
So-
of diet and exercise, which I wanted to try first, I was told no.
Right.
Because my daughter sits on her phone and does nothing and eats horrible. And I wanted to try some other things first, and I was told that I
Okay.
have the right to do what I want. Sorry.
And you're representing yourself pro se in court?
Yes, for the last 2 years, I'm broke. The driving 100 miles a day also was cutting into my work day. Like some days I'd get 4 or 5 hours of work in. There was no before or after care, and I'm driving to New River. She
Okay.
was ordered to put them in a midway school, and even the appeal court stated, mother argues the question of school choice never really an issue in the 2020 hearing, however, clearly provides that father filed this petition in May of 2019. We were ordered multiple times to find a midway school. And she literally just, and then what they finally did was, okay, if they're in a school by you, then you're going to drive them. She just stopped doing that too. So for
Okay.
3 years of that, it really put a burden on my financial being, my business.
Okay. Representative Kusher?
Yeah, Mr. Chair, thank you. I have a couple, a couple of random questions. My first would be, you mentioned a name that's coming up constantly in these hearings, Kristen Alcott.
Yes.
Did you have other court-appointed advisors or supervisors or therapist interventions, anybody else that
Many.
was?
This has been going on for 10 years, and I've been through, I've had probably 4 different attorneys that I ended up losing each one by the time.
Right.
But yeah, right now they're trying to order us to do family therapy, and I'm
Okay,
like, you know what?
Who
My
is
kids
the
are
therapist involved, if you wouldn't mind me asking?
I don't. Right now, they're ordering us to do family therapy. We haven't
Can-
been appointed to
Can you
anybody.
keep us up to date on that, please?
Yeah.
We'll make sure you have our numbers. And I guess my second question, Mr. Chair, is the police report about the sexual assault. Was that put before the judge? What
Yes.
came of that?
Nothing, and there was 2 of them. What happened was it was at mom's boyfriend's house. At the point that mom wouldn't tell me where she lived, she moved, tried to say my address is protected, which it's not. I've never done anything or been in trouble in my life. If you look up, I've never, nothing, ever been in trouble.
What's the status of those reports, those police reports? Are
They were all just basically closed. One was at school, and then one was at mom's boyfriend's house by his son. They were all hidden from me. The only reason I found out was one night my daughter confided in me when we were talking about men crossing lines with younger women, and I was trying to basically discuss how she should handle and how she should be able to talk to somebody. And she said, oh, like at so-and-so's? And I went, what are you talking about? And she said, when this boy touched me, and when I asked mom about it, she denied knowing anything and said, that's a police matter. And I have the messages on co-parenter that we're ordered to use.
Uh-huh.
So I asked mom, what happened? Why wasn't I told about this? And her answer was, that's a police matter. If I had done the same thing, if my daughter had been sexually abused under my care and I hid it from mom, I'd have been in so much trouble.
Yeah. All right, members, any other questions? All right, thank you very much for your testimony, sir.
Thank you.
Next on the list.
Steve Alcott,
Yeah, that's what I thought.
Michaela Flora, Karma Lindsay,
We have a winner. All right, ma'am, if you would please get as close to the microphone as you can. Give your name for the record, and you have 7 minutes.
Good morning. My name is Karma Lindsay. I'm here because, much like many other people, I thought my case was the only one. And it's come to the attention of myself and many others that this is absolutely systemic. In my case, I escaped my abuser. I was married a second time in my life to my daughter's father. During the time of that marriage, I was financially abused. I was verbally abused. I was emotionally abused. And I left when the abuse became physical. My daughter was just before kindergarten age. He had never shown any signs of abuse to her, but he was abusive to my teenage boys. And when he took off a belt and went after my son, I walked away. It took a long time to get back to a sense of normal after this. And we shared 50-50 custody. During that time of us deciding what was going to be best in the divorce, my My ex-husband said that my oldest son's mental health problems due to the abuse was a reason for me to be on supervised visitation with our daughter. He came after me for supervised visitation only. He decided to rescind that and go to 50-50 when I agreed to waive child support. So when I waived child support, he said 50-50 was fine. And we somewhat peacefully co-parented for several years. My daughter, when she was 12, refused to go with her dad. It was something completely simple in the fact that I had COVID, she had COVID. Her father's an ER nurse, and he was planning to pick her up to go to a birthday party for a grandmother who was in her 80s. And my daughter was very concerned over spreading germs to this grandmother. Emma refused to go. He called the police. The police came, they removed her from my house kicking and screaming, and I was not allowed to see my daughter again for about 8 weeks. Father obtained
Excuse me, you were not allowed to see your daughter again for 8 weeks because of a court order, or how did that happen?
Yes, sir. He immediately went that following Monday and received a temporary order that was, it was I forget what it's called, but it's the kind where they don't invite both parties. He came, he put in for a change of judge. He received that change of judge that same day, which was very strange. And he received also that temporary order that same day. I was accused of drug use. I was accused of being crazy. I was accused of many, many things. And when it came time for us to go in, it's supposed to be 14 days for us to have a hearing, for me to be able to come and show my proof and evidence. When I showed up to the hearing that day, it had been canceled.
I'm sorry, what? You showed up for the hearing on what?
It had been canceled by the courts.
Okay.
So then they rescheduled it. It was rescheduled, and it took nearly 6 weeks to be rescheduled. During this time, I was on supervised parenting time. I was able to see my daughter for an hour every Wednesday and every Saturday at $100 an hour.
And who is the supervisor?
It was whatever supervisor the courts, they had on a list. It was $100 an hour.
Okay.
So to continue with that, we went in front of a pro tem judge. I pled my case, provided my evidence. He pled his case, provided his evidence. He had also reported us to DCS. DCS did a thorough investigation, and during that pro tem hearing, decided that the allegations were unsubstantiated. I'm sorry.
I'm sorry.
The allegations against me were unsubstantiated by DCS. DCS did put in a report for our temporary hearing, and that judge, the pro tem judge that heard our case at the temporary orders hearing, restored 50-50 parenting time. So then this moved through the courts. We're back to 50-50 parenting time. Everything's going fine. We get ready for our final hearing, which was about 9 months down the road. And that judge was the original judge. She looked at the same evidence, considered all of the same evidence, said that DCS, even though they had been the only person who had talked to our child, was apparently not credible. She never talked to our child, who at this time is now 13. Basically, she ordered no drug tests, no family evaluation. She just heard testimony from him, from me. She excluded 2 of my personal witnesses, excluded his witnesses as well. And despite the fact that I provided information, stacks of emails where Father is berating me by email, despite the fact that she, in her order, states that she does believe he has anger issues and control issues, and further ordered him to anger management classes and parenting classes, she granted him custody.
Okay, ma'am, when you say she granted him custody, that doesn't tell me a whole lot. Granted him sole custody, 50-50 custody, some other arrangement?
She reduced my parenting time from 50-50 to every other weekend and Wednesdays. She granted him the final say for educational and medical, despite the fact that, he thought it was perfectly fine to take a child with COVID to a restaurant with an 80-year-old grandmother.
That begs the question, based on what?
Based on his testimony and my testimony.
Yeah. No, it's rhetorical, ma'am.
She further, though, ordered that no other adult may live in my home. That
Really?
included my 19-year-old son, who was going to school full-time and working at my store. That included my then 17-year-old, once she turned 18 and had not finished high school yet. She had to move out if I were going to have parenting time.
Do you have that in writing, ma'am?
I do.
If you wouldn't mind,
It
we would
gets
like to
better.
have a copy of that.
Yes, I can do that. It gets better because she also further ordered that my ex-husband has the right to visually inspect my property and ensure the safety before allowing our daughter to be present.
I'm sorry, this judge's name is what?
Soleil Hancock, out of Yavapai County.
Okie dokie.
So it went a little like this. He came to the house for the first month, every Saturday, or every weekend and every Wednesday, pulled up in front, took a picture and left with our daughter. I have not had parenting time with Emma since then. This has also further allowed him to continue to abuse me. So he, no matter where I live, he shows up in front of my house. He takes pictures. I moved to a place that was further off the beaten path because I was afraid for my safety. And he would be outside with an Uzi, like long gun, 2 miles up the road, the only road to get out of the property, knowing that Thursday is the day I go into work later. And he would be there target shooting, holding the gun and waving merrily at me. I have called the police to enforce our court order, but because he has the right to say whether she can be there or not, I cannot have parenting time. They will not enforce it. And they also further say that this would be stalking and harassment. It would be criminal, what he does, if he was not allowed to visually inspect my property. If he were not given this right to determine this for Emma, the things that he does would be considered criminal. Now, Emma is 16 and a half years old. The only way that we get to see each other for any parenting time is when she drives to a restaurant and we get to have food.
And what's the financial impact been on you?
Excuse me.
Take your time.
I had to sell my home to appeal. I ran out of money for the appeals court, and so the appeal did not proceed. I do not have the funds to have an attorney in order to fight this, and my daughter's asked me not to fight it anymore because she says that the fallout at her dad's house is too big.
And your daughter's how old?
16 and a half.
16 and a half.
Yeah. I had told the court, I testified to the court when we were there, that he has done this to his other ex, that ex has no contact with their child, that he has alienated that parent. I stood in front of the judge and I said, I fear that he will alienate me completely. And I was right. And Yavapai County has not only empowered him, but in my opinion has been complicit to the parental alienation of my daughter, Emma.
Okay. Let's make sure that we get your name. There's some resources that we can get you in touch with so that you can get some assistance. Members, any questions for this lady?
Mr. Chair, it's more of a statement. Thank you. I'm sorry that you're going through this, but I just want to reiterate some things that you said because it is exactly what's happening, just to get it on the record. The family courts are being used by abusers to continue to abuse their ex-spouses 100%. And so I just want to validate what you're saying. I've seen it over and over again. And thank you for sharing your story. I'm sorry for your daughter. You know, from what you've said, I'm assuming she wants to spend more time with you, but she also doesn't want to deal with what occurs at home
That's
when
correct.
she pushes for that. So
Yeah.
I'm sorry for what you're going through, but thank you for sharing with us.
Members, any other questions or comments? Thank you for your courage to come up and speak about your experience, and we'll see what we can do to get you in touch with the resource. All right?
Thank you so much.
All right. All right, next up on the list.
Okay. Nandy Martin. Tabitha Vitiaro Marto. I'm going to totally butcher that name. Is Tabitha here? Laura Graham.
If your first name even sounds like it's right.
Danielle Hessling T. Maureen Mulraney.
Thank you for coming, ma'am. If you would, please give your name for the record, and you have 7 minutes.
I have a PowerPoint that I gave to Landry. I don't know whether I can use it or not.
We've received it, ma'am.
Perfect.
Right now, you got 7 minutes for your testimony.
Then let me just start real quick.
Okay.
My name is Maureen G. Mulvaney. My background is elementary ed and psychology, taught college psychology, master's degree in psychology as well, and drug and alcohol counselor for the U.S. Army, and currently a motivational speaker.
Excellent.
Here today because of my role as a grandmother. And so I wanted you to meet my family. Marie was adopted from, that was my daughter. She was adopted from Vietnam. She had we had two grandchildren, Michaela and Matthew. And this is their picture. And so we did very well until my daughter, 4 months after that picture was taken, took her own life. After years of abuse in the marriage, she couldn't take it anymore because even after she divorced him, he called daily to tell her he would take her children away, and even her blankety-blank mother, who is me, wouldn't be able to help. And that's exactly what happened. And so as soon as my daughter was gone, he eliminated and severed my grandparenting rights. The year was 2019 in December. 2020 was the pandemic. And instantly we go into the pandemic, and now I have to start a legal war with this man who absolutely loves the legal system because he knew how to manipulate it for his first wife and my second wife with my daughter, and now he's married again. He knew every trick in the book, delay, and how to make it very costly. He made it very clear to me that I was now the enemy and he would come after me. I'm a grandmother, for goodness sake. And so I was not even allowed to hug my kids goodbye. As a legal virgin, I was easy prey for this guy. One of the things that I wanted to talk about with this committee is the narcissist, who is replete. Almost everybody who's come up has said this, and there's a whole page that I've got for you to look at on this. They have weaponized the court system, and the judges unwittingly have helped. The solution, one of the solutions would be judges need more tools and training in how to recognize and respond to narcissists who have successfully weaponized the legal system. And will you help us to stop this takeover? So the first person I want to talk about is a court-appointed advisor. Mine was Carrie Rusk, R-U-S-K. High cost, bias, and intimidation were problematic. Carrie Rusk was appointed by the judge. Her total fee was $1,000 to write a report, split between me and the other party. 2021, she had a year. She did not write the report. She did not complete the report. And by a year and a half later, she still hadn't completed the report. So I asked for, how crazy of me to have asked for a refund. The following page shows you exactly what she says, and I quote, "I will not issue a refund. I'm happy to write the report. Raise your hand if you would like a report written by this lady who was already angry because I dared to ask for a refund." I wrote the check immediately and did not ask for the report. This is a small system in this Maricopa County. They all know each other, and they gossip back and forth. She didn't write the report, but her bias, assumptions, and animosity followed me throughout the legal system, asking for my grandparent rights. The next person I'd like to talk about is the forensic counselor, one that has a stranglehold on the Maricopa County system, David Weinstock. David Weinstock's high cost and intimidation are absolutely clear. The specifics are, October 2020, I had to pay $5,000 straight up front. His first email to me was the evaluation will not be completed by the Family Settlement Court date on November 2020. 2020-21, he still has got it. So finally he does the report, and we all know the MMPI is one of the things that is used, a test that is completely valid and used throughout our psychology system to see psychopathy, who's a psychopath, narcissism, and all this. He says, and I quote, he provided an invalid profile in presenting himself in an overly positive manner and responded in a defensive manner. And his report wrote, The test result was not interpreted because he didn't complete it. That's one of the main points. If the person doesn't complete the test, that's used in the diagnosis. He then does drugs. He gets all of the medical records, finds out that he had had 56 prescriptions in 3 years for things like Vicodin, Dermarol, and opioids, and 32 doctor visits. I'm 75 this year. Honey, I can tell you I don't have 56 prescriptions in my entire life. And he had them in 3 years. And this psychologist writes that he no mention of doctor shopping or drug use. Then alcohol. He was convicted of a DWI, interlock system put on, had his driver's license suspended, 6 police reports that were, and I can provide all of this, of course, that went on. Every one of them involved alcohol. 2 divorces, every one of them involved alcohol. The Banner Health says that he's got a medium alcohol problem, but this fellow writes, alcohol, mild, rule out. So either this man is extremely incompetent or he is extremely biased. Either way, I think it's both.
And I'm sorry, which you've mentioned a couple of names. When you say this man, please be
Dr.
specific.
David Weinstock.
Okay, thank you.
Thank you, sir. And it's in this report. I'll send it to you.
All right. No, we've got it.
High cost, bias, and intimidation. His fee was $5,000 just for that report. That wasn't complete on time, but there were other charges that he charged. And he writes,
You have 30 seconds, ma'am.
okay, if the payment is not made, Dr. Weinstock will determine the best actions, may include contacting the court. So what we've got is my solutions are, please eliminate judicial bias because they all talk to each other. I have got a whole page of provide oversight for court-appointed advisors and forensic counselors, establish a funding assistance for visitation-related visitations, mandate transparency and review of adoption-linked terminations, open sealed reports for biological and grandparent rights, pass legislation that protects ongoing parent relationships, grandparent relationship, and please eliminate judicial immunity.
Members, any questions for this lady?
Mr. Chair, I do have one.
Representative Keschel.
Ms. Mulvaney, when you are being in this court battle with this man, what is your end goal for your grandkids? Are
Just
you
visitation.
Just visitation.
Which I was
okay.
granted. And now he has escaped Arizona. We're still in this 6 years later. He violated the court order of visitation, had his third wife take my grandchildren to the Philippines, where her home country. So I have a lawyer in the Philippines. He goes to Kentucky, and I now have to have a lawyer in Kentucky. And just recently, Judge Lisa Wallen gave me visitation of makeup for how long they have kept these kids away from me. And I'm now having to fight in 3 jurisdictions on 2 continents. Talk about cost. I've just given you minimal cost. But like everyone here, I mean, I'll be working to the day I die. And thank goodness I love what I do. But I will be working simply to pay off these court costs. So that's what we're up against.
Members, any other questions? Ma'am, thank you very much for your testimony. I have to say, of all the folks that we've heard over the last 2 previous hearings and this hearing, you've added a great deal of color to...
I'm a motivational speaker. Yeah, I'm not the bad guy, but this narcissist has made me into that.
Well, perhaps there will be a little motivation on
Come
the
on
part
now.
of... Yeah.
I'd love to speak
All right.
for the courts. Here's the copy of this. I don't
Yeah.
know whether y'all
Thank you very
got
much,
that.
ma'am.
Thank you, baby.
All right. Okay, ladies and gentlemen, please, let's not have applause, okay, because this is being broadcast all over the country. And what we're trying to do is not show any bias ourselves in the testimony that we have here, okay? All right, next up on the calendar.
Damon Fiorel, Camille S., David Hansen.
We got a winner.
Oh, sorry.
Yeah, come on up to the microphone. And so that we know who you are, please give your name for the record. You've got 7 minutes. Get as close to that microphone as you can so that we can make sure that we've got sound pickup. Okay?
My name is Camille Swanson.
You're going to have to speak up there.
My name is Camille Swanson. I've been litigating in family court since February of 2019. I have 3 kids, 2 are minors. The big issues that I've seen in this process have been that there are a lot of loopholes between the laws and the statutes and the rules of procedure that are being exploited. There's no data or fact-driven decision-making. So just whatever goes. And really, this is textbook litigation abuse. And litigation abuse is defined the frivolous use of legal motions that are an extension of traditional intimate partner abuse tactics. And that's from the Journal of Family Violence. That's their definition. Again, I believe that there's no continuity of information between the courts, police, just even the IRS, financial issues. There's just no sharing. There are a lot of conflicts and gaps between the laws and the statutes, and the lack of oversight for case participants is really problematic, and which causes inconsistency between the outcomes of the cases. Again, I've heard over and over again some that are similar and then others that are polar opposites. The rights of kids and domestic violence survivors are being violated, and really it comes down to there's a lot of money to be made from all of us. I want to start with a text message I received initially when I heard that this committee was formed. I sent it to a bunch of friends who'd been affected by this. And one of my friends' dads responded to me, which was very surprising. And I'm going to keep their names out of it for privacy.
Yeah, please do.
Hi, Camille. My name is John. My daughter is Jane, CC'd on this text. I've unfortunately been monitoring her emails since she passed away this past Tuesday. That was April 8th, 2025, from issues mainly brought on by her long divorce and custody battle. She never received any child support as promised from the Arizona court system, which from my view are tragically tilted towards the father no matter what. She ended up dying of stress and other issues dealing with raising her son by herself. She just melted away waiting for hundreds of thousands of dollars of promised child support never received. I'm a former state representative from another state. Raise your voice. My friend was there by my side through a lot of it as I tried to be for her. She contacted me last year after her ex was arrested for felony assault against his intimate partner. He was indicted by a grand jury. He faced 3 charges, aggravated assault, DV, impeded breathing, assault, intent, reckless injury, threats of intimidation with property damage. All were dismissed with a plea deal for disorderly conduct, which is basically fighting. So as far as I understand, the DV conviction piece of it was dismissed. It will have no bearing on my friend's son, who is the same age as my youngest daughter. They're in 6th going into 7th grade, so they're kids, they're little. So none of that will be considered going forward, but there's this record. Again, as all this fact sharing and all this information that's available to us is not shared between the courts and police and the agencies and whatnot, because of it, all of it is not considered. So, for example, in my case, we had a custody evaluation. It took a year long. It cost $30,000. That was done in 2020. The last gentleman spoke about the evaluator, who was the same one I had, but I found he actually favored me, which was surprising. But that was disregarded in the case in our final custody orders. We recently had a CAA complete a report this year for $2,000, and it basically echoed the last report, but no one's heard it yet. I've had 4 protective orders. 3 of them were upheld. There have been multiple police reports filed in multiple jurisdictions, many not admitted during trial or hearings for many different reasons. Medical records that cite diagnoses and different things that have occurred with our kids, not considered. School records, things like grades, just static information, not considered. And then things like finances, like we all file taxes. A lot of what this comes down to is money. And because money is used as a tool to manipulate custody, when the decisions are not made on actual facts, it distorts everything, and we are forced to return again and again and again to get the record right. So it just ends up being a mess. As far as I can tell, the courts say we operate on our word, which doesn't work with abusers because they exploit it. Now, the bigger issue for me is the conflicts in the statutes and everything. With protective orders, you have RPOP and whatnot. For example, my custody evaluation noted that my ex had essentially violated 2 that were in the protective order statute, which is 133602 or 3601, which is domestic violence. It cites all the, quote, significant domestic violence factors. It was documented in the report. My only complaint of our evaluator is that he said that he didn't find anything significant, but it was documented. He submitted the evidence to the court, not me, but it was still not considered. So even though he shouldn't have been able to rebut the presumption against the best interests, he did, and he actually has final say for legal decision making, even though it's completely contrary to what the report stated. And that's what stands to this day. And to the point, the judge in that case, in our case, trial, said, well, what's the big deal?
You have 1 minute, ma'am.
Okay, what's the big deal? Treated it like nothing. Ironically, the same judge that we had at our trial is the same judge who presided at my friend's ex-husband's case against
And that is?
the judge,
Yeah.
Kevin Wine.
I'm sorry?
Kevin Wine?
Okay.
Yep. So when you need to have a conviction to invoke your rights, like your victims' rights under the state constitution, I think it's Article 2, if there's no conviction because police won't do anything about it, even in spite of all the police reports and whatnot, there's just no interest whatsoever, you don't have any rights because you can't invoke something. There's no conviction. So you're stuck. And that's what happened to me again and again. So all these guidelines and rules and different things that we have, they're never followed. So we have no rights. Our kids have no rights. Things like ADA rights don't exist if the judge doesn't care. And there's no oversight for appointees. So in our case, we had a court-appointed real estate commissioner. Anybody has the opportunity to exploit this process.
Your time's up. Members, any questions?
Mr. Chair?
Ms. Singh?
All right, thank you. And your name is, sorry, I have your name on this other side. Camilla Swanson. Okay, you talked about, problems with communication. And so are you seeing a communication, are you talking about like police to the judge, the CAA to the judge? What are you specifically looking at where those breakdown is happening?
I believe it's everything. I mean, police have no standing to come into anything. I mean, trying to have police reports admitted, the judge said they would take judicial notice, but without actually having the records, it doesn't help. For example, there's a statute it's a rule of procedure in RPOP that says if a protective order case is done in municipal court, that the whole docket is supposed to be transferred to the family or to the superior court. The problem with that is if you go to have a protective order granted, it's never done in municipal court. It's only done in superior court. So that rule doesn't even apply.
Okay.
Ma'am, are you currently under a temporary order, or was there a temporary order while this was all going on?
Yes, there were a long time ago, at the very, very beginning of our trial. I requested assistance because my ex-husband decided to not contribute anything anymore and started spending and whatnot. And so the judge initially ordered a small sum for child support to be paid. And then a couple months later, my ex decided that he had lost his job, which the court or the decree invalidated. But the judge actually said, okay, you keep paying the $800 a month, and then ordered me to pay $18,000 a month, after deciding that my income was a third of that.
Okay. So the things that you were bringing up around all the evidentiary stuff that was presented to the court, at that time, were you under a temporary order?
Yes. That was, the temporary order lasted from, we didn't have trial until May of 2021. Our temporary orders went for a short period, the first one from, call it October 1 to January 10th, and then from that date all the way through to trial, which was May of 2021.
Okay. You seem like you're very well informed.
I try to be.
Do you know the purpose of government?
Yes. It's to create,
Protect the civil rights of the people.
well, that and create a society that we can live in and that we can thrive in, and
Well,
economy will function.
The primary role of government is to protect the civil rights of the people. Are you aware of and this is kind of an out of left field question, are you aware of a case by the name of Gutierrez
I believe so, domestic violence case?
that deals with temporary orders?
Not sure.
that the court doesn't have to consider them?
No.
The court does not have to consider certain factors when issuing a temporary order because it's temporary.
Right.
You aware of that ruling?
Maybe not.
Okay. Came out of the Arizona Appellate Court.
Okay.
So we'll deal with that in our majority report. All right. Members, any other questions? All right. Thank you very much, ma'am. I appreciate your courage. All right. Next.
All right, David Hanson,
David here?
David Slepek.
Okay.
Jason Baker.
Do we have a winner? Yes. Oh, he's behind the column. Bingo. He's behind the column. All right, sir, if you would, that switch to your right will help raise that thing just a tad so you can get your face right in front of the microphone. If you would, please give your name for the record, and you have 7 minutes.
My name is Jason Baker. Can you hear me good? So thank you again for having this meeting and this committee. It's desperately needed here. My story started back in 2013. I had not seen my ex and I had separated. I wasn't seeing my son, so I filed for visitations and whatnot. Went into court, got the usual, oh, he may not be his. Had to do the biological DNA testing, came back positive, he was mine. Judge ordered my name put on birth certificates, and everything was 50-50 for about a year, and then my ex just kind of started going crazy and trying to take my son from me. And in her first attempt, she was successful for 2.5 years. My son was removed from me for no reason. He had never been hurt, never any issues. He was 2 years old when we started our visitations, and shortly thereafter, he came to me abused. I was taking him to the hospital. It was reported, CPS was involved. 2.5 years goes by, get my son back. 6 months after getting my son back, he's discovered to be psychologically abused, chronically psychologically abused.
And I'm sorry, this came from?
Children's Phoenix Hospital.
All right.
My son had been in therapy since our separation.
Okay.
I wanted everything documented. So during the 2.5 years I was on 4 hours a week, supervised visitation, he was suffering from chronic psychological abuse. He had tried several times to commit suicide, and he was only 6 years old. After this, I finally get him back. And again, there's another issue brought up by mother, and he is removed from both of us this time. This time he's put into a DCS group home where he was sexually assaulted numerous times. This is during COVID, 2019. His mother, the DCS case manager, the group home manager, all got together and decided they were not going to report the crime. And he was kept there for 3 more months being sexually assaulted. I finally got my son full custody of him 2 years ago. Mother just gave him to me because he was running away, no longer wanted to live at her home. Her significant other, and I say significant other because it is not a biological male, it is a biological female pretending to be a male, that insists that my now 13-year-old son call him dad and reaffirm his change whenever he is there. Now, he has not gone and visited his mother or her significant other since I've gotten custody. The reason for that is number one, mother is in possession of a fraudulent passport, which she has used to remove our son from this country and take him to Mexico. She used an old birth certificate without me on it to get said passport. We all know it's fraudulent because you can't do that. There's only 3 ways that you can get a passport for a child. You have the permission of the co-parent, you have a statement from the court giving you full, complete custody, or you provide a birth certificate with only the mother's name on it as father unknown, which in my case was the case because my ex was married at the time. So when our son was born, father was listed as unknown. Currently, my ex is now trying to gain full custody again of our son, despite the fact that she's under investigation for these crimes of taking our child out of the country on a fraudulent passport and for the cover-up of his sexual assaults. Mother just filed 3 weeks ago in court to get full custody. I have no contact. I'm not allowed to know where she lives, even though there is no restraining order on her. And this came out just a few months ago in child enforcement court, which is where I ended up yelling at Commissioner Gia Guantano for lying on her own court papers. I do believe Representative Keschel may have seen the video on that. I've posted it on X and on YouTube. Her lying on the court papers was about mom having a protected address and a current order of protection. She did not. And the commissioner felt it was her choice to lie and say it was true. This put our son in danger because I was forced to give him to his mother while she's still in possession of a fraudulent passport, and she will not cooperate with the police investigation about our son being raped. Our son would have never been raped if family court wasn't dishonest and only looking for money. They take your child and say, you must have mental issues. So we're going to send you to a forensic therapist, and they're going to give you a test. Now, how does this make sense? You've taken my child. I'm emotionally disturbed and distraught, and then you want me to go through a mental evaluation? Yeah, that makes a whole lot of common sense. You're just stacking me up to lose. Well, I beat those. Not because the state people are 100% corrupt. I beat the state's mental forensic people by going and getting my own private forensic specialist, which cost me $800 for 2 hours. And his report came back completely the opposite of what the state said. Go figure. Fact is none of this would happen if judges were held accountable and commissioners were held accountable. We've had juries proposed. That might not be the solution. But having someone sit in that courtroom watching those judges and commissioners, that's going to make the world of difference. That's my time.
Thank you for your testimony, sir. Members, any questions? Great.
Actually, I do. Sorry, Mr. Chair.
Representative, go ahead.
Mr. Baker, just one thing, you talked about juries, keeping them accountable. So do you believe an option for a jury trial would be beneficial in the family court?
Well, I not only would it be it should be mandatory, but I know because of cost-wise, that's not really efficient. But I do know from my own experience that having people, court watchers and whatnot, in the courtrooms and on video calls makes a world of difference. When these judges and commissioners know they're being watched, that changes their attitude. And they tried to prevent me. I have a movie called Fathers that's about my story for my fight for my son. It was being filmed while we were in court, and they were trying to stop it. Dean Cain, Superman, was involved with it. And every step that they came forward, they were like, no, you can't do it. And I'm like, Dean Cain is a registered police officer in multiple states, and you're going to have a problem with my son going on set with us? It was absolutely absurd and ridiculous.
You're aware of Justice Brandeis's famous, it's actually been paraphrased, but sunshine is the greatest disinfectant. Funny how that works. Yeah.
Mr. Chair, I actually do, have a to that point for Representative Fink, because I did run that jury trial bill, and I just want to put any, alleviate any issues when you said cost. Honestly, from what I understand, we did some research. Representative Colladin really looked into it. And as we do the budget, and there's millions and billions of dollars being thrown around, a jury trial for this type of situation, it would only happen in about 5% of the cases, and it would only end up being about $1.5 million a year, which I know that's a lot of money, but in the grand scheme of what we spend, it's peanuts. So it would only be about $1.5 million. And honestly, a lot of the people that are utilizing the courts to abuse an ex-spouse or whatever, I think they'd be a lot more likely to settle if they knew they were going to have to be in front of a group of their peers and air all their dirty laundry. So I do think it's a good option, in my opinion.
My current paperwork, if you look at it, I have a copy for you guys if you want to look at it. It reads like legal kidnapping. My ex is asking for basically to legally kidnap our son
Well,
in this paperwork.
To your point, Representative Keschel, I believe that one of the folks who's going to be testifying, Ms. Lund, is paid well in excess of $1.2 million. So she would probably view that as a drop in the bucket. In fact,
I'm sure if you put all of us together, we've contributed way more than that to the family court fund.
All right. Thank you very much, sir. I appreciate your testimony.
Would you
and your
like
time.
to see these? or-
If you would, please hand that to this gentleman right here, and we'll put that in the record. Thank you very much. All right, next on the list.
Okay, I have a name here, Valence, V-A-L-E-N-C, Valdez. Leslie, it's Valerie Valdez. Yeah, that probably is you, Valerie. It did not, that's okay.
That's a handwriting thing. If you would, Valerie, could you lower the table? You're gotten it. And speak as close to the mic as you can. Give your name for the record, and you have 7 minutes.
It's Valeria Valdez is my legal name.
I'm sorry?
Valeria Valdez?
Yeah.
Valerie Valdez? Okay.
Please proceed.
I'm submitting my concerns on behalf of my son and many other parents who share serious concerns about the Arizona family court system. I'm a licensed insurance agent with 20 years of experience. My nightmare began in 2021 and unfortunately continues. To date, my son's father has filed over 16 motions, resulting in legal costs exceeding $80,000 for me. My serious concerns are for my son's safety and well-being. He disclosed instances of abuse, threats, and physical violence, including being punched and hit in the face, and reported instances of unwanted sexual touching by his father. At only 6 years old, our son has learned to avoid corporal punishment by lying to protect himself in this situation he's unable to get out of. I have filed multiple reports to DCS, including concerning intrafamilial abuse by my son by his father. Despite these reports, DCS has stated that they are unable to intervene because our case is tied to the family court system. DCS explained that they're unable to meet with the father because he refused to speak, and he reverted them to his attorney. As a result, my son's left without protection, and the abuse continues without intervention. These reports are concluding unsubstantiated, which in turn the court interprets as false, reporting by mothers to say it never happened, which is inaccurate. Unsubstantiated means that it is not supported or proven by evidence. Many times it was recommended by my attorney that I not report abuse to avoid losing custody and parenting time, even though it was happening. The safe parent is being portrayed as the problem in the family court system. My son's father was recently investigated by the Diocese of Tucson and terminated following complaints from parents and students regarding misconduct, sexual harassment at the Catholic school where he was teaching. Similar complaints arose at the University of Arizona, where he was also terminated and dismissed in lieu of termination. His lack of judgment is confirmed in his moving from school to school while under investigation. This indicates a failure to disclose his history to the Department of Education, as well as to various schools where he had secured employment. It is hard to overlook this and not see this as a serious problem, but sadly, my concerns have been ignored. These predatory behaviors and poor judgment by the father should be taken into consideration, but the family court system has informed me that, absent of a criminal conviction or incarceration, the father is entitled to request permission to take our son out of the country to the Middle East. I am extremely worried that he will take our son and not return. My concerns continue to be ignored by the family court system. I'm on my 7th attorney, and the ongoing court processes have left me financially destitute. This is a reoccurring issue for me and for many mothers who entrusted the family court system to help protect us and our children from post-divorce domestic violence and interfamilial abuse. We are not receiving the help we need. Instead, we're being censored and ignored. All we ask in our cases to be taken seriously and the children's rights to be established, including the implementation of the Cadence Law, where the family court system can adopt to help provide protections for children in Arizona who are currently trapped without support. I have serious concerns regarding the authorization of international travel in high conflict family court cases, especially when issues related to the child have not been resolved. This analogy they equate international travel and granting permission to allow a child to go to another country as a Disneyland trip. It was presented to me by the family law court in a typical situation where there's no history of predatory behavior, domestic violence history, and no falsified employment applications. I might agree that international travel is safe, but in our case, it's not. As my son's father's attorney shouted during a court session that I would have to deal with, my son being taken, whether I liked it or not, he would be traveling out of the country. The judge never corrected him or stated he was out of line for saying these things out loud. The family court has repeatedly advised me that I need to accept that my son will be taken out of the country because there's no other way around this. They say all parents are allowed to travel, and my concerns were not persuasive enough. A concerning trend in the family court is that decisions regarding international travel with children are being done without consideration of issues with the child or with the parent requesting the travel. It appears there's an assumption that all parents requesting the travel, all parents inherently possesses a right to take their children out of the United States regardless of its high conflict case, which consequently underdetermines the objections of parents who fear no return. The current approach seemingly defaults to granting permission for international travel without sufficient consideration for the potential risk involved. This essentially offers no assurance of the children's return. I believe a more balanced and cautious approach is necessary to protect the best interests of the child. In these cases, the family court system often overlooks the history of domestic violence that led the safe parent to seek the divorce. We urge you to consider these critical factors. Vulnerable children are at risk. Please prevent their removal from the U.S. to countries where American rights are not recognized. When deciding on international travel arrangements, the child's best interest should be taken precedence, especially in cases where there's been a history of vexatious litigation and where there's a lack of cooperation with the other parent, of history of domestic violence and child abuse. We worked with the parent coordinator, and he submitted his final report on April 18th, granting permission to his father to take our son to the country of Cyprus. I believe I provided the Department of Justice report to the PC regarding prevention of family abduction through early identification and the risk factors. There's nine risk factors, and 7 out of the 9 we met. The data can be retrieved online through the Department of Justice. Based on that information presented, it's important to know that I shared that information with the parent coordinator, and that the northern half of Cyprus is under Turkish occupation and the Hague Convention does not apply. Furthermore, even when the Hague Convention applies, there has been instances in Cyprus where children were not returned to their parents residing in the U.S. However, these concerns were not addressed. I want to express my concerns about inaccuracies in the report provided by the parent coordinator. The report did not indicate that I provided responses on certain matters, which wasn't correct, and I already provided information that he portrayed. It's a long thing, but
All right, no, I appreciate it.
just to get the gist of what.
I appreciate it. Well, you've already given me one idea on blocking travel while a child is under the jurisdiction of the court in the state. Members, any questions you might have?
Mr. Chair?
Representative Fink.
Valerie, I just want to ask a few questions. So currently, do you have 50-50 custody?
Yes.
Okay. And so you have 50-50 in regards to legal and medical
Everything.
decision? Okay. And then the other thing is with the multiple charges. So he's had multiple charges of sexual predation?
Harassment, yeah.
Harassment, but they've never gone to a conviction.
Right.
So the courts do not take that into consideration.
They can look at it, but they're not taking it seriously. They just see it as if he didn't get taken in by a police officer, then it's not serious. And I did get I subpoenaed the reports from the diocese and the University of Arizona to show that this did happen, in hopes that they would take that into consideration. But unfortunately, the parent coordinator did not. And he did say things that I didn't respond, like regarding vacation time and such. It was just very biased, his report. So I'm trying to go back to court on this matter, and my hearing is on Wednesday. But it's already been decided by the parent coordinator that he gave permission. So it's really hard to, once it's done, it's a hard thing to overcome.
And the name of the parent coordinator?
Aaron Michael.
Yeah.
Michael Aaron, sorry. I have it backwards.
Okay.
Mr. Chair, just real quick. So he had multiple charges, and why were they not just prosecuted, or he just left from school to school? It sounds
right.
like he's
Once
just,
they start investigating, he would quit.
Okay.
And that's what they couldn't do much. And unfortunately, as I have learned through the system, is that the police department, there's nothing they can do. DCS, there's nothing they can. It's like everyone just turns their back, and this is just going to affect other children, not just my son. And it's just a scary matter.
Okay.
So I'm kind of left with, I'm not sure what else I could do. What are my rights? If it's 50-50, it's not true, because I'm saying he's too little to leave the country. He doesn't know how to come back. But they're saying, the dad is wanting to do that. So that's not really 50-50 decision. It's one-sided, and it's been like that because he's used the court to take control. But
thank you.
Members, any other questions or comments? All right, thank you very much, ma'am.
thank you.
Next.
Leslie? How do you pronounce? Yeah, you can say your last name when you come to the podium, please.
I wouldn't try that either.
Good morning.
Leslie, if you would, yeah, you can raise that if you want, whatever's comfortable for you, so you don't have to lean into the microphone. But get the mic as close to your face as you can. And if you would, please give your name for the record. You have 7 minutes.
Yes. Good morning. My name is Ana Leslie Dritzis. My case number is FC 2017-091852. I am here, similar to a lot of other people in this room today. My case is a little bit different. I am a state of Arizona address confidentiality participant. I have been in that program through law enforcement, and for good reasons. My ex shattered my left ankle. I have 12 titanium screws, nuts, and bolts, and 2 titanium plates in my left ankle. My kids were abused as well, but I choose not to show those pictures.
Thank you.
And we have been stuck in litigation for a very, very long time. My case initially started in 2011. I finally filed for a divorce from my abusive ex in 2017, and I have consistently been dealt some bad cards. What I have found in the family court system is there are a ton of judges who are either unfamiliar with domestic violence and sexual abuse, or they do not seem to comprehend what a ACP participant is. I even had given them my ACP card that was issued to me by the state of Arizona. I even had explained to judges before, like, here's the program, here's what the program is for. Still to no avail with all the judges that I've had in my case. They still requested me and ordered me in some cases to provide opposing party with my actual address, which is completely illegal and against me being in the program. My children and I have had to move several times as a result.
Excuse me, ma'am. Who is the judge that ordered that?
The judge, it was Michael Mandel, and then it was
No, I mean the one that ordered you to give up your address, which is protected by law.
Commissioner Don Walton, and also Judge Stephen McCarthy.
Okay, thank you.
And they don't listen to me. I'm a nobody. So
No,
after.
ma'am, no, you are somebody. We work for you.
Okay.
Let me be really clear on that. Okay?
Okay.
So, please proceed.
So after $85,000 worth of attorney fees and legal fees and therapeutic interventionists and LFAs and all these other things, I had to file bankruptcy. And my 4 kids and I, my kids started out at the ages of 8, 9, 12, and 13. We were homeless. And our friends chipped in and the church chipped in for us to have a stable place. Basically, my ex used that as an advantage and leverage along with his attorney to try to gain the kids full custody. Well, it didn't work. So, and then Dr. David Weinstock. We were ordered to our last TI. After 8 TIs, I had Dr. David Weinstock, DJ Vaughn, Kathleen Mahalik, Annette Ruskin, Sarah Gallimore, Javier Perez, Celeste Corsten, two BIAs, Stephanie Stromfords, Stephanie Presadio, Kristen Alcott, parenting coordinator, we had Ann Schrokenstein, and the list goes on and on and on of how many countless people were ordered by opposing party to intervene on this case.
And I presume each one of them charged you for their services.
Yes, and that was part of the $85,000 that I had to file bankruptcy for, but a lot of them demanded cash payment and would not take credit card payment. So then they went.
One moment.
Yes.
Did they accept insurance?
No.
Okay. Please proceed.
Okay. And then I was deemed hostile, so to speak, or dragging the process or prolonging the process because I didn't have the funds to pay. So the court, what I found is family court leans heavily on these TIs for their recommendations. So then it just turned into a whole bunch of abusive litigation. I filed for abusive litigation June 22nd, 2021. Motion to restrict abusive litigation for opposing party and David Weinstock, and I didn't get anywhere. I also filed a complaint with the State of Arizona Board of Psychological Examiners against Weinstock. And this is its entirety right here because he would lie about me? Well, okay, fabricate the truth is what I've been trained to say. Fabricate the truth and say things that were not true. What he eventually realized is that I'm a person that keeps documents like crazy. I mean, it's like every single thing I can back it up, whatever I say. And then he kind of backed up. So one thing I would like to read here was an email by opposing parties' counsel.
Well, you have 1 minute and 30 seconds left.
Okay, so I just want to read this one part right here. This was not intended for me, but she sent it to me by accident. It says, you'll be contacted by Stephanie Stromfors. Please let her know we would like her to discuss this matter with Dr. Weinstock, collusion. Be overly nice and accommodating to her. She is what we need to take the kids from mother in January. It doesn't get no better than this.
I beg your pardon. So hold on.
Yes.
That email came from whom?
It came from opposing party's attorney, but it was meant to go to him, not me.
So this is an ex parte conversation between opposing parties' counsel,
Yes.
the TI, who is supposed to be a neutral party, addressed to whom again?
It came to me.
No.
The
It
email
came to you
came-
by accident.
Yeah.
We've already established that part. That would be what they call it.
It was Weinstock, Dr. David Weinstock, and Stephanie Stromfors, who they had chosen to be the next BIA for my case.
Okay. Was there a bar complaint filed against this opposing counsel?
I attempted, and I even drove down there, and they told me she already had priors. This attorney had prior incidences. She is on probation and admonition for prior things that she had done similar, but she got away with it, I guess. They told me I can't do anything else until she's completely done with my case.
And this was when? What's the time period?
This was 2021, December the 3rd, 2021.
Uh-huh.
And
Okay.
so it just shows a collusion, and even in my complaint against Weinstock, there was countless conversations between Dr. David Weinstock and her, and then the other.
Just a minute. When you say her, that doesn't tell me who it is.
Opposing party, I'm sorry.
Opposing party counsel?
Counsel, yes.
Okay.
That excluded me, and somehow I would find out. Like, it's like either she would accidentally thinking she's BCCing her client, but because we had the same last name, if she perhaps put in DRIT, she just hits the enter button, and then I'm getting this, and I'm like, thank you.
So in some circles, they call that providence. Just saying.
Okay.
All right, ma'am. We're out of time with you.
Okay.
Have you got any other items that you would like to let us know about that can be handled quickly?
The Kobe process, they tried to take and they did try to take my kids from me. They tried to remove them by police. Police showed up at my children's school and basically cut off the campus. They had police on both ends of the campus.
And this was based on court order?
Yes.
Okay.
And my
Was this-
kids scattered. They all wear uniforms.
I get it.
So
Smart kids. So
Judge
was this a temporary order that this was made?
that was a temporary order, but they
Okay.
tried to deem me incompetent and.
No,
and-
okay. I'm trying to focus on the temporary order.
Okay, yes.
Because time and time again, over the last 3 hearings, it's become crystal clear that one of the biggest problems in this entire system is temporary orders and quasi-judicial immunity. Those two things are the bane of this court's existence. So if you would, the documentation that you have there, ma'am, is that copies for this committee, or
Yes,
is
it
that
is.
your personal copies?
No, these are copies for you all.
I'm particularly interested in the email,
Okay.
the ex parte email between opposing counsel and the TI.
Okay.
All of it, we would love to have copies of. And if you would, could you just put it over here so that this young lady can get it?
Sure.
All right. Thank
I
you
just
very
have
much.
one more thing to say. I just really wish that.
1 minute.
I'm sorry. I just really wish that the best interests of the children would be taken into consideration, because these are innocent lives and they don't understand being ping pong in between. My one son tried to commit suicide several times throughout this whole TI process. And I didn't think it was fair to him to miss 6 weeks of school because he didn't want to participate in
Yeah.
the program.
Well, that's the whole point of Section 403 of Arizona Revised Statutes.
Yeah.
There are factors that are supposed to be considered, and we'll get into that in our majority report, but the court took it upon itself
'Cause
to
this is what
basically
his dad
say,
did to him.
court took it upon itself to say, oh no, that doesn't count in temporary orders. Despite the fact that there's no notwithstanding language in the law,
And the
the
police
court
are
just acted
confused.
arbitrarily and capriciously. Members, any questions for this lady? Representative Fink?
Mr. Chair, Leslie, thank you for coming. I just wanted to kind of clarify along with that email. So Dr. Weinstock was a court-appointed
Therapeutic
therapist.
interventionist.
Okay, so he was supposed to be doing, working with you and getting the information, and so therefore that's very interesting that he sent a letter or an email, or the opposing attorney, legal counsel sent it to him to work to take the children away. Did I get that correct?
Well, it's Dr. Weinstock. Well, it's hard to tell who the email is exactly meant for, to be honest.
Okay.
So what it does is it just proves collusion between David Weinstock and the BIA and this whole process. It's a small community, so they choose who they want to get to sway to get what they want. And these abusers are very smart. I mean, my ex, he makes $500,000 a year, and I was a substitute school teacher. So, I mean, well, still is, but I only make like $70 a day when I have an assignment. And they would deliberately have court hearings on days that I would tell the court, I can't do that day because I'm scheduled to work on that day. And they would just take that day away from me. So, I mean, I'm trying not to get emotional because then it's like I'm labeled in the system as don't call her, she's not reliable.
Yeah.
So how am I supposed to get work?
Representative Kishel?
Yes, Mr. Chair, thank you. So just really quickly, you mentioned about, what was it, 8 TIs? Or
Yes.
Was there anyone in that group that you felt like was actually trying to do right by the parties involved, specifically you and your kids? Was there anyone in there?
I would speak in defense for Annette Ruskin because they failed to have her dismissed because they didn't like her report before she filed it. In my opinion, they didn't like her report.
I'm
And all
sorry,
she did
they-
was state the facts.
Opposing counsel?
Opposing counsel, I'm sorry. Yes. And once they had her dismissed, then she fought to have her actual report entered in the ECR docket because the judge was dismissive and was like, well, you were already dismissed. And she said, no, I still did a report. I mean, I paid her my portion. So, and she fought to have it issued in there. And yeah, and even helped to have the kids, Safe Haven. One of my sons had a Safe Haven therapist, and those records were supposed to be sealed, but David Weinstock was trying to get those unsealed and access those records anyway, regardless of the court order. And that's in here too.
Thank you, ma'am.
Mhm.
I'd like to, if Maureen Mulroney, could you please come back up here for a moment, ma'am?
Oh, we are, her daughter was one of my very close friends that committed suicide. So we are joined.
Okay.
We
Ma'am,
run the same group.
if you would, please get close to the microphone, and if you would give,
Yes.
again, for the record, give your name.
Maureen G. Mulvaney.
Yeah. Maureen, I wanted to ask you this before, and we kind of got rolling on with our group.
Yes, sir.
Based upon your experience, and you seem to be the professional in the room, so I'm going to lean on that a little bit.
Appreciate it.
In your experience, were standards of practice followed in any way having to do with established psychologist work ethics?
I'll be honest with you. I had David Weinstock's report investigated by 5 people around the country that are top-notch in MMPI. They all said the same thing. Now, it was almost laughable. They said, who wrote this report? And I gave the name Dr. Weinstock. And they said, this is absurd. His evaluation and lack of was absurd.
Okay.
Would they testify against it? No, because we are in the psychologist realm, just like the Blue Wall and legal and
Good old boys
others.
club.
Yes, sir.
Yeah. What about the APA standards?
He's right on the edge.
I'm sorry, ethical standards.
I was just going to say, he's right on the edge. He pulled so many different things. He's right on the edge. He knows enough because he has a degree in psychology and in legal. This is why he's so valuable, quote, quote, in the Maricopa system. Mm-hmm. He knows what he's doing. He goes right up to the line, and he doesn't probably go over it, but you're too upset and too financially devastated to even go into it. I don't know how to look at his cases, but I would say take a little review of the results that he gets in all his cases. Very biased.
I guess one of the questions that I've got for true psychology professionals
Yeah.
has to do with why would you need quasi-judicial immunity if you are following established standards of
Thank you, sir.
practice?
Thank you, sir. Thank you, sir. My exact same question.
Okay. Thank you very much, Maureen. I appreciate it.
it.
All right, next on the list.
Shelby Gigich.
Shelby. All right. We have a tall one. Okay, you're gonna have to lift that desk up a little bit. There's a switch.
That's beyond
Yep.
my pay grade.
Okay. If you would, get as close to the microphone as you
I'll
can
try.
and give your name for the record.
Perfect.
You have 7 minutes, sir.
Awesome. Senator Fincham, Representative Keishel, President Fink, all the members of this committee from both sides, thank you so much for this committee. I will be honest with you, I'm very scared to speak today because my lawyer said not to speak anything. But because I have kids, and if you guys want to speak to them, they're in the back. But I want to begin with the jury trial. I know that we always say that we the people, and our Constitution begins with we the people. And it's supposed to be that the people are the source of all the law. But when our founding father created the law, it's a circle. And if you cut the circle, then all the power ends up where you cut the circle. So when you begin with the law, with the judiciary system, with the legislative system, then you have the executive, then you have the judiciary. And if you cut it there, then there's nothing. It's everything there. All the power is there. And the reason for this, that I'm asking for the jury. Why we need a jury? Because we the people, when we put a jury, or the reason why the founding father requested the jury to be at the end, because there is something, I'm going to give something that probably nobody wants anyone to know. There is something that a juror is immune. A juror is there to judge the law and to judge the fact. And if the law is not really according to what the three branches of the government want it to be, the jury can simply say, not guilty, or give whatever judgment they want, and that's it. Even if the law said whatever it wants, the jury can simply nullify that law. And that's where the circle complete. We, the people. And that's where every time we try to put a jury, that jury law somehow gets circumvented, disappear, go somewhere else. They don't want that law to be anywhere. But thank you for presenting the law. Now, President Fink and Keishel, thank you for putting the law, and hopefully it will come back. And if you ask yourself why this law disappeared, because they don't want to give you that power. Because that power, we the people, we have the power to nullify the law. And actually, this is the reason why you cannot retry someone else again. Because if you, and I will give an example, probably I'm going to be up. If you pass a law that says you cannot have a gun, but we, all the people, disagree with this law, the jury can nullify that law. The 12 say not guilty. None of these law that passes by all three branches of government passes. We, the people, at the end, pass the law. And we don't need 12 we don't need 12 people, by the way, for the, you mentioned that the cost. We don't need 12. The state have a simple civil case with four juries, 4 people. You can put 4 people. Now, that's my comment about the jury. I think the jury is what we really need. It's really the check and balances. Final, another thing about our rights. I'm one of the people that the court ordered me not to file anything with the court. Every time I file anything, I cannot even file. You know that this is a law in Arizona? You cannot file anything with the law. I shared all my orders. The very moment you file anything, they sanctioned you. Where's my rights? How am I supposed to protect those 2 kids behind me? Tell me. I don't know. I think the child testimony should be on the record. If you have a child, the child testimony should be on the record. There is nothing behind. Why do you want to take some child in the back, rewrite his testimony, do whatever? Put him on the record. Let everyone see what his testimony is. Another thing, the child's civil rights, the child should have the right to choose a school. Are you studying for him? Who's studying for the child? You, me? If you want to am I going to become the engineer or the doctor or the astronaut? Or my child? Let the child choose which school he wants to be. While the judge in control of that. Why am I in control of that? Why anyone of us in control of that child? Also, why that one parent should be in control of which drug should be given to one child if the child refuses to take that drug. And I will give my experience. My child was dragged, handcuffed, taken to Mine 24/7. The mother signed a paper that, drug him. My son refused to take any medicine, stand there for 24/7. Actually, both of my kids refused to take any medicine for 24/7, not even water, until they released them. Ask him. Ask him. He's in the back. Finally, I think it's worth reducing the emancipation rate to maybe 15 years old. California has it 14. Reduce it to 15. Maybe this would be a better choice. If California has it 14, we can have it 15. I'm a big fan of 50-50 parenting time. I believe that both parents should have equal parenting time. Although until this moment, I still believe that my ex should have equal parenting time with my children. But in my case, I barely see my children. I'm lucky today that I was able to have my children because of Father's Day yesterday. I'm able to have my children today. But that's a pure coincidence. And happy Father's Day to every father here, by the way. And with that, thank you so much.
Thank you, Shelby. I appreciate your testimony.
Thank you.
Members, any questions for this gentleman? Are you under a temporary order right now with the court? Okay. I guess, so has the court awarded a particular percentage of parenting time? I know you said 50-50, but it sounds like it's not.
At some point, they terminated my right for parental right, so I end up with nothing. But because of how, my son came to the court. My lawyer said not to mention any name, but it was Christian Alcott. My son was brought to the court, and they both threatened the child. You can ask him. In the court, both. They put, and there's no record, by the way, of that because they cut the recording.
Okay.
Both of them threatened the child, and they tell the child, you have no father anymore.
Okay.
Your father is no longer your father. And then they drag him handcuffed from the court.
So
and you continue with this abuse. So
here's
sure.
what really confuses me about this entire TI Kristen Alcott
Sure.
group. Okay.
You don't have to ask me, but
okay, please don't talk over the chair.
Sure.
What has me really confused about this situation is this group seems to fly under the radar, justifying their activity as preventing parental alienation. Yet at the same time, they advocate for terminating parental rights, which seems to me to be the ultimate in parental alienation. Am I even close to what your personal experience is, sir?
Let me say this.
That's a yes or
so
no.
My relationship. I will give you a better example. My relationship with my son was probably okay. My relationship with my daughter was she was leaning toward her mother. But after the court did what they did, both of my children actually realized that I am the parent. Both of my children actually liked me now, and they're fighting with me.
That's
so
pretty hard.
what's the parental alienation you're talking about?
Yeah. That's
How
pretty
many?
hard.
Probably the statistics that should be. How many of the children that they were ordered to follow parental alienation classes came back to talk to the other parent? That's the statistics.
How old are your children now?
14
today?
and 12, and both of them gifted children by the state.
Okay.
And
Okay.
honestly, my lawyer said not to let them speak. But Nathaniel is in the back, Sophia in the back.
They're welcome to speak if they'd like.
My lawyer advised not to because they believe that it's
Totally understood.
that we don't have power. Period.
No, you've got power in this group, so we appreciate your time.
And the court, they will terminate my right, unfortunately, and I don't know where to go.
All right. Thank you, sir.
Thank you.
All right. Cassandra Kuntz, you in the room, Cassandra? Come on down.
I'm going to read just
Hi,
because.
Cassandra. If you would, please give your name for the record. Speak as close to the mic as you can.
Yeah, my name is Cassandra
And you got
Kuntz.
7 minutes.
Okay. My name is Cassandra Kuntz. I have been in the family court system since 2019 for my 3 boys. I was initially ordered sole decision making, and Dad was ordered 3 6-hour visits a month due to domestic violence and child abuse. I have been a nurse practitioner and have over 20 years of medical experience in the hospital. I am a survivor of years of severe domestic violence, and I'm now confronting a family court system that has not only failed to protect me and my children, but has actively enabled our continued trauma by becoming aligned an aligned super parent rather than an impartial judge. In 2019, I finally built the strength and I left a violently abusive marriage after years of enduring physical, emotional, financial, sexual, and psychological abuse. That December, after I filed for divorce, my ex-husband broke into my home in the middle of the night, raped and sodomized me. At the age of 37 years old, I lost all control of my bowels due to this assault. I'm sorry. As a result of that assault, I've undergone 3 reconstructive surgeries to repair my rectum. In 2023 was the most extensive surgery that required 2 surgeons, 9 procedures repairing my vagina, rectum, and bladder, and the placement of mesh in my rectum. The last surgery was the most extensive, and I had to recover from that surgery living in a domestic violence shelter in a 10-by-10 room with 3 boys sleeping on bunk beds. These were not minor injuries. They were documented, medically necessary interventions due to the severity of the assault. Dr. Branton was appointed to my case. Dr. Branton is a psychologist and has no medical training or credentials at all. He dismissed the findings of licensed surgeons and falsely claimed my injuries were due to hemorrhoids. I had to have my entire rectum, vagina, and bladder reconstructed from this assault. Dr. Branton laughed at it as hemorrhoids. He mocked my experience. He told me I should be ashamed for not forgiving my rapist and claimed that it was me harming my children for not moving on. His behavior was not only unprofessional, it was abusive and re-traumatizing. After my house was broken into, my children and I stayed in a domestic violence shelter. We were enrolled in the address confidentiality program for our protection. Dr. Branton also disregarded the legitimacy of the address confidentiality program, accusing me of going against the courts by not disclosing our home or school addresses to my ex-husband after the break-in. He claimed the ACP should not overwrite the family court stance that both parents should know where their children live and attend school, directly contradicting the core purpose of the program, which is to protect domestic violence victims. In an effort to ensure our safety and establish accountability, I hired a certified forensic data specialist to investigate the break-in and simultaneous hacking of all our devices and accounts. That specialist was admitted into the courts as an expert witness. He has testified numerous times in the courts. The data forensic specialist produced a thorough report identifying my ex-husband as responsible. Dr. Branton dismissed this expert's analysis, claiming the forensic professional didn't know what he was talking about, accused me of being paranoid, even though in his own psychological assessments of me, he found no signs of paranoia, delusions, or personality disorders. He claimed I made the entire thing up. Even more disturbing is how Dr. Branton treated my children. All of my children have written statements detailing the abuse they have endured at the hands of their father, both before and after our divorce. The youngest 3 told court-ordered forensic psychologist Dr. Ron Lavitt that they had been choked and punched by my ex-husband. Dr. Lavitt took these disclosures seriously and recommended supervised visitation for my ex-husband. Dr. Branton, when he came on to the case, belittled Dr. Lavitt's finding and expertise, dismissed the children's reports, and rejected the recommendation. The only thinking that Dr. Branton appeared to have was to shame me for my rape, alleging that he knew more than Dr. Lavitt. Dr. Branton even went so far as to tell my children they were exaggerating or making up their abuse. Despite the fact that their stories have remained consistent, I have 6 children. All 6 of them have had consistent stories across multiple professionals. In addition, there were 4 separate CPS cases against my ex-husband brought on by third-party witnesses who observed him choking my children. These date back to 2013, before our divorce. They date back for many, many years. We supposedly went through a comprehensive family evaluation. I provided documentation for me and my children dating back to 2008, which was before me and my ex-husband even met. I later found out at the end of this comprehensive evaluation that my ex-husband did not disclose any of his records. He did not turn in a single record. Me and the children had to turn down records from 2008 to 2025. How is a comprehensive evaluation done if not all the records are even reviewed? How can that be comprehensive? That in medicine, that is not comprehensive. Comprehensive is taking all the data and looking at it.
Excuse me, ma'am.
Yeah?
Who's the judge that was involved in this?
So our judge actually changed today. It was Julie Mata. Today we are now under Justin McGuire.
Okay, but the previous judge was who?
Julie Mata.
Okay. You now have a new judge. Has the new judge been privy to any of the previous information or inputs from this so-called therapeutic interventionist?
So he, after, and this is my next paragraph, after he emptied out my bank account at close to $60,000.
I'm sorry, how much?
$60,000.
60 with
Yep.
3 more zeros after it.
I told him at $42,000 that I had no more money to give him. I had sold my house. I told him, I asked him for an estimate. He told me $12,000 more. I sold my car. He charged me the $12,000 and continued to charge me.
And this is
Some
coming
of which
from,
on Christmas and New Year's Day, I got charges close to $6,000.
so, and this is coming from this Branton character.
Yeah,
Okay.
because you must keep a card on file, and nobody's there to even say he's doing work, to be honest.
Okay. You got about a minute if you want to wrap it up.
So I lost my lawyer after he emptied out my bank account. Me and my children were getting food boxes. I'm a nurse practitioner. I have a good career. I've done really well for myself. We were living out food boxes for 3 months because he emptied out my account, overdrew my account, and I could not even pay our rent because of this man. He recommended my kids go to the Kobe for reunification with their father, which I would be footing the bill for. Later, I found out the Kobe is actually, Dr. Brandt makes the money off of the Kobe. He's recommending the courts that I pay this money for him to reunify my kids with their abuser, but I have to pay him to do that. How is that not double dipping? How is that not wrong? He is making it a court order that I have to continue to pay this man who's already emptied out my entire life savings. Lastly, I would like to discuss my children's best interest lawyer, Ms. McEachran. Ms. McEachran interviewed my kids for 15 minutes each via virtual interviews. They told her they did not want to see their father. They reported to her being choked and punched during his very small amount of visitation. They reported to her that he tells them that their mom's a whore, that their mom is a slut, that I'm a horrible parent. During our hearing, Ms. McEachran was connected virtually, was seen on her phone texting the entirety of our hearing. Ms. McEachran told the judge, Judge Mata, that she would leave it up to the judge's discretion. Ms. McEachran is appointed to help protect my children, and she did not once attempt to advocate for them at all. Senator Fincham, I am willing to provide documentation privately as this evidence is part of an ongoing litigation. I am not just telling my story, I am issuing a warning. The Arizona Family Court system, through individuals like Dr. Branton, is actively enabling abusers and punishing survivors, and we have been through enough. My kids have been through enough, sir. I respectfully ask that you investigate this matter and support legislation that requires trauma-informed training, enforces the legal authority of the address confidentiality program, holds psychologists accountable for ethical conduct, requires courts to respect findings from licensed medical and forensic experts, centers and protects children's direct disclosures of abuse. We can't tell children that they're making things up, which is what Dr. Branton has been telling my children. Thank you so much for your time, your service, and for listening to those of us who have been silenced for too long. I appreciate it.
Cassandra, thank you for your courage. Thank you for sharing what must be words escape me on how to describe what you've been through. And I'm very, on behalf of this panel, I'm very sorry that you've been put through this, quite frankly, at the hand of the state of Arizona. It is one of those things that makes my blood boil.
Thank you, sir.
Members, any questions for Cassandra?
Mr. Chair, I do have one. Do you have a protective order against your?
I have had multiple.
You've had multiple.
Multiple charges of breaking it.
Okay. And it just doesn't seem to be. When you take that protective order, because I'm going to tell you right now, Representative Fink and I were we were trying to listen to a recent court hearing, and they wouldn't let us in, of course. So we sat there, waited to be let into the hearing, which is, the judge should not be doing that. Melissa Zabor should not be doing that anyway. But I feel that we are told, whether we go to the judge over all of the judges, that these parents need to follow certain protocols and then it will work out for them. And just recently, a parent who I've gotten to know very well in this process, what was said in that hearing was, well, you don't have a protective order. So maybe if you had had a protective order, that would help you protect your boys. So she's now gone and gotten one. And my fear is it's going to be, oh, I'm sorry, now you need to do this.
Yeah.
Is that what you feel has happened with you? I mean, I guess I'm trying to wrap my brain around, if you have a protective order to keep this abuser away from you, and the court is doing what with that? I guess I'm trying to understand.
Yeah, I will tell you that I've done everything that I'm supposed to do. I've kept every bit of evidence. I've turned it all into the courts. I've gotten orders of protection after orders of protection. I've told the police everything. I've done everything that I've been told to do. I sold my car. I sold my house. I literally have nothing left financially. My retirement, nothing. Just because I thought this was going to protect my kids.
Have you filed the complaint with the regulatory board against Raymond Branton?
No, that is next. That is on my agenda, sir.
Okay. All right.
Mr. Chair, I have one.
Representative Keschel?
I guess I have one follow-up. Because we've heard a lot about the address confidentiality program, which I'm actually becoming pretty familiar with. That's something we need to look at, apparently. Has that been honored in your case? Are you and your kids safe? And has that been honored, or have there been issues with them trying to divulge that information to your ex?
So Dr. Branton is saying that I'm going against the courts right now because I refused to give it. And I gave him the phone number, the card. I told him to call. They told me that they educate judges in the family court system that we're allowed to keep this information private. At the end of the day, a lawyer disclosed our location, and then we had more things happen, and so we had to move again.
Wait, what? An attorney,
an
a member of the bar,
yes, disclosed,
violated state statute by releasing your protected information?
That is correct.
I would like to know that individual's name offline.
Okay.
So please see to it that my staff gets that, all right?
Okay, sounds good.
When did that happen?
It just happened in, I think, November of this past year.
This past year?
Yep, so we moved again because of that. My kids have been uprooted so many times.
All right. We need to connect after this hearing's over.
Okay, wonderful.
Ms.
Thank
Fink.
you.
Okay, Mr. Chair, thank you. Cassandra, I am so sorry for all the things that you have gone through. Hopefully, your bravery here will I'm hopeful that it will help us in being able to address some of these concerns. But one of the things is we hear about all this money being spent. So was everything that you had to pay for, was it all court ordered?
So this is probably my error because I was told for Ron Levitt, if I hired him, my kids would be protected.
Okay.
And I did. And then they required me to hire Dr. Branton. My ex refuses to pay for anything. He wouldn't even pay for the kid's attorney. He'll pay for his own, but not the kids. So I offered to pay because I thought, this is what I have to do. I don't care if I work 5 jobs. I don't care what I have to sell. I will pay this money because this is what it takes to protect my babies. And so I'm the one who said I would pay because I thought, and I was told that this is what would protect my children. And money means nothing to me.
Okay. Thank you.
Okay, let me get this straight. The court has made a demand upon you to engage a so-called therapeutic interventionist, a TI.
A forensic psychologist. We haven't had a therapeutic interventionalist.
All right, a forensic psychologist. They kind of changed their names, whatever. The court,
okay.
Yeah.
Okay.
It's the, I want to say the title du jour Depends on what their function is for that day. So the court is requiring you to engage this individual, and the opposing side refuses to pay for it.
Yep.
Yet you're told that if you don't, there could be an untoward consequence.
Correct. Julie Mata actually said in court that I was potentially parental alienating my kids because they wouldn't go.
I'm sorry, what?
Julie Mata said in court that I was parental alienating my kids because they refused to go. And that's what thwarted me towards paying this massive amount of money to Dr. Branton, because I was told by my lawyer, she already has it in her head that you're alienating them. She's already got this preconceived notion about you.
So much for the presumption of innocence.
Exactly.
Okay then. All right. Cassandra, thank you very much.
Thank you.
You're a courageous woman, and I appreciate you coming today.
Thank you so much. I appreciate it, and thank you for your guys' help. We really appreciate it.
We'll do what we can. All right. Next up on the list.
Stacy Ross.
Ma'am, if you would, please give your name for the record.
Yes,
And
sir.
if you need to drop that a little bit so it's not poking you in the nose, that's fine. But your name for the record, and as I promised, you've got 20 minutes.
Yes, sir. My name is Stacy Ross, and I'm a retired Master Sergeant for the United States Air Force. Good morning, Senators. I'm so grateful to be here in front of you today. My name is Stacy Ross, as I just said, and I'm a former United States Air Force Master Sergeant, seasoned healthcare provider, and mother of 3 sons. I'm here to ask this panel for accountability by sharing my testimony regarding substantiated child abuse, domestic violence, military negligence, and judicial misconduct that have endangered and traumatized my children and shattered our faith in the systems meant to protect all families. While married to a former Army service member stationed at Fort Bragg, I was sexually assaulted, which was documented in my military medical records. I reported this to the local police department years later, and the case does still remain open. But there is no federal statute of limitations for rape within the Department of Defense, sir. In 2022, the abuser's NSA clearance was denied after he admitted to strangling me, confirming the credibility of my report. Yet no criminal charges have been filed, and military agencies dismissed the abuse as a civil matter. My former spouse raped me 3 weeks after our first child was born, which resulted in a significant injury requiring sutures to close. The sutures were ripped open during the rape, leaving me permanently disfigured, as well as incontinent of stool and urine. In 2017, while stationed at McConnell Air Force Base, he strangled me unconscious and threatened me at gunpoint in front of our 3 children. While stationed at Fairchild Air Force Base, I filed an Air Force Inspector General complaint after suspecting child abuse at the Base Child Development Center, which is an on-base daycare. I discovered that the CDC, which is the daycare, lacked the required closed-circuit television monitoring. Despite written proof that the base leadership was aware of their noncompliance, and I have that in email, I was told no findings were made. The absence of action allowed young military children, not just mine, to remain vulnerable to unmonitored harm. Between 2020 and 2021, the United States Air Force Central Registry Board, which is equivalent to a state CPS, officially substantiated child abuse, neglect, and sexual abuse involving my children at both Fairchild Air Force Base and Luke Air Force Base in Arizona. These were not allegations, they were substantiated findings following internal military investigations, which resulted in my receiving an expedited transfer military orders from Washington State to Arizona. I have no friends or family in this state. I am selectively alone. So I got the expedited orders here for my safety and the safety of my children. After my ex continued to sneak onto the base after the wing commander barred him from entering a federal military installation, they had to physically remove me from a state and move me to a different part of the U.S.
I'm sorry, was that here or in Washington State?
I was moved from Washington State to Arizona, sir.
No, I'm physically the removal, the base commander thing.
That was in Washington, sir. He tried to get onto Luke Air Force Base as well, but he was not successful.
Okay.
Despite this, the CPS and civilian law enforcement were never notified, in direct violation of 10 U.S.C. 1787, requiring military to report child abuse to state agencies, and DODI 6400.01 as 6400.03, which mandates coordination with civilian authorities, which never happened. 3 bases, nothing ever happened. 2021, 2022. Kansas substantiated the sexual abuse of my autistic son in 2022. In the state of Kansas, the Kansas Department of Children and Families, DCF, substantiated the sexual abuse of my autistic son. The abuser appealed, and after a thorough legal review of the Kansas Office of Administrative Hearings, upheld the findings in March of 2025, yay, making it final and binding under the Kansas state law. But that did me not a bit of good here in Arizona, because the family court in Arizona does not recognize organizations like other courts of equal or higher level here, which is a direct violation of every federal law. But I reported everything to law enforcement, to the Air Force, to the Army. But Army CID falsely claimed that they had investigated the military sexual trauma 14 months before I ever filed the complaint, which is impossible. OSI, CID, and the Family Advocacy Program in the military all failed to act despite their legal duties to investigate and refer these crimes. Because I was frustrated by the inaction, I escalated my concerns to Congresswoman Kathy McMorris Rogers, who back in Washington, referred my case to the Congressional Armed Services Committee. Just months later, President Biden, 3 months later to the day, he signed an executive order 14062, amending the Uniform Code of Military Justice, which is the UCMJ, to address crimes like child sexual abuse and domestic violence through the newly created Office of Special Trial Counsel. Despite this, no one revisited my case. The Office of Special Trial Counsel has failed to review these substantiated findings, allowing abusers to walk free while victims remain unprotected. Because the military refused to act, I was forced to protect my children alone in family court, leading to financial ruin, loss of my military career, and a lifelong trauma for my children if it doesn't stop. The Maricopa County Family Court continues to ignore the military's and Kansas's affirmed abuse findings. They have ordered reunification with the abuser, endangering my children further despite violations of federal laws, including the Adoption and Safe Families Act, ASFA, the Child Abuse Prevention and Treatment Act, CAPTA, the Americans with Disabilities Act, the ADA. My eldest son, who has autism, was sexually assaulted. My youngest son sustained a traumatic brain injury, which is he's symptomatic with. Both have long-term emotional, cognitive, and medical challenges as a result of their biological father. And yet, courts and military leadership refuse to intervene, violating the very protections that are federally mandated, while judges become emotionally entrapped and aligned super parents rather than remaining impartial. Despite extensive documentation, Central Registry Board reports, police records, Inspector General complaints, Department of Children and Family rulings, and medical evidence, letters to the Arizona Attorney General, Arizona Board of Behavioral Health Mental Examiners, and the Arizona Department of Public Health and Services, everybody's been ignoring me. They've ignored mandatory reporting laws, obstructed investigations, silenced medical and legal facts, repeatedly placed my children in harm's way. That's what our Maricopa County Family Court has done to my children specifically, and I'm just a visitor here in their state, trapped here. This is more than a personal tragedy. It is an institutional betrayal of all families and vulnerable children who should have been protected under the law. I respectfully urge your office to take the following actions. Refer this case up to other committees and maybe some criminal charges. At this point, I think that we all kind of deserve a little justice. Request a U.S. Department of Justice Civil Rights Division review of military and judicial misconduct, please. Audit the Department of Defense's compliance with family advocacy procedures and mandatory reporting under Department of Defense Instruction 6400.01. Ensure this Office of Special Trial Counsel, which is brand new, fulfills its mandate under Executive Order 14062 by prior President Biden by reviewing and prosecuting previously neglected substantiated abuse cases. initiate a GAO investigation into possible misuse of Title 4D and 4E funding where child safety and federal disability rights are ignored by courts, support emergency protective measures to halt and the forced reunification of my children with their abuser, please. Rule 81 needs to go. Pursue a formal inquiry into the conduct of military leadership and investigate agencies at Fairchild Air Force Base, Luke Air Force Base, Seymour Johnson Air Force Base, and Fort Bragg, North Carolina, sir. I am ready to testify before anybody you put me in front of and present all supporting documentation. I'm not asking for sympathy, and I'm not here for vengeance. I am asking for justice, for oversight, and for the protection of my family and all the families in Arizona who are still trapped in silence and fear. Thank you for your time, courage, and commitment to justice.
Thank you, ma'am. Are you currently in family court here in Arizona? And if so, under what judge?
I am here in family court under Judge Amy Kalman.
Okay. Is there a temporary order in place?
There are no temporary orders. I have 50-50. Father has final decision making. He lives in another state. And he is currently getting supervised parenting time while we are doing the therapeutic reunification process.
Okay, let me get this straight. He has final decision making on health care, but he doesn't even live in this state.
That is correct, sir.
Sounds like a miss to me, but okay. Have you been ordered to interact with any so-called therapeutic interventionists or individuals in the psychology world to do an evaluation of you or your children?
Yes, sir.
And can you tell me what that looks like? Has there been an outcome? Has that been resolved? Are you currently engaged in that?
That's a complicated question, sir, because just like a spider's web is sticky as well as a net, I'm not quite sure. Yes, my children and I have been doing the therapeutic intervention process. I have had a psych eval, normal, healthy, I'm good. And now they want me to do another one, a focused family assessment, but that provider withdrew. So I'm sure there's another one coming.
Was there a reason that provider withdrew? Did they give you a reason?
He didn't give me a reason, no, sir. But I imagine it's because he lied to me about the federal HIPAA laws, and I called him out on it on the phone. What was a provider? And so I know the federal HIPAA laws, and so I know them very well. And so when I quoted them back to him, he withdrew.
Uh-huh. Were you threatened with vacation of your parental rights?
No, I was threatened that if I did not comply specifically with all of the instructions, that custody would be reversed to the father who lives in Kansas.
When was that, man?
When was
that threat made?
Every single time I go to court, sir.
Oh, all right. So it's an ongoing thing.
Every single time I talk to the courts or their appointees.
And
yes, sir.
have you had the same judge for this entire period of time?
No, sir. She came in very early. The case, the first judge, I don't remember his name. That's how short he was there. And then I got Amy Kalman.
Okay, so you've been with this Kalman judge for
a while.
The majority of the time that this has been going on.
She's made all of the rulings.
Uh-huh. Uh-huh. Okay, members, any questions? Representative?
Mr. Chair. Thanks, Stacey Ross. Thank you again for your service as well.
Thank you, ma'am.
I appreciate that. I had worked with parents to ban reunification camps. And so I hear this reunification therapy, and I'm wondering if it's a workaround, these reunification camps. And so my question is what is the basis upon, it looks like they're mandating reunification therapy, correct?
Yes, ma'am.
And so what is the basis upon that?
So it's pseudoscience. So there's no actual science based on any of this. I think they're trying to write the book here in Arizona as we speak, because I've never seen it, and I've been around the world. I was 21 years military service. I've literally been around the world. And I went through a divorce in Washington State, and Washington State is also a Democratic state, and it was not this rough, and this is just custody. Okay, very rough here in family court.
Okay.
Any other questions? All Thank you, Master Sergeant.
Thank you for your
And
time.
by the way, thank you for your service.
Thank you for yours
We
as well, y'all.
appreciate you.
Thank you, guys.
All right, let's see. We're at, next up.
Next is Molly Finley.
Molly?
Okay. Megan Schubert. Beth Hennon.
Okay, come on up.
Okay, if you would, please get as close to the microphone as you can. Give your name for the record, and you've got 7 minutes.
All right. My name is Ariana Askew. I am a 17-year-old survivor of child abuse and witness to domestic violence. I thank you, Senator Fincham, and those who have given me the opportunity to voice my family's horror stories in the family court system. Today I will be speaking on my mother, Anya Askew's behalf, who could not be here to share her story. My mama was here at the last hearing and wanted so badly a chance to speak. So she wrote down her name for today. I will be taking it. She was wrongfully and illegally thrown in the Coconino County Jail for 5 days on June 13th. Given the over 5 years of abuse and suffering, there of course is more details to our story than what I'm about to share. I have gathered all of our evidence that the family court has refused to consider and put it in a hard drive that has been given to her for review. I was 8 years old when my wonderful, loving father died. My little sister and brother were 4 and 3. My mother remarried thinking she had found some stability, and we took him into our home, just excited to have a dad. She was pregnant with my little brother when what was once emotional and mental abuse eventually became physical. That began behind closed doors, eventually spilled over into public view, and my siblings and I became unwilling witnesses and victims to who I once called stepdad. The week before Christmas, December 2022, forever changed my mother's life. He had been fired for being intoxicated on the job and even threatened suicide. The extreme unstable behavior me and my little sister had recorded on our Apple Watches is a small part of the evidence that was ignored. December 23rd, 2022, they were separate but working on the marriage. Despite this instability, he insisted on taking their son for visitation at his place, which we could not argue with. My mom called to check on her son and heard him crying on the phone. When she went over to check on him, she had gone 3 times prior just that week. He started recording on his phone, "I don't want you here, get out." She responded, "I will in a minute." I was worried about my son, that's what she said. She was there for a total of 7 minutes. It didn't matter that she had ample documentation of abuse and alcoholism. It didn't matter that she was there for her baby's safety or that she feared he was going to shoot her son and then himself. They were attacked in that 7 minutes and thrown to the ground. They were bruised from the altercation. She went straight to the police station and reported it. She asked for the help that everyone says for you to ask for, and no one cared. That disgrace of a man walked away without accountability. Meanwhile, she was put on probation for a felony charge for trespassing. She showed up to court for the first time on January 3rd, 2023, unprepared and without legal representation. We had no money. She's a single mother. I was there and testified to the abuse myself, and I was dismissed. My mom had never experienced a court hearing in her life. The judge, Brent Harris, dismissed her order of protection despite clear evidence of abuse, pictures of bruises, video and audio footage, witnesses, and documentation of alcoholism. But the most shocking part, the opposing counsel filed for an order of protection against her with no documentation to support their false claims, and it was upheld. Her voice, her evidence, and her plea for safety were ignored. Harris didn't even try hiding that he knew Brian Middlebrook and Taylor Hutter personally and made jokes during the hearing making a mockery of our trauma. They were the opposing counsel. This was only the beginning of what would become a 2.5-year nightmare in Arizona's family court system. On July 14th, 2023, Judge Harris made an illegal ruling to revoke her parenting time with my 3-year-old brother and ordered that she undergo a psychological evaluation. Harris ordered that she pay her abuser $3,500 in legal fees and restitution. She immediately went and had the psychological evaluation completed. The results of this were that she had severe PTSD from abuse and separation anxiety from being apart from her child. Otherwise, she was above and beyond a fit and mentally stable parent. Judge Brent Harris denied reinstating her parenting rights despite meeting the demands in his illegal order. She obtained a second psychological evaluation, neither of which were inexpensive, might I add. We didn't see my brother for 11 weeks of his life, with no contact with him outside of supervised visitation, court-ordered, at a sketchy park in Williams. We were supervised by the father's creepy stepdad. He followed my mom to the bathroom with Luke, made comments towards family members, and even harassed me on multiple occasions. She didn't even have a say in where we would meet him. We were recorded the entire time and subjected to the trauma of my little brother being taken away, screaming for his mother each time. After 2 months without even speaking to her 3-year-old, with help from the church, wonderful people in the community, my grandmother, and my 92-year-old great-grandmother's retirement funds, we were able to collect another $20,000 to pay the retainer fee to hire an attorney capable of filing an appeal. The 55-page appeal was upheld immediately, and her baby was finally able to come home. There was never any drug abuse, alcoholism, or physical abuse on her account, yet the actual abuser failed his court-ordered alcohol testing and never lost any parenting time. After the appeal, it was time to solidify the final parenting plan. She was told it would be another $40 to $50,000 to litigate in court for her rights as a mother. At this point, my family had spent over $200,000 for legal representation, and we had nothing left financially, so she settled out of court, agreeing to let her abuser continue to have the final legal say. In February 2025, my brother's therapist filed a DCS report after bruises appeared on his wrists. This was the 8th time DCS had been involved, though never at our request. Despite sympathizing with our family's situation, they couldn't help, advising her to file a police report next time. Just days later, my brother came home with a bruise on his stomach from his dad's girlfriend, after he told her, in his words, "You're not my mommy." Even with the involvement of DCS, a detective, therapists, pediatricians, and my brother's school, the investigation was closed because there wasn't enough evidence to press charges. She was told there was nothing she could do to protect him and was accused of coaching him by a forensic investigator themselves. My little brother, who is now 5, still suffers from severe separation anxiety, and I live in fear of what will happen if she can't afford her attorney, knowing the abuse will never stop. The post-separation abuse through the legal system is being used to hurt mothers everywhere, using their children as pawns. I respect your request to focus on personal accounts, but I feel it's important to mention that a class action lawsuit is underway against Judge Harris, who remains on the bench in Coconino County. He has harmed many families, including mine, and countless others who are unable to be here to share their stories. While I'm not leading the lawsuit, I am committed to sharing and supporting from my own experience. There is also a petition to remove him from the bench, which is publicly available. My story is just one of many over the past few years. Today, my mom sits in jail, unlawfully, and away from her children who need her now more than ever. The order of protection and probation was used against her simply after saying hi to her child, not approaching his father at a public event. His dad happened to bring my brother on the same day as us as bait and set her up to have her arrested. Our abuser made a false police report saying she followed him around despite 20-plus witnesses who would say otherwise. Her corrupt probation officer, Ryan Vilte, ordered her to come to his office and be arrested without cause or show any evidence. We could not argue, or he threatened more time in jail. I drove her and said goodbye to her as they took her away in cuffs. She is now being threatened with 7 years prison time for having possession of a hand-me-down shotgun from my great-grandmother that doesn't even work. We don't have ammo for it, and she simply forgot it was in the closet, but our abuser knew where she kept it and anonymously reported it. October 17, 2024, she served 24 hours in jail for this, scarring her and my family forever.
Excuse me, ma'am.
I'm so sorry.
Is she a convicted felon?
She is.
She is or is not?
Wait, I don't know.
Okay,
I don't
because
know.
in this state, it's not illegal to own a firearm.
Well,
unless
she
you're a
was under
convicted felon.
probation. She was under probation because of the trespassing. She was under probation for the trespassing.
Family court probation.
Family court probation.
Not superior court probation, family court probation.
Yeah. And
Deals
she
with
had
a
a
family
firearm.
matter.
It was a hand-me-down firearm from my great-grandfather that doesn't even work. It is like really dangerous to even use. And we don't have ammo for it. We don't know how to use it. She just has it in the back of her closet, like in case an intruder comes in. I don't even know.
All right.
But yeah, so she's in jail right now.
You have about a minute left.
Okay.
Let's get it wrapped up.
All right. Yesterday, I should have been celebrating my real father, the most wonderful man who could never dream of the things we were going through without him. Instead, I am here hoping for justice against an abusive, narcissistic man who is an unfit parent and will never deserve the title of my dad. My family is desperate for help, and we need justice before it's too late. Thank you for your time. all I had.
Thank you, ma'am. Members, any questions?
I know a lot of details about it. My mom keeps me in the loop, so if you had anything.
Okay. Well, if you would, please forward those to my office. We'll make it part of our majority report. So is she currently in custody for this alleged offense against the court?
Yeah, she said hi to my little brother at a public event because
Okay.
my ex-stepdad brought my little brother at the same day, and he never ever went. You know, she goes every year. You know, she's a very regular visitor to this event, and he never liked going. He refused to go whenever my mom wanted him to when he was with us.
Okay.
And so he just so happened to bring my little brother on the same day as her and set her up, basically.
Okay.
And he is in cahoots with my mom's probation officer, Ryan Viltang.
Okay, so this Judge Harris is a family court judge?
Yep.
Is there any other judge that has got their finger in the pie of this situation?
My
For example,
grandmother
juvenile
knows.
court or superior court or some other court? Yes, ma'am. If you would, please give your name for the record.
Yes, I am Charlotte Deaton. I am Anya Askew's mother.
Okay.
And I've been very involved in this case, and I've spent about $200,000 of my retirement
Okay.
trying to protect my daughter and my.
Okay, so help me
So,
understand, just a
yes,
moment.
there-
Is that money that's been paid to the court or lawyers? Or is
Both.
that money that's been paid to these
Both.
psychology folks?
All
and
three,
then
all.
also lawyers.
It's all gone to attorneys then?
Yeah.
Attorneys, evaluations. She was
Okay.
ordered to pay William the
Okay,
abuser.
ma'am, just a
So-
minute. When you say evaluation, I'm trying to get to, is this by a psychologist?
Yes,
Okay, so there is a component of that in the cost. All right.
yes.
So are we in front of one court or multiple courts with this
We're in
matter?
front of a criminal court. For the trespassing, they charged her with a felony. With the shotgun, they've charged her with a Class 5 felony. So there's multiple charges.
I'm sorry,
Yes,
felony trespass?
they charged her with felony trespassing.
Who charged her for that? Was it the sheriff's
Judge
office?
Brent Harris.
Okay, so that came out of the court
That
as a
came out of the
charge.
court. That came out of the court. Well, no, there was a different, no, that's a criminal court.
What's the other judge?
Judge Slayton, well, let's back up. Brent Harris was removed from the family court system because of an appeal filed by Anya's family law attorney, Chad Winger. He was removed from, it was upheld. And there is ongoing class action lawsuit against that judge.
Okay,
Judge Slayton, who is current judge, was friends and his mentor. So he is the judge that's ruling in family law.
okay, so Harris is out of the picture, supposedly.
Well,
Slayton is now taking the lead on this thing.
yes.
Since when? In some kind of span of time? Since first of the year?
2012, a year, roughly a year.
Okay, so he's got a bit of a history with this case.
Yes.
Okay. Members, any other questions?
There's massive documentation of the abuse, so we
Okay.
have it. We'll
All right.
send it to the
Thank you, ma'am.
committee. Thank
All
you.
right, I appreciate you guys coming up. Thank you. All right. Next.
Okay.
We've got
Steve-
time for one more, and then we're going to, by the way, recess so that members have got an opportunity to get lunch. Y'all can get lunch yourself. We will probably be back here somewhere around 1:30. We have floor activity and duties on the second floor in about a half an hour. All right? So, next on the list.
Steve Gottlieb.
Gottlieb? No?
Karina Norland. Is Sherry here? Sherry Lund? I didn't think I saw her today. Okay, Kasazi S. There's no last name. Let's see. Valerie Bertrand. Cherry Prilo. Chastity Flores. Sorry, this is my old list from last time. David Hamu, Christine Hiller, Samantha Gibson. Oh,
Nah, she was faking.
come on up.
All right. Okay, ma'am, if you would, please give your name for the record. Get your as close to the mic as you can. And you have 7 minutes.
Thank you so much. My name is Samantha Gibson. I wrote stuff to keep me in order, but I think I'm hearing a lot of moving parts here, so I'm going to jump back and forth a little bit. But Arizona Family Court case knows me. The last 4 digits of my case, 5414. I'm a mother of 5 children, 24, 23, 21, 10, and 7. My older 3 kids are from my first marriage to my high school sweetheart, Michael, who is in his final phase of terminal cancer, so I will be the last surviving parent for them. I have 2 younger kids that are 10 and 7 from my ex-husband, and who I've been divorced a little over 3 years now and have been in and out of the Arizona Family Court system, dealing with some challenges, what the court defines to be quote-unquote high conflict parenting, and yet we can't seem to find some resolve. I'm here today, and I want it on record that I fear his retaliation, and I understand speaking today increases my risk of losing my boys. But I know that if I do this, it helps everybody here. I'm a victim of domestic violence by Arizona statute, and yet I can't seem to get any reprieve. I want to thank you guys. I didn't come in April, I came last month, and I'm here today. And I'll be at the next one, and anything else you guys do, because you're giving me hope that somebody sees us. My son Baker is 10. He asks me all the time to help him, make sure that I can get him his counselor back. It's been 2.5 years that I've been trying to fight to get them access to counseling. My 7-year-old has manic episodes. He bites the skin on his fingers, holes in his shirt, has massive temper tantrums. My son Baker has anger issues and he doesn't understand where they're from. They are scared because they're told that mom is going to take me away from dad, and just the ongoing conflict of conflict. Some of the words that the family court has allowed inside the courtroom and through court documents to be used to describe me: a perjurer, a fraud, a criminal, an alienator. My ex-husband has called me an effing idiot, incompetent, a greedy little pig, an extortionist, and diabolical. I have been threatened numerous times that I'm going to burn in flames if I don't back down. His lawyer even told me that if I didn't, they were going to take me for absolutely everything I have and not leave a penny to my name. I'm not allowed to tell the court that I was diagnosed with complex PTSD because that also means I could lose my kids. I'm also told that I can't tell the courts in my child support paperwork, because I pay child support even though we're 50-50 with joint legal decision making, that it cost about $600 a month out of pocket for me just to stay functioning, working my job. I'm not allowed to say that, because if I do, then it also shows that I'm not making enough money to make ends meet. So instead, I pay child support, 60% of unpaids. Somewhere, the court system thinks that we're supposed to be thriving co-parents. Somehow we're supposed to stay healthy and we're supposed to stay strong. I don't understand, when we're having to face all of these challenges, how that's possible. The last 3 years, I will say, has gifted me a lot of things. It's allowed me to learn how to be the therapist and counselor for my boys, because I want them to know they have a safe place. I've learned how to become an IP address forensic scientist, learning what splitting emails are, even showing that emails are getting written through our family wizard out of state with not a single consequence by a third party that under oath at trial he stated he had authorized to do. I've become a SoberLink forensic question asker. Did you know that SoberLink, the program our family court system uses, and that recommends to be the source of the end-all be-all for determining if somebody has an alcoholic problem or not. They believe, because it's their philosophy as a company, that they do not want to pressure the alcoholic. That's not their job. So if a court does not specify the actual windows of times necessary, If that alcoholic chooses not to take the test during that time, it's okay, because that would be putting too much pressure on the alcoholic. They don't want that. Yes, I'm going to leave that right there for now. I'm also trauma informed. I went through a designation course because I was sick and tired of the court telling me after 3.5 years that I don't know what I'm talking about. I'm still told that that has no weight. I tell you what, I'm a mom, 5 kids, I have a GED, pay child support. I'm going to law school now because I want to make a difference. I'm also a licensed real estate agent, and I can tell you that the Arizona Department of Real Estate, we are all about transparency. We have to have continuing education to hold ourselves accountable. If there's a complaint, you're allowed to file that. I don't understand why our court system does not have the same things in place. My case over the last 3 years, not including my divorce, has cost me $105,000. When you add my divorce, it's $130,000 to $150,000. When you add the rulings, because that did not get me an attorney at trial, I actually still had to be pro se. I couldn't afford anymore. I sold my house. I'm losing my house now. I've lost my dignity. I keep going because I'm a mom and I'm supposed to protect my boys. And I promised them I would get them counseling and some reprieve. But when you take the ruling of what the judge did in my case at trial, I went in for enforcement of my decree and enforcement of a parenting plan, and I walked out with a modification. My understanding, that's illegal. I went to one of the top appellant law firms, charged me $600 for 45 minutes of their time in order for them to get their hands wrapped around my case because there's so much involved. They estimated it was going to cost just shy of $100,000 for that, and that trial would run another $100 to $120,000. They told me that the ruling, the modification that the judge did, even though it's an extra $76,000 worth of liability that she places on me now, still is offset. It's cheaper than going to trial. I don't understand how this is sustainable. I have 11 more years to go with this. And I want to talk about mental health. I don't want to unalive myself, but you get to a point where you start weighing how much more can you take. I stay for my kids, stay for my older ones because they'll be left without a dad, and I don't want them left without a mom. I'm trying to advocate through my fear, but I think it is so important. We need to start really educating the people that are sitting on these benches. We need, I believe, a red, yellow, green light system. There's mental health resources in place that talk about suicide, etc. There's a red, like, traffic light. Why don't we have that in the courts? It's patterned behaviors. You know, we talk about abuse. There is patterned behavior. There's certain words that are used. We need accountability. You know, it's like you go in for an oil change and they give you, instead of your car back, they give you a set of roller skates and tell you, all right, now go roller skate your way to Queen Creek.
You need to have you wrap it up, man.
So I just want to leave it with this. As victims, we don't want to be one. We don't want our kids to be either. We're here protecting our children. They're going to have all kinds of issues growing up. I think it's important. Victims are seen as guilty until proven innocent, and then we have to start advocating for our children. But the abusers are seen innocent until proven guilty. I don't understand this. We're supposed to show up to be strong, but we don't overtalk. We're not supposed to undertalk. We're not supposed to look like a victim. We're not supposed to look like a thriver. We're not supposed to cry. We're not supposed to diagnose. We're not supposed to do anything. So what you see is a groomed version of ourselves versus allowing us to be seen and heard for exactly what we are, advocates, advocating for our children to thrive and be the best co-parent we can. We have rights, and we, along with our children, deserve a quality of life. We deserve to feel safe, heard, seen, and understood. We deserve our abuse to have a place. It's called Not on My Watch, Arizona. If we have statutes for coercive control, post-separation abuse, domestic violence, legal abuse, why are we not using it? We have to keep recreating cases because it's all quiet. No one talks about it. We can't pull up records of using past case law. So it's as if we're trying to win our very first case in the history of the United States over and over again. So thank you again for giving us the opportunity to speak today. And thank you, and please remember my son Baker and Witten.
Thank you for your courage, ma'am. And the judge that is in charge of your case right now?
I don't have one now. It was Patricia Starr is the one that did the ruling. My understanding is she was removed or something took place.
Okay. Representative Keschel.
Thank you, Mr. Chair. I just want to thank you for coming, and I just want to tell you, your kids need you, so you keep fighting, and we'll do our part in that.
Thank
They
you
need
so
you.
much.
Keep fighting. Stay strong.
Thank you.
Members, any other questions? No? All right. Ma'am, thank you very much for your time. All right, ladies and gentlemen, we are going to recess for probably about an hour, maybe an hour and a half, based on what happens on the floor of the Senate. I expect that to be fairly short order in business. So what I recommend is that you be back down here if you are yet to testify or if you want to observe at or about 1:30. All right? With that, we're on recess. The Joint Legislative Ad Hoc Committee on Family Court Orders is back in session. We're going to try and get out of here, everybody, by 3:30, so, because I know many of you that are in here have got a bit of a drive home. So we've got a few people on our previous list to go through, and then we'll cover the slips that we've got. Just a reminder, please, no clapping, no applause, no yelling, hooting, hollering, any of that. And if you would, please do not mention the name of your former spouse, former significant other, whoever. Judges, lawyers, and therapists, that's another story. So, Representative Keschel, who's first on the list?
Matthew Blair.
Matthew Blair, you in the room?
And I don't see Jax. Erin Gerlach. I know she's
I know
here
Erin's
somewhere.
here.
Oh,
All
there
right.
she is.
Okay, Erin, if you would, please give your name for the record, and you've got 7 minutes, young lady.
My name is Erin Gerlach, and I am a victim of this family court circus as well. My daughter and I were victims of domestic violence and child abuse, which was founded by multiple different agencies. I have a stack of police reports several inches thick. But because my ex is a police officer, he has unfortunately gotten away with it. Our case was put in front of Judge Charlene Jackson, who didn't follow the law whatsoever. And that is what I believe the issue is with the family court system in general. There is no oversight, and the oversight bodies that we do have do not enforce the law. The statutes that we have on the books here in Arizona right now would have protected me and my daughter if they were followed, but unfortunately they were not. So Judge Jackson issued orders when she didn't legally have jurisdiction to do so. She issued orders that were contrary to Arizona statute, and she placed my daughter in the custody with her abuser. My ex committed perjury like nothing anyone has ever seen. And when it was shown to Judge Jackson that he had lied in order to obtain orders, she retaliated by issuing warrants in my case. I can't say a lot because I'm now facing criminal charges for custodial interference for keeping my daughter safe from her abuser. I have criminal court tomorrow, as a matter of fact. That's why I'm here in Arizona, because I don't live in Arizona anymore. I live in California now. Sorry. If the Commission on Judicial Conduct had done a proper investigation into Judge Jackson and the issues that we all know she doesn't follow the law, I wouldn't be here today. Judge Jackson should not be on the bench. She's placing a lot of children in danger, not just mine, but many others. In fact, there's one child that's currently with a man who is under investigation for pedophilia. Yet she's still issuing orders, and they still stand. And I'm not sure why the state of Arizona is allowing that, and how the state of Arizona doesn't think that there's a liability in keeping her on the bench. I also don't understand how my ex is still walking around with a badge and a gun when he has filed things with a court under oath and lied. I've had over a dozen false police reports filed against me throughout all of this, and it's all just a continuation of the abuse is the problem. We were fine. When I first left with our daughter in 2022, he and I were still talking somewhat, and when I would not go back for the last time, because I went back to the abusive situation multiple times, when I wouldn't go back for the last time, he resulted in this family court case. He filed a court case in Maricopa County demanding a judge issue orders to force me and our daughter to move back to Arizona. And the basis for that is he said that I erratically took our child from school and ran to California with her. However, in the same filings, he also said that he knew that I took our daughter and that the trip was supposed to be temporary in nature. However, a week before he filed this case, he went to the Gilbert Police Department and told them that we moved and he was planning on coming to visit us soon. He knew that we moved. But that was the basis for Judge Jackson issuing her orders. It was not because I was abusive or neglectful or not a good parent at all. In fact, I took care of our daughter every single day since she was born, and her father was very rarely even home. And when he was, he had really bad PTSD, substance abuse issues. And Jackson saw hundreds of pictures of injuries. She saw videos of him breaking things, screaming at us, harming us, taking my phone, not letting me call 911, us locked in the bathroom while he's saying F you for giving birth to her, talking about our daughter, screaming at her. I was pregnant with our second child when I lost him at 20 weeks because of the abuse. And Judge Jackson didn't care. She put my child with a psychopath. And now here I am facing criminal charges and looking at 5 years in prison for keeping my child safe. And if the Arizona court system had just done their job and followed the statutes that are on the books now, I wouldn't be here today. And I prepared a whole speech and I can't even read it because I am so stressed out from being here because I know that I'm going to be retaliated against for coming here, just for walking in this room and speaking to you. I know that I'm going to end up back in jail. And I know that my daughter has nobody there to protect her. And I wish I had stayed. I wish I had stayed in an abusive relationship with someone who tried to kill me and my daughter and held her head underneath the water when she cried. Waterboarded my baby because he hated crying so much. Someone who treated us that way, who's killed multiple other people and has no remorse. And I'm going to be retaliated against for coming here and speaking out against Judge Jackson and speaking out against the experience that I had in the family court system. And I can't even form a sentence right now because I feel like I'm going to pass out because I have court tomorrow and I know they're going to retaliate against me for coming here. And there's nothing that I can do, but if I can't save my own child, at least I can try to help save somebody else's. And what I'm asking you guys to do is consider defunding these organizations that aren't doing anything. And I understand you guys with the separation of powers, but we have the Commission on Judicial Conduct that does nothing. You can file all the complaints that you want. They won't do anything. Then you have the Bar Association. You can file all the complaints that you want. They won't do anything. And in fact, I have a restraining order, a civil restraining order that Judge Jackson filed against me where she wrote in there that me filing complaints with the Commission on Judicial Conduct, me speaking to Representative Keschel, me going to the Bar Association, me filing police reports, doing those things, she said that they were considered harassment. And I don't see how going to our state representatives or to an oversight body is considered harassment. None of this is legal. There's not a single order in my case that's legal, but yet I'm looking at criminal charges for it.
So you do have a First Amendment right, and you're here exercising that First Amendment right. And one of the questions that we have for family court is how they are abrogating the civil rights of children and parents. That's intolerable. My recommendation is, and this is not, I'm not giving you legal advice,
Yes.
okay? But I suggest that you may want to contact the U.S. Attorney here in Arizona.
I did, yes, sir.
And ask about Hayden's Law.
Okay.
All right. Members, any questions? All right. Thank you, ma'am.
Thank you.
Next.
Okay, next up is Danielle Encontro.
I've said it enough times, people already know.
I already know.
All right, if
I've
you would,
watched it
please
all
give
day.
your name for the record, and you've got 7 minutes, ma'am.
My name is Danielle Encontro, and I'm speaking as a witness today. First, I want to thank everybody for their courage in speaking today. You guys can't see it from there, but I can tell you from sitting here, I'm watching about 40% minimum of all the speakers physically shaking because, like so many have said, they're going to face retaliation for being here today and shining light on what's occurring. Further, real fast, I think there is a correction that needs to be made. Senator, you had said, while we cannot resolve the current individual cases, we must learn from them. And I think it's important, if I can, to correct you on that, because what you're doing here, while it's not solving the issues and it can't undo what's been done, it is incredibly important and it does have an impact. You had mentioned something about shining light on these dark things. This industry, and it is very much a cottage industry, it operates under secrecy, closed doors, gag orders, intimidation, and you just holding these hearings, it does matter. You've seen other people from other states come up. I'm from California, and I could tell you what you're doing here in Arizona, it is having a ripple effect across the country, not just in California. We had someone from Idaho. I know there's been other states here. It absolutely matters. And you guys, I believe in the deepest of my soul that you are making history and you are changing this entire industry right now, even with these hearings. So while you can't undo some of the damage that's been done in these cases, it is so important for you to understand that just this alone, it absolutely matters. So I wanted to correct you on that a little bit, if I could.
Well, I appreciate your kind words, but the context of that is we cannot intervene as a legislative body.
Correct.
In a judicial matter. It's a different separation of powers. It's a different part of the government.
Correct.
Your point is well taken. The testimony that we're taking here is to affect, it actually is two-pronged. Mm-hmm. And we'll give you your time back when I get done with my
It's okay. Go ahead.
diatribe.
Go ahead.
It's two-pronged. Mm-hmm. One is to hear from constituents. Mm-hmm. And let me put a fine point on that. We work for you. That's why you put us here. We work for you. And when the other branches of government don't work for you, we're the ones that are supposed to hold them accountable. Not some commission on judicial performance, not the behavioral board of psychobabble, none of that. Ultimately, it's our responsibility. However, with that said, we cannot interfere with the court allegedly doing its, air quotes, job.
Right.
Okay?
Yes.
So while every one of us up here empathizes with the stories that we have heard, and quite frankly, this is the third hearing of heartbreaking stories, and I hope the bloody blazes that the presiding judge of the family court of the state of Arizona and every damn county is paying attention, because there are changes on the horizon that are going to affect the way they operate.
I love that. Thank
Okay?
you so much for saying
Please proceed.
that.
You get your time back.
Okay. So after thanking everybody, I come before you today not to speak about a personal case, because like so many others, I cannot. However, I do bring in what I believe is a unique perspective. I'm from California. I used to work for the district attorney and their office. I'm highly connected to law enforcement through family and friends who serve across multiple agencies. And so aside from being a litigant, which I cannot talk about, I'm also a domestic violence advocate. And so I have witnessed other cases extensively within the family court system. I presented a whole thing, and honestly, I can sit here and I can go over all these further horror stories about seeing alleged abusers given custody when a 3-year-old comes back from a forensic medical exam with an STD from that parent, and they were given custody. I've seen it. I've witnessed it. It's all closed doors. Someone had mentioned court watchers. I believe that is absolutely important. So many judges now close the courtroom doors. They don't allow people into hearings, just as they didn't allow you guys in. And while, yes, there are possibly HIPAA-protected conversations that are going on during those hearings, it's incredibly important to have somebody in there to watch what's happening. Even if it's someone who works for a separate body, it's incredibly important, because I can tell you from experience, when those doors close and the gag orders go in place, that's when you get the majority of these horror stories. It's when no one sees it, and it's in the shadows, and it's in the dark. I'm going to skip my speech, and I'm going to talk a little bit off the cuff today, if that's all right. Let's talk about solutions. That's my favorite topic to talk about. We are all aware at this point that there are massive issues, that there are problems. In California, we have some of the most stringent child protective laws in the country. We're supposed to be transparent, and there are issues with it. There's a couple things that I wanted to address, one of which you guys had mentioned jury trials. I absolutely agree with that. However, I think that you also need to keep all of the prongs of protection in place if you implement that. For example, you could put a jury trial together for these cases, but if you are not ensuring that both parties have legal representation, then it doesn't matter. Because one party is not going to be able to get evidence in, they're not going to get their witness testimony in, and you've just added another prong of complication. So I'm absolutely for jury trials, but you have to ensure everyone's equally represented and that it is a fair trial, just as it would be in criminal or in any other court. Judicial training is something I feel very strongly about. We passed Peaky's Law in California.
You got 1 minute, ma'am.
Yes, we passed Peaky's Law in California, requiring judicial training on domestic violence, abuse for judges. The problem is that training is provided by other family court judges, attorneys, the custody evaluators, and all these problem people that just sit there in an echo chamber, and it's not training. It has to be from outside sources. They cannot just keep bolstering each other and padding each other's pocketbooks. It's not going to work. I have 20 seconds. The other thing that I think you guys should be aware of, and I've seen CPS reports from Arizona with the same problem California has. They do screener alerts when a CPS report comes in, and it says custody dispute, which means anytime, yes, which means anytime a CPS call comes in, before they do any investigating, before they go out to that house, before they talk to the children, anything, They seek custody dispute, and it is immediately prejudiced. And that's a problem, and that shouldn't be that way.
Thank you, ma'am. I'm curious, since you're in the advocate world,
Sure.
your thoughts on malicious litigation.
It could be twofold. There are absolutely people, I've seen abusers do it frequently. They tend to do it more often than not. However, once they get that custody, they'll flip it and they'll do it the other way. And then they'll say, if you file, if their victim files for custody, to get custody back, to get visitation back, suddenly they hit them with that vexatious litigants, is what we call it in California, and to prevent and wall off that parent, to prevent them from ever regaining any sort of relationship with their child. So it needs to be looked at with a fine-tooth comb, and it can't be at the discretion of one judge who already doesn't like you. That's a problem.
Well, my question was actually coming from a little bit different direction. That is,
Oh, sorry,
when you
go
have no, that's all right. I'm sure you're not a mind reader. When it comes to malicious litigation, my default position is the person who brings the litigation, if they fail, they pay. That immediately shuts down a lot of the abuser preemption, I'll put it.
Yeah.
Because there is no guarantee. So,
I can
members.
Oh, sorry. If I could respond to that
Sure.
really fast. I think that's fair if both parties have attorneys. But when you have, I've seen litigants with no attorney and the other party has multiple attorneys.
Fair enough.
That's not a fair fight. They're going to lose going into court every time, especially if they're already disadvantaged. They're coming out of a DV situation. They have PTSD. They can't present themselves well. It's a problem.
Fair
So
enough.
things to consider with that.
Representative Kishel.
Yes, Mr. Chair, thank you. Thank you for coming. I actually just want to make sure we touch base after this. The big focus this last session was, Representative Fink and I ran a lot of family law types of legislation. But what you just said about DCS, CPS, whatever you call it in California, is so true. And I'm thinking you might be a really good person. I have a lot of contacts that we'll be working with on family court legislation, but I don't have a lot of insight on the DCS connection with what you said, where they want to just steer clear of anything that has anything to do with custody. And it's causing a lot of problems because they're not doing their job of protecting the children that are in these potentially abusive situations. Can you please make sure you get my card and my number so you can help me work on some legislation that makes that tie, that connection between DCS and the family courts and how they can better be utilized to actually protect these kids?
Yes, absolutely. And I would suggest adding the district attorney to that as well, because I've seen prosecutors, regardless of evidence that they have, even if it's forensic medical evidence, they go, oh, we're not touching this. It's in family court. Okay. And that's the wild, wild west.
You can help me with that.
All right.
Thank you.
Anything else?
All right. Members, any other questions?
No, I think what I want to do is to make sure we can meet later, so that's been taken care of.
Absolutely.
Thank you.
Okay.
Thank you so much
ma'am.
for having me.
All right, next on the list. Are we done with the list?
Yes,
All right.
we've been done with
Now we're going to go to the new folks. All right, so we're going to try and get all of you in.
So I think the next speaker is actually related potentially to the last speaker. So Sawyer, can you come on up?
All right, young man. Yep, you know the routine. Okay, if you would get close to the mic so we can hear you. Give your name for the record, where you're from, and you have 7 minutes.
My name is Sawyer Encontro. I'm from California. I'm here to speak about something that has left a permanent scar on my life. And I also want to speak on behalf of the other silenced children who don't get a chance to speak in places like these. Family court has left a scar on my life, not by the hand of justice, but by its failure. I'm here on my own accord because I refuse not to be here, and I refuse to deny my lived truth and experience. As like all other teenagers, nobody can make me do anything I don't want to do, so that should be a little bit more proof. But no one has forced me to be here or to speak, but I'm sure it'll be twisted and appear that way, and I'll be continued to be punished for speaking out. Like many others, I trusted that if something terrible happened, I could go to the people in charge, the police, Child Protective Services, but most importantly, the courts. Not only was it their civil duty and job, but they promised to protect the truth, to protect children. But instead, they kept us silent. They looked away, and in doing so, they protected the very systems that caused the harm. They have failed all of us in this room, and many unspoken. When I first came forward, when I told the truth to Child Protective Services about what was happening, what had been done to me and what I've seen, I wasn't met with compassion. I wasn't even met with neutrality or humility. I was asked questions that seemed more like accusations. They didn't see a child asking for help. They saw a problem to ignore, a risk to their image, a complication of their process. I was met with silence, with suspicion, and they didn't listen, not because they couldn't, but because they chose not to, all because I was labeled as being part of a custody dispute. I wasn't just ignored, I was erased. They turned their backs and later separated me from my sister. She was our light, the part of us that still believed in something pure. But now, we're watching that light fade. We have been taught to keep our voices, or to quiet our voices, to feel safe and compliant. Or to feel safe and be compliant. Piece by piece, we're disappearing. And when it was time for me to testify, I'd hoped I would finally be able to share the truth. But instead, instead of being allowed to speak freely, I was interrogated for over 6 hours in front of the very person I was terrified of. They didn't just ignore the truth, they forbade it. I wasn't allowed to speak about what mattered most. Instead, I was dragged through my pain all over again to feed a system built to protect itself, not the people it harms. I want to be completely clear. Family court in America is not protecting children the way it claims to. It's protecting its power, it's protecting its appearances, it's protecting its own financial interests, as I'm sure has been proven today. There is a sickness in the system, a refusal to listen to victims, especially the truth. And when the system refuses to listen, it doesn't just fail, it harms. It changes the course of people's lives. It breaks families and it steals childhoods. It teaches survivors a harsh lesson that speaking up may not guarantee justice, but silence guarantees that nothing will ever change. And that's even more impacted when people are forced to be silent. But all of us here today, we're still speaking because someone has to say what so many others are too broken, too afraid, or too ignored to say, or forced not to say. The family court justice system is failing. It doesn't protect the innocent or uphold justice. It silences survivors and abandons children. It rewards those with the financial means to purchase children from the system itself. Children deserve better. Survivors deserve better. And all of us won't stop speaking out until the system learns how to hear it. And I want to thank you today for making this first step for the systems to start being forced to listen. As a child who has been silenced and hasn't been listened to, ignored, it's very validating that finally our voices are being heard. And I want to speak on behalf of everybody here and all the other children who aren't able to speak out, that we thank you for at least starting this.
Thank you, young man. One of our most cherished rights in this country is the First Amendment.
Mm-hmm.
You know about that, right?
Yes, sir.
Do you feel that your right to free speech has been impaired by the very system that you're encouraged to speak up in?
Absolutely. Every turn they get to stop me from speaking out, they take every chance they can.
Has that been in the court?
The court, CPS, anything linking to family court, it silences victims.
Been told to shut up and sit down?
Essentially. Not in that phrasing, but basically.
You're one of the few. All right. Members, any questions?
Mr. Chair,
Representative Cashel.
Sawyer, thank you so much for coming. If you don't mind me asking, how old are you?
I'm 15.
I'm very impressed by how eloquently you spoke. My question for you is, as we kind of try to look at this, because it's become very obvious that the child's best interests are not, that is not happening. And more often than not, I hear about kids just like you, some younger, some older even, that are not even being heard at all. Do you think that there's a particular age, you know, as we bring our brains together to try to come up with some legislation in the future, is there a particular age where you felt like you knew enough within yourself of what you needed for you to be safe, or whatever the circumstance was? How would you help us as legislators out with that question?
That's a tricky question, just because a lot of people, especially children, obviously, in this situation, they're heavily manipulated. So a lot of the time, from my experiences, there were things that would just go over my head or wouldn't like click that it's wrong because I was convinced otherwise. But I would say about 10 was when I would kind of start like remembering, and like things would start clicking of like things were wrong and essentially what would be my best interest. But I think it kind of differs on the case. So I didn't have the most severe case. I'm not allowed to talk about it, but definitely not the worst it could have been. I got very lucky, but I know there's other people who it's much, much worse. So for them, it could be decided at a younger age. Like, obviously, if you're being hit, drowned, all sorts of stuff like that, it's a bit more obvious that it's wrong. So I'd say anywhere from 6, 7 to 10.
Thank you. I was just curious, coming from an expert, since you're one of the kids who's been here. So, yeah, I appreciate that, and
of course.
Thank you again.
Mr. Chair?
Representative Fink.
Sawyer, again, thank you for coming. I appreciate you. And you answered it a little bit, my question to Senator Fincham, but you said nobody didn't listen. So you said the course, was that like the judge? Was it the attorney? Was it, who all were not listening? Was it police? How, if you could kind of explain some of that.
I'm trying to think of how to phrase this without giving away information.
It's always a challenge.
Yeah. When I testified, I would be asked kind of incriminating questions and not be allowed to explain myself. So, not against me, but they would kind of flip-flop the situation, saying that one side was in the wrong when it wasn't, and they wouldn't allow me to speak on behalf of that and explain why they're wrong. They would just kind of shut me down from speaking about that. And then with CPS, I would have really short interviews, like 10 minutes. And a lot of the time, or maybe, I guess not a lot of the time, but there's been a few instances where they would just cut me off mid-sentence and just be like, that's done. That's all we need for the day. As I would be getting into one of the most crucial parts of whatever story I was talking about. So, yeah, it's a little bit of everything, but
So when you were talking about the question, so was it kind of a leading question trying to get to one answer and not allowing you to kind of really explain what the...
Exactly.
Okay. Thank you.
Any more?
Thank you for coming.
Sir, you get a long runway, man. You're a very articulate young man. Thank you for your courage.
Thank you so much for hosting this. This is very impactful.
Very good, sir. Thank you.
Thank you.
Next.
Elizabeth Davis.
Good afternoon. If you would, the switch to your right on the front of the table, we'll lift that up a little bit so you don't have to bend down. Ah, pretty cool, huh? All right. If you would, get your face as close to the mic as you can. We need to have your name for the record, where you're from, and you have 7 minutes.
Elizabeth Davis. Thank you. I'm Elizabeth Davis. I'm from Tucson right now, originally from San Diego. I'm a former Navy pilot. I served this country for 13 years. I graduated from the Naval Academy with a degree in electrical engineering. I spent my life protecting freedom only to return home and lose my own in a courtroom. I'm a mother of 3, and I have not seen my children since February 7, 2024. Not because I'm a danger, not because I've harmed them, but because I've spent my last 3 years trying to protect them from the man they told me over and over again was hurting them, and who they watched hurt me. And for that I was labeled unstable, alienating, dangerous. I lost almost everything. Let me be clear, I did everything the court asked. I completed 2.5 years of VA therapy. I went through DV classes. I followed the orders laid out by a forensic psychologist who happened to go to high school with my ex-husband and didn't recuse herself and ignored my kids. Everything they told her about wanting to be with me because I was the good parent. I did everything she asked, even though I wasn't the one who threatened my kids. He was. So I was evaluated by psychiatrists, therapists, counselors. All of them said the same thing. I'm not a danger. I'm a mother with a normal trauma response to years of many different types of abuse and coercive control. But it didn't matter. Truth didn't matter, because in this system, connections matter more than facts. Allegations without evidence matter more than hundreds of pages of documentation, thousands actually, that I've submitted to court, all to be dismissed and ignored, including a Rule 85 that was over 1,000 pages. I've submitted complaints to the State Psychology Board, 1,000 pages. I've submitted 500 pages of evidence of my ex's 7 felonies that are recent enough to prosecute. Lots of witnesses to those too, and TPD won't do anything because he has friends in the police force.
And I'm sorry, ma'am, your case is in Tucson or in Phoenix?
Tucson, it's in Tucson. So
And the judge in charge of your case?
right now, it's Dawn Walton. She inherited it from Jack Cassini.
Okay, thank you.
You're
Go ahead.
welcome. The forensic psychologist, who is criminally guilty of all kinds of things in this. Her name's Holly Joubert. She's the one they use in Tucson, but she should have recused herself, and she didn't. And they did a cursory investigation, asked her 3 questions, and she lied to all of it. So anyway, the allegations without evidence matter more than the facts. As this young man was just saying, nobody listens. And my kids have told me what they told Joubert, what they told the cops, what they told the therapists, who all have worked together for decades and back each other up. And all of that should have gotten them immediately removed from his custody and returned to mine. They fought for me for 1.5 to 2 years before they were silenced. So mothers like me are prosecuted while abusers walk free. I am now a convicted felon, not because I'm violent, but because I dared to beg my daughter not to surrender her siblings to an abuser. When she wrote a 6-page letter, that Holly Joubert ignored and called her indoctrinated. And this was a 16-year-old, straight-A student, scholar, athlete, varsity soccer player for 4 years, who was in AP psychology at the time and got a 5 on that AP psychology test. And she wrote a 6-page letter detailing his abuse and threats and intimidation and neglect and crimes. And Holly Joubert disregarded that to hook up her friend from high school.
Ma'am,
So,
I have a question for you. I'm sorry,
Yes.
I can't help myself. You just said that you're a felon?
I am, because my 18-year-old, she's 19 now, we got into an argument. We'd never even argued before because her sister was forced to write a letter,
Okay,
told her
I-
in class, and we ended up in a scuffle over her phone, and she ran to her friend's house, and her friend's parents called. And I had to
Okay.
take a plea because I was being excessively charged because TPD was already aligned against me because they're friends with him.
Okay, so
So-
there is a conviction on your record.
Yes, 2 years after this started.
And honestly, I don't care about that for the purposes of this hearing. I just want to be clear when somebody makes the claim, I'm a this,
Yeah.
that we know exactly that really is the case, so.
Right, I am, and I'm on probation, and this absolutely never would have happened, and my daughter said it to the judge in this case, that it absolutely never would have happened if my ex had been locked up where he should have been, and that it was absolutely about the injustice of this divorce case, and that it shocked both of us. We'd never even gotten into an argument before, and now we were in a scuffle over her phone. She got a bruise over her eye, ran to her friend's house, and they called the cops on me, and they were trying to charge me with really excessive things, and I couldn't go through that, so I took a plea. So,
Okay.
not because I'm violent, but because I dared to beg my daughter not to surrender her siblings to the abuser. She didn't want to. She wrote a 6-page letter, and it was dismissed, so she said it wouldn't do any good. But she told me things, and I asked her to tell the judge what she had told me, because we were going into the last hearing, or what was supposed to be the last hearing, the day after the Super Bowl in 2024. So the system said I was the problem, that I had to prove I wasn't dangerous, while the man who threatened to kill me, our kids, himself, and the pets still holds custody. He put a loaded gun in his mouth 2 feet from me, yet he and his cop friend said I did that, and I got psych swatted for it. And while I spent 2 days in jail, he went and got an order of protection against me with his other friend's false allegations that I threatened to kill him and the kids, and between all of them, they couldn't come up with any proof of that. No text messages, no nothing. I've got text message proof of him threatening the pets, but they don't care. They don't care. So they say I'm the problem. He got an order of protection against me based on false allegations that was upheld. It was total hearsay, no proof, and he used it to stalk me. He used it as a shield to stalk me. I reported him 13 times at TPD for felony level stalking, and they ignored. And then I spoke up in defense of myself, and I was arrested because I violated the order of protection when I asked him, when are you going to stop stalking me? After 11:30 at night. I left for he was right near the house that I was staying with my 16-year-old daughter. He'd threatened to kill us both. I left for 10 minutes. I came back. He was still there. I wanted to let him know I wasn't going to be a soft target. So I said, when are you going to stop stalking me? And he reported that. I reported him to the cops again for the 14th time for stalking me. And instead of arresting him for felony level stalking or the sexual assaults I'd already reported him for or the theft or the animal abuse or anything like that, they arrested me for verbal statement, when are you going to stop stalking me? That I admitted to saying because I thought that self-defense would actually trump the silly law of violating an unjust order of protection. So I'm still facing charges for that for August of 2022 for violating that order of protection in defense of my life and my daughter's against his felony level stalking.
Your time's up.
I'm sorry, what?
Your time's up.
Oh,
If you have one last thing to say,
Just-
but it needs to be short.
Just, I haven't seen my kids. I'm the parent who raised them. They begged to be back with me. I've lost $400,000 with legal fees, investigative fees, trying to fight this, replacing what he stole. I filed so many police reports. He's committed 7 felonies. They won't do anything. The courts pick, like I heard someone else say earlier, they pick their favorite and they go with it. And they have turned several moms that I know, that I have met through these years of fighting, they've turned all of us into, we have to fight, and then we're villainized for it.
Okay.
I was a law-abiding citizen my whole life. I served this country. My ex doesn't even have a job still. He has no relationship still. According to my oldest, the kids still hate him. They're just surviving. Well, I love them. I love them, and they're safe with me, and they need to come home and not be with whatever girlfriend at the time he's decided to have. He still doesn't even have a job, never paid into Social Security, and I was the primary caregiver while he slept all day, drank all night, and cheated on me or abused us when he was awake.
Thank you, ma'am.
Please fix it.
Are there any questions?
Sorry, thank you.
All right. Thank you for your testimony, ma'am. Next.
Anna Dritsas? Oh,
Harrisburg.
okay, we gotcha. Martin Lynch.
Oh, boy. Mr. Lynch, if you would, please give your name for the record. You got 7 minutes.
Martin Lynch, and I represent We the People Court Services and the NAACB. So I came here because I've listened to all these people talking, and just really quick housekeeping, Representative Keschel. You talked about any tie-in to CPS. If you look at ARS 8-223 and 224, you will find nothing. But those laws did exist. They were created in 2003, and then they were sunsetted in 2005. They basically create a jury trial in DCS court, and the other one creates a public hearing, because they've decreed that all those cases have to be done in secret. Okay, so there was a statute saying you can't do that. So just FYI, okay, and it
Could you
kind of
repeat
bleeds
that
over.
again? That
Sorry.
ARS what?
8-223 and 224.
And really quickly, Mr. Chair, sorry, Mr. Lynch, so because of the sunset, those got removed from statute?
Oh, the lawyers who crafted this legislation, they put that sunset provision in there because obviously they didn't want it, because oil and water don't mix, you know. You can't steal things from people if you have due process. It's much more difficult. You need.
Well, there is a habit of things suddenly reappearing at the legislature. Happens every year, as a matter of fact.
So we try to bring up these opportunities to remind our legislators that there are things.
That's duly noted.
Because this ground has been plowed before. That's kind of my point. I just wanted to make, because I've listened to all this testimony, and I hear the word judge I don't know how many times, but I haven't heard the word equity even once. But I haven't been here the whole time, so I might have missed it. I don't know. In our analysis, we've determined that a thorough understanding of a court of equity, what it is absolutely essential to getting on top of this thing. First of all, we decided we wanted to attack the whole idea of an equity court. But then when you open up the Constitution and you get to Article 3, Section 2, it says judicial power extend in all cases in law and equity. So the founders recognized equity as legitimate. So then it becomes, well, what is equity versus law? And, how do we make the system work for us? So when you go and do the deep dive into the historical foundation of these things, all the way back to Lord Chancery in the 1600s under British common law, you'll find what they were trying to do, and most people can agree with what they were trying to do. And where things have kind of gone off the rails is in equity, they give the judge much more latitude, discretion. I've heard that term around here, so I know people understand that. They give, in fact, I presented evidence in my own personal case that was ignored, so I went to the Court of Appeals, and the judges in the Court of Appeals came back and they said that the judge has a discretion to abuse his discretion. So then I thought, well, that's crazy, but I need to investigate it to find out who knows what I'm going to learn from this. And sure enough, I found out that if you're in a court of equity and there's reasons for it, they have all this latitude. And so then it comes down to, because I've been writing down all these different numbers, $200,000, $80,000, $85,000, $400,000. Every time you turn around, it's just people's kids' college funds, your 401ks, everything's all disappearing to feed this monster. And so what we've determined is that the court system has been converted into a control mechanism, which allows these actors free access to your money, and which I assert is what this whole thing is about. But the good news is that if you understand the difference between law and equity, there's certain matters that are being tried in these equity courts that belong in a court of law, where due process is to be heard. And the foundation for that is the Seventh Amendment, for the $20 provision of the Seventh Amendment. So if somebody says, okay, well, you know what, we're going to put your kids over here, we're going to put that kid over there, and then we're going to charge you, you're going to have to pay $20,000 in legal fees. Oh, stop right there. Because now we're over $20. Okay, but until you understand that you have the right to demand due process for something that requires due process, then you don't make that argument, then there's nothing that you can do to defend yourself. And so then it comes down to, well, and I heard the other lady here just a little while ago talk about, well, a jury would work if you're adequately represented. And she hit the nail right square on the head with that thing. So when you've got lawyers that don't know what the Seventh Amendment says, and they don't understand the difference between a court of law and a court of equity, and when it's time to say, no, this matter belongs in a court of law, and we're going to have due process, we're going to have a jury make the decision, and if you don't make that argument, then the judge can't rule in your favor, and the Court of Appeals can't override the abuse, what would then be the abuse of discretion, because you're talking about a matter that belongs in a court of law. And so if you have the wherewithal to understand all this stuff and make these arguments, and the only reason I'm standing up here telling you all this stuff is that, you know, we've been through this. We have ongoing cases right now where, you know, the first thing they do is they say, well, we're going to take the kids, okay, well, whatever. We're going to do whatever it is, and then when they get to the money part of it, then it's like, oh, thank you. Because now we have you. Okay, all we have to do is hold up a check for $20 and say, I'm surrendering the $20. You have no discretion to say no. And there's case law to support it. But, you know, if you don't know, you know, how the system works and what your opportunities are, then it's going to get past you. So the regulation of the legal profession is, in my estimation, the foundation of what we have to get our arms around here. Because, you know, judges regulating the legal profession is, you know, if it's not a violation of separation of powers, there is no such thing. Because, you know, we have lawyers over here in the legislature giving legal advice to the legislators. We have lawyers that we hire to represent us in these cases. And if these people are not independent and competent, then we can expect the kind of results that we're dealing with here.
30 seconds, Mr. Lynch.
Okay. So that's what I wanted to do, was to emphasize that concept of court of equity, because if anybody wants to research that, they might apply it to their own case and turn it into something that can work for them. I'm just going through here quickly. So we everybody agrees that money is the root of all evil, and absolute power corrupts absolutely. And so if you can transfer these matters that belong in a court of law over to that jurisdiction, our experience is that these cases just resolve and that they disappear. You litigate nothing.
Okay. Thank you, sir.
So,
members, questions?
Mr. Chair.
Representative Fink.
Thank you, Martin. Thank you for coming.
Yes, ma'am.
So just kind of, you talk about, you know, the Court of Equity and Court of Law. So how would that process look like, you know, for example, for some of those that have been here before, is that they just say, okay, you've now charged me over $20. I am asking to be in a law or a court of law versus, and would that still be the same family court system, or how would that look? I'm just thinking how, you know, just in my mind, how would that work?
Sure. Mr. Chair, Representative Fink, there's a lot of ways to skin that cat. What we've been doing is we try to get legislation, but of course we know about court lobbyists. We can't do anything as long as they won't let us in our own elected legislature. Beyond that, we just make the demands straight up, and we cite the legal authorities. That's key, because what I think is legal or illegal is that and 50 cents to buy a cup of coffee. That's your opinion. And the last thing any of us want is for somebody's individual opinion to dictate what goes on in a courtroom and the results of a court proceeding. So what we do is we cite the legal authorities, Seventh Amendment, give them a check for $20, say, okay, now I don't care what the judge thinks, I only care what the jury thinks. That's the key concept here. The founders put checks and balances in the Constitution all over the place. Mm-hmm. So that every person in the executive, legislative, judicial branch has somebody looking over their shoulder. So there's somebody legitimately, that's the key term here, that is looking over the shoulder of the judge. And, you know, I hate to say it, but it's not, you know, suing the judge. If you think about it, if you sue a judge, that for when they make a decision that somebody doesn't like, well, then every single case they have going before them, they can expect to get sued because they're going to have to rule against somebody. Okay, so do we really want to take away their ability to make impartial, what they think at least is impartial decisions? That's what we have them there to do, is to make what they think is impartial decisions. We're handing them that authority, and so do we want to subvert that? So the founders put the Seventh Amendment in there for that purpose, was to say, okay, that's going to be the limits on the power of a judge, is a jury of your peers making the decision and not the judge.
Thank you, Mr. Lynch. I presume that you'd be willing to assist with a legislative crafting panel sometime in the not-too-distant future?
Sure, we'll pull up existing stuff that's already been floating around, and
well, we can start there and move on.
We don't have to invent a lot of new stuff, because
well,
most of the stuff is ground that's been plowed.
Well, and considering we already have laws on the books that the court doesn't recognize or follow, does kind of cause us a question. All right, thank you very much for your testimony. Next.
Yes, Ms. Barari, I don't want to butcher your first name. I know we met last time.
If you would, ma'am, please give your name, where you're from, and you have 7 minutes.
Good afternoon. My name is Nastaran Barari. Thank you for allowing me to speak today. Just very quick background. I moved to United States as an international grad student in 2011. I went to Texas A&M, studied political science, graduated within a year, was hired as an instructor of political science at the university until end of 2014, where I because of the husband or the fiance at that time, who I divorced here in Arizona, moved to Phoenix due to his job. So since December 2014, I live in Arizona. I love Arizona. I come from the Netherlands. I was born in Iran, but as a child we moved to the Netherlands because of the political issues that my parents endured. And so I have a citizenship of the Netherlands as well. I married in 2014, December of 2014. I had my children, twin daughters who are 9 now, in 2016. And I filed for divorce in 2023. So I have, since I moved to Arizona, I have worked in education since after my children were born. Immediately after, I acquired a corporate job, and I have been with the same company ever since. I have thought that I was the primary breadwinner because I thought for the longest time that I was making the bigger income, which was part of the issues in the marriage. And I also acquired the home that I'm currently living in. So I bought it on my own income alone, even though it was during the marriage with the person who also had an income. So in 2023, I also wanted to say that I did not want to speak today until, and Ms. Keschel, I have spoken with you about this issue, until I got a minute entry in my court inbox, and I thought, okay, I need to speak up because it's getting a little bit out of hand at this point. So there may be retaliation, but I have already filed an order recognizing that there is judicial bias against me in the court, in the family court specifically. So when I filed for my divorce in 2023, June 23 to be specific, at that time I had endured a lot of different types of abuse. And I'm talking about financial marital abuse, domestic violence abuse, and medical abuse, etc., in which my children were witness of. The reason why I decided to end the marriage was because the abuse became dangerous. At this point, we had seen sort of a couples therapist who had diagnosed the opposing party as psychotic due to his excessive drug abuse. So abuse is already excessive, so this was excessive. So it became very dangerous, so that's where I ended the marriage. It became very odd, the abuse. It turned into allegations of marriage for the green card, which did not fall within the scope of the facts. and it became very threatening. It was threatening like deportation, removing my children, taking my house away. During this period, I was able to get my children into therapy, and that was because they had undergone an psychological evaluation prior to filing for divorce, and there were recommendations that both children need to be in therapy for trauma, matters associated with trauma and issues related to that. In that first session, the children had already revealed to their therapist that they have witnessed domestic violence at home, and the therapist immediately advised me to file for an order of protection. This advice was given to me by multiple friends of mine who are in the legal field. I was sort of afraid because I didn't know what the implications are of filing an order of protection. It was very new to me, never done it, never heard of it before in my circle of friends and family. So because this therapist recommended it, I was afraid that if I don't do it, then it may have implications on my relationship with my children, and that DCS would come and take my children away for not protecting them. When I did that, I was given, because one of the aspects of the abuse, or one of the things that happened during abuse, was strangulation, and the judge who basically ordered that order of protection, or granted that order of protection, also made sure that there is no guns involved, et cetera, et cetera. So fast forward, I started looking into divorce, and was looking into all the matters in terms of the family law, and I realized that in Arizona, rules of family law are pretty straightforward. So everything says, so for example, ARS 25-304 states very clearly what factors need to be taken in consideration in regards to child custody and legal decision making. I met every single factor, and I had evidence for it as well. I have over 400 pieces of evidence over time that I collected. I need to also say that I have a background or a career background in financial crimes investigations, so I was very good at exercising that skill in this procedure to find out information, to collect it, to document, and also did primarily the majority of my own legal proceedings of finding the law, finding the documents and the evidence for every single process that needs to be taken into account myself. However, my attorney totally kind of let me down. I spent over $100,000 for her just to print papers. I wrote majority of the pieces. At some point, I went pro per because I wasn't able to pay for my bills.
You have about a minute, ma'am.
Yes, I was not able to pay for my bills. Again, fast forward, I came into the judge's court, and the judge from the very beginning allowed the father, who has now domestic violence abuse allegations against him confirmed, as well as other documents showing that there is financial marital abuse, as well as medical abuse, etc. He got 50-50. This was abused over time to the point that that 50-50 was constantly vetoed on the opposing side's behalf, and I was not able to make any decisions about my children. Finally, when I went pro se, I started writing to the court explaining all the things that are happening. Perjury, such as filing false documentation to court, filing over 31 false police reports under a false order of protection against me, which is now squashed, as well as violating preliminary injunction, taking children out of state without permission, etc. Fast forward, in the trial, the judge said, I want the trial because I think it's taking too long. And that was exactly my point, and the point was that the opposing side is not cooperating in the disclosure procedure, and they are filing vexatious motions against me, projecting that I'm in contempt, whereas I was ready and was pending for them. In the court, the judge took all my testimonies, et cetera, but in his final decree, it shows as if I did not exist in that court hearing. There is nothing about what I said listed as far as the testimonies, the evidence that I provided, and is highly favoring the opposing side with purged documentation, with false allegations, as well as false testimonies. So giving, again, that 50-50 power to the opposing side, Currently, the judge expects of us that we make decisions just because he assumes that previously, during the marriage, everything was done in the same order. However, there's no evidence of such. In fact, I said this person was MIA for the most past year in the marriage, and so that's why we are getting a divorce, because things were very bad. So he made a decision based on no evidence, whereas there was evidence showing the opposing, basically the opposite. And he also expects that if we can't come to agreement with each other, we should hire a mediator to make these decisions, which is very costly for every ding and dong to hire a mediator to make these decisions. Currently, I have written 3 different motions to the court to ask him for a sole consent to be able to sign for my children's passport, because the opposing party is not responding.
Go ahead and kind of get to the end. I want you to finish with that, because that's another issue that someone else brought up earlier about the passports and taking kids out of the country. So maybe find
Yes.
that, yeah.
So that's where I am now. First of all, since I went pro se, the court is constantly making me circle around the rules that don't exist in the family law. So it says, no, I don't want you to write it this way, you have to write it that way. So I have to go figure it out how to write it. Now I write it, then they deny it, saying, well, this rule, I can't make a decision, I'm not pursued. So then I write a motion for reconsideration, and today I got the response saying denied. My travel plans are from 27th of June, which is next week, till July 24th to the Netherlands, which is a Hague Convention country. That's where my immediate family lives. And I have provided the judge very detailed itinerary as well as reasons why we are going. We are going to see my immediate family. We have not seen them since 2021 because of the court proceedings, as well as we have 3 major family events. Celebrating my father's 75th birthday because he's the only surviving child from his siblings, and because we have the right to see my family. And the judge simply denies, and I don't get a reason why he's denying, because there is no reason founded about me being a flight risk. I have a home ownership, I have a job, and I chose Arizona as my home state because I joke about it. I say I'm a weather refugee. If you know Netherlands, it's always raining. I love the heat in Arizona, and I want to stay here. And so there is really nothing that the judge found about me, except that at this point I have found it a bias against me, because one of the other things that I had requested of the judge is, out of all the holidays that exist in my culture, I celebrate 2 of them, which is the Persian New Year and then the winter solstice. And can I please have that on the calendar? He removed it, he denied it, and he even changed the weeks from the moment that he filed the decree. He changed the weeks so that it would fall on Father's Week, so that I had to beg him so that he would say no, and I did not have my children. And the
this
father is
judge-
American.
And this judge's name is what?
Judge Knapp.
I'm sorry, Judge
James Knapp with a
James Knapp.
K-N-A-P-P.
What court?
Family Court Southeast, Maricopa.
Maricopa County? All right, thank you, ma'am.
Thank you, Mr. Chair. The reason I wanted her to talk was it shows how it depends on the judge, the day of how these decisions are made. So we had one testimony earlier where the mom is worried about a flight risk. You would just like to take your children to see family. So having to figure out how to balance that, but make it unilateral across everything.
And now I'm asking also, what is my next? Because I'm currently taken hostage and I can't go see my family. I will not travel without my children because they are part of that family. They have a stake in being in where we are traveling to, and I'm being held back with even the last option was a motion for reconsideration, and he simply put denied without any reason.
And you're represented by an attorney?
No, I dropped my attorney because she was not efficient and
Okay.
I was wasting a lot of money.
All right. Any other questions? Thank you for your testimony, ma'am. I appreciate it. Next.
Mary Dalton.
Good afternoon, ma'am. If you would, get as close to the microphone as you can. Need your name and where you're from, and you've got 7 minutes.
Good afternoon. My name is Mary Dalton. I'm from Prescott, Arizona. I'm a mother, a college graduate, an assistant fire chief for 39 years. But today I'm not here as a professional. I'm here as a domestic violence survivor and a mother devastated by Arizona's family court system. So I want to talk a little bit about the systemic family court systems that you've heard so much about, but I'm just going to talk about one more. So specifically, the family court's disregard for domestic violence has been a problem. In 2012, my ex-husband strangled my son, his stepson. He pled guilty to that, but the Yavapai County Family Court judge said, who's still serving today, said that just because he strangled his stepson wasn't an indication that he would hurt his own children. And he awarded 50% custody to our twins. While the twins were with their father on their 50% custody and we were going through the divorce hearing, my daughter was hit with a broom handle, and in spite of the bruising and additional consistent reporting from teachers, DCS declared this was a custody problem. We've heard that a lot, and issued an unsubstantiated report. The twins were calling regularly, begging for me to come get them. I could hear their father screaming and swearing at them, threatening physical abuse. It was terrible. His attorney sent me a note saying that because of the unsubstantiated DCS report, they would be filing for full custody. I decided that I should have him move back in the house in order to try to attempt to protect my children. They were young at that time. I believe they were in second grade. I think they were in second grade at the time. But the ongoing abuse continued, as usual. He shot a gun through the roof of our house. He assaulted the children. Black eyes, photos of black eyes. The orthodontist talked about how he cut my son's roof of his mouth with a box cutter. And sexual and emotional abuse continued. So in 2015, just 3 years after that, he strangled our daughter, our young daughter, and he once again pled guilty for strangulation. This time his sentencing was higher, right? I filed for divorce again. And as soon as I did that, I was advised by my attorney as well, don't disclose the sexual abuse or any of the other abuse except for what you have the police reports. Don't talk about anything else. But some of that started to come in. He counterclaimed parental alienation. And so once he did that, the children were sent to multiple providers where they had to relive their story by retelling it again and again. Initially, after my daughter was choked, we were sent to the Yavapai County Victim Advocacy Center where they met with a trauma counselor. She was amazing. She documented the abuse and she said there was no alienation. The Yavapai County judge ordered a court evaluator, Dr. Ron Lavitt. I had to pay for the majority of that because the father refused to pay. But he confirmed to the court that there was extensive domestic violence history, including the attempted suffocation of my ex-husband's first wife. But still, Dr. Lavitt recommended that reunification therapy would be good for the twins so that they could establish a relationship with their father. He said there was no parental alienation. So the family court ordered that the children see Carol Kibbe, a reunification therapist in Prescott, with both parents assisting with those payments. On the very first visit, after visiting with the children, the twins, for 15 minutes, she declared that this was parental alienation. She ignored the multiple police reports, the court reports, the guilty pleas, the orthodontist records, the medical records, all of that. She ignored that. And over the next year or so, as they continued to go, she continued to tell the children that they were lying about the abuse. She told me if the abuse had been that bad, I would have left, and regularly threatened the children with being sent away to reunification camp. She also falsified many reports to the family court, and of course, things only got worse. So then father hired his own expert parental alienation psychologist, Dr. Lemberg, and he had the children again tested and interviewed. They had to go through the whole entire process. That psychologist also opined that there was no parental alienation, and the children were actually emotionally, physically, and verbally abused. The court ordered another, this time family reunification therapist, with the entire family attending. The father quit attending after a couple of visits when the therapist wasn't agreeing with him. Finally, when we got to the end of the court orders, based on solely the initial reunification therapist report, Carol Kibbe's of parental alienation, the judge ignored all other psychologist and counsel reports, all other documentation. He authorized unsupervised visits. In the divorce decree with shared custody, the family court judge acknowledged that there was extensive domestic violence, but stated, it's in writing, that it was not significant per Arizona revised statutes. So I want to talk a little bit about the family court impacts. I was punished for protecting my children. When my twins were high school honor students, varsity athletes, they were active church members, they were freshmen in high school, they refused visits. They were arrested, They were handcuffed, they were loaded in behind their backs, they were loaded in separate police cars and taken to juvenile detention. I was held in contempt of court for not being able to force them to go and was forced to pay my abusers legal fees. I spent over $225,000 trying to protect my children. We lost our home, our financial security, and our peace of mind. Most importantly, we lost precious childhood time. All of us suffer from PTSD. The court's decisions prolonged the abuse, re-traumatized the children and myself, and emboldened my ex-husband. Instead of helping the father become a better parent, the reunification therapist sided with him, dismissed the children's abuse disclosures as lies, and blamed everything on unproven parental alienation, destroying any chance of healing and only made things worse. Finally, even though the family court judge insisted that father was a safe individual, he denied my request for an order of protection and he granted shared custody. My ex-husband was then arrested, charged with 5 new Class 2 felony domestic violence charges, kidnapping and sexual assault. After a lengthy criminal trial, the jury found him guilty of all charges, and he was sentenced to 28 years in prison. So this is not just my story, it's the reality for countless Arizona families. We need legislation that requires courts to prioritize safety over shared custody, that disqualifies professionals who disregard documented violence, and that prohibits judges from relying on junk science such as parental alienation over substantiated abuse. I stand here today asking for real reform, and no family should have to go through what my family has. Thank you.
Thank you, Ms. Dalton.
Thank
I appreciate you making the trip down from Prescott.
Thank you.
Members, any other questions?
Yeah.
Representative Fink.
Thank you, Mr. Chair. Mary, thanks for coming. This has come up before. So when the judge says there wasn't significant evidence, did they define what they believed should be significant evidence?
No, and he said that there was domestic violence. He had the 2 strangulation charges. He had everything. He said those were not significant domestic violence.
And he didn't give you like a...
What would be? No, I'm not sure exactly how much it would take to be significant.
Okay. Well, frankly, that's a made-up term. It's not in law. Under 25403, it says domestic violence.
Okay.
It says under, that's one of factor 6. Under factor 8, I believe it's sexual assault. I might have them backwards. I don't see substantial in there. I don't see qualifiers.
Yeah.
It's a hard statement. Yeah. So that's one of the things that we happen to be finding with the testimony here. Now, of course, it's laypersons that are doing an assessment of the people that have just totally upended their lives. So I'm not sure who I trust more, probably the laypersons. But you probably will receive a call from my office in the not too distant future.
Okay.
All right.
Thank you.
All right. Thank you for making the trip. Next.
Cami Denny.
Ma'am, if you would, could you please give your name for the record, where you're from, and you have 7 minutes.
My name is Cami Denny. I'm here from Prescott also. I'm a dedicated mother, a healthcare worker, and I've taught swim lessons to children in my community for 7 years. I have absolutely no criminal record. My daughter is 20 months old and healthy and completing milestones far ahead of average. She's thrived under my sole care since the day she was born. We're survivors of domestic abuse. My co-parent has admitted in therapy that his standard of care is based on the profound abuse that he's endured. Our therapist wrote a concern letter to the court, which Judge Ainley admitted into evidence and then later denied admitting and threw out. He's made disturbing statements about his desire to control and harm us. He once told me that having a daughter would make it easier for him to turn her against me. He has 2 pending DV charges.
I'm sorry, his 2 what?
Pending DV charges.
Okay.
He's choked our dog, purposely kept me sleep deprived by waking our infant during the night to spite me, and subjected me to psychological torture, including after I expressed relief to finally have my body back to myself after pregnancy and 6 months of exclusive breastfeeding. He forcibly impregnated me against my will. When I eventually miscarried, I hemorrhaged and got an infection. He refused to help me find any pain meds, take me to the hospital, or even carry our sleeping infant safely downstairs for me. Instead, he left me bleeding out on the floor to die, to continue drinking in his room. My daughter went to the hospital with me where we spent 2 days. When I returned, he had left. He demanded that I clean up my mess in the bathroom. And it's there that I found the body of my miscarried baby in a glass bowl on our counter. He dictated that I needed to wait for him to bury our baby together, then proceeded to be unavailable for a month and a half. I looked at that baby every day. When I couldn't take it anymore, I buried that baby alone. He never even mentioned it. When I first entered family court with an ex parte petition, I was granted sole custody, and my co-parent supervised visits based solely on my word, with the agreement that I would be the supervisor, and Judge Ainley granted him 9 to 5 visitation at my home. So I had to follow my abuser around and babysit him to make sure he didn't hurt our daughter for his supervised visits all day long. During the hearing, where I provided evidence that everything that I said was true, and my co-parent admitted to drinking and driving with our minor child in the vehicle, he was homeless and hadn't even shown up to all the supervised visits, our judge told me, oh well, he's still the father, and granted him overnight unsupervised visits. She offered me an order of protection, but would not cover our daughter, so I withdrew my petition because I was afraid it would upset him, and when he's happy, we're safe. I took my daughter to the hospital after she returned from visitation with a swollen purple nipple. I did what any responsible parent would do. The hospital staff contacted DCS because they too were concerned. Aside from this visit, my child had only been taken to the doctor for normal well visits, a febrile seizure due to COVID, and a cut on her finger. There was no pattern of misuse of medical care, only appropriate parental concern. Instead of being met with support, I was threatened. Judge Tina Ainley told me she would take custody of my daughter from me if I continued taking her to the doctors. She then told me about another mother she had already done this to, another protective parent criminalized by acting in her child's best interest. The message was clear: stay silent or lose your child. What this statement implies is that if I hide the abuse, making me complicit, that I would be allowed to keep my daughter. That isn't justice, that's coercion. It mirrors the way gangs initiate new members, through forced complicity and harm. This is not an isolated incident, it's a systemic failure. DCS, after being contacted, gaslighted me after a 15-minute visit with her father, saying, I just don't understand what a normal childhood injury looks like. I'm an X-ray technologist. That's literally my job. If that's not enough, I have also attended the Child Abuse Convention put on this year by Phoenix Children's Hospital. Everything that's been reported by me was on a slide. When I asked for a supervisor, I was given a random incorrect number and then promptly ghosted by the investigator. Throughout this process, the lawyer representing my co-parent has encouraged him to manipulate loose wording in our orders. He's emailed me lists of demands unrelated to custody. He files that I'm in contempt, and when we get to court, he immediately withdraws. I still have to pay my lawyer. He vexatiously litigates, where we've been in court about 7 months, and I'm up to about $30,000. We've had no professionals assigned, and I have been pro se for several of the hearings.
You have about a minute, Cami.
Sure. Mr. D'Arienzo no longer serves me with filings or notifies me of any way. He claimed I was equally likely to be a predator due to the sexual abuse by his client. Judge Ainley ordered no child support and gave my co-parent a credit for about a year of 50-50 custody that he will not have. She ordered no back pay. Recently, my daughter was withheld from me during a scheduled exchange. I requested YCSO respond due to my co-parent having called multiple times while manipulating orders and then forcing my daughter to go. I've been threatened with felony charges repeatedly. He has a whole slew of criminal misconduct in the past, and Deputy Eric Hardy, who responded, informed me he'd be taking other calls and he'd get there when he'd get there. They left me at the exchange location for over 3 hours. When I called back, they had another officer at the station that they dispatched immediately. He found that I was telling the truth. He reviewed my evidence. Other Deputy Hardy came on scene, refused to have my daughter returned to me. He falsified the police report. YCSO is refusing to fix it. I have a hearing in about 2 weeks for contempt for this incident.
Okay.
He will skip sobriety tests, and Judge Ainley will say he's passed most of them. If he knows he's not going to pass, he just doesn't take them, and there's been no recourse.
Time's up, Tammy.
Sure.
I'm sorry, Tammy.
No worries.
Members, any questions? All right. The name of your judge again?
Tina Ainley.
I'm sorry, I'm having a hard time.
Tina Ainley
Okay.
of Yavapai.
And that's Yavapai Family Court?
Yeah.
Okay. And you're representing yourself pro se?
Yes.
Okay. I'm sorry for your loss, man.
Thank you.
And I'm sorry for the way the court system has treated you.
Thank you.
So we'll see what we can do to fix it. All right?
Thank you.
Thank you. Next.
Teresa Mangus.
Ma'am, if you would, you know the routine. Please give your name, where you're from, and you've got 7 minutes.
Teresa Mangus, Goodyear, Arizona.
Please proceed.
I'm going to read my statement because I'm nervous. My name is Teresa Mangus. When this family court case began, I had 4 minor children. In May of 2020, under temporary court orders, I was ordered to pay the mortgage and all the associated bills for my home, despite having done so alone since my ex-husband left in 2018. This order was based on my desire to keep the home for the stability of my children. However, when the divorce decree was finalized in October of 2021, the home was not addressed in the decree. It wasn't until April of 2022, 5 months later, that the home was awarded to me. The decree also denied my ex-husband parenting time due to his abuse of us. But the court continued to appoint therapists, court-appointed advisors, therapeutic interventionists, and COBIs. The list of the therapists were Barb Kiffmeyer, Madison Rhodes, Joseph Gaunt, David Weinstock, Robert DiCarlo, John Moran, and Judith Louise Tome. Over time, I was ordered to work with the several different court-appointed therapists. Despite the final decree, the court process continued, causing significant trauma. I was no longer financially able to afford these therapists. The court urged me to take out loans, open new credit cards, or take a HELOC on my home. I refused to take on more debt. My mother had already paid my home off completely, abiding by the court order, so that we could get the loan out of my ex-husband's name. I repaid her after I received my retirement settlement a year after the divorce. Because I couldn't continue paying for the therapist, the court stated I must sell the home to fund reunification therapy.
I beg your pardon, ma'am. The court ordered you to sell your home to pay for the therapy?
Mm-hmm.
Do you have a copy of that court order?
Yes, I do.
I'd like
Not
a
with
copy
me,
of that,
but
please.
I can send it to you guys. The proceeds were to be held in a trust by my ex-husband's attorney and paid directly to the psychologist through the trust.
What's the name of your judge?
This
The judge.
The
The judge that this happened under.
The judge that this happened under was Judge Stacy Avalar.
Thank you.
But the judges that I've had so far were Bustamante, Vandenberg, and the three that were the most atrocious were Stacy Avalar, Kiefer, and now the latest, Garabino, or Garbiano. Subsequently, the judge allowed my ex-husband and his attorney to pursue a civil court action to have me and my children evicted. They falsely claimed he was the landlord and we were his tenants. This was 3 years after the divorce decree.
I'm sorry. 3 years after the divorce decree, but also after you had paid the house off and gotten him off of the mortgage.
That's correct.
So in other words, you committed perjury.
Yes.
Okay. Just want to be clear on that. Thank you.
This was untrue. There was never a landlord-tenant agreement between us. Moreover, the home was held under my mom's trust and was not in his name. The fraudulent claim violated a protective order that granted me exclusive use of the residence and prohibited my ex from even coming down the street. Despite this, the Maricopa County Sheriff's Office enforced an unsigned writ of restitution, which I have on video, and forcibly removed my children and me from our home at gunpoint. An incident captured on video. When I questioned the legitimacy of the writ and requested the officer's oath of office, I was dismissed. One officer present was sworn into the Parks and Recreation Department, not even the sheriff's office. My formal complaint to the sheriff's office was followed by the court filing a different writ 3 weeks later that was signed, but not by a judge, by a clerk.
Excuse me. And you have all this documentation?
That's correct.
Okay, please see to it that my office gets this documentation.
Okay. And it didn't, the writ that they filed into the court was not the original writ, and I have both the writs, one that was on video because I videotaped that day. Later, the judge and the judicial assistant changed my official court address at the request of my ex and his attorney. They served documents to an address I had never confirmed as my own, resulting in a hearing I was unaware of. The new judge, unfamiliar with the case, erroneously assumed that the home was jointly owned and ordered it to be sold. Mind you, he ordered it to be sold 53 minutes before the hearing even began, and it is on court record that he ordered this 53 minutes before. My mother's trust, the rightful title, was never made a party to the case. I received no notice, no hearing, and no due process. My ex and a real estate broker that was appointed by the court, Beth Jo Zeitzer, proceeded to list the property on MLS under various false ownerships. Sometimes it was my mother's name, sometimes it was her trust name, and finally mine and my ex's. My ex signed documents as if representing my mother's trust, and the broker signed on my behalf without authorization. Despite this, the Maricopa County Recorder's Office recorded these documents and transferred title without the trust's consent. The supposed buyers have already resold the home just months after acquiring it in October of last year. An investigative journalist contacted the listed title company. The vice president of that company and a staff member confirmed that they refused to clear the title once they were made aware of the situation. Despite this, documents on file at the recorder's office still list the title company. The vice president stated they would not clear the title to avoid potential lawsuits.
Okay, Teresa. Time's up.
Can I
understand.
just have
Can you finish up here in just a minute?
Yep.
Because I got a bunch of questions
Yep.
for you. All right.
After the sale of my exes held the proceeds in the office trust account. Around $70,000 remains unaccounted for, and I have never received a complete accounting. Though the home was sold under the premise of funding reunification therapy, no such services have occurred. The result, my home is gone, my money is gone, and my children and I were left homeless. Most devastating
During this ordeal, my youngest daughter was diagnosed with an aggressive brain tumor in October last year. After brain surgery and nearly 2 months of radiation, she has no home to return to. The only home she ever knew has been stolen. She asks for it back every day. Is this justice? Is this what a system that claims to serve the best interests of the children looks like? Is this not evidence of a coordinated scheme to rob people of their home, finances, and families? I, along with the many others, am begging for this to stop. Someone must take action.
Thank you, Teresa. I'll give you a minute. I got a bunch of questions for you.
Go ahead.
Ladies, you have a question?
I do have one.
Representative Fink.
Oh, okay. Mr. Chair. Teresa, thank you for coming. I'm so sorry to hear all the things that have occurred. One thing I just had a question on, because you said you were given, order to have all these therapists and all that, and it was after the divorce was final. Why did they start ordering all of those court-ordered interventions?
Some of them were before, and 4 of them were after, because my ex-husband was not awarded any custody. So they left it open, saying he's not awarded any custody due to his abuse, but they were going to let him try to regain custody at a later time. So it continued on, so that maybe at a later time, because they could not give him custody until he was reunified. So they just kept ordering more reunification specialists.
Mr. Chair?
Proceed.
Okay, so with this reunification, so even though there was abuse and all that, you were ordered to do reunification therapy in a reunification camp and to sell your home for all of that?
That's correct.
Okay.
And I even filed a complaint at the psychology board because they were trying to take the home. Before they took the home, I filed it against Dr. Moran because they were trying to take it to pay Dr. Moran.
So I'm sorry, I need to get some clarification here. You said everything was taken from your house or sold in order to pay for certain therapy services and reunification, which never happened.
They took it to under the guise that I was going to have to do the reunification therapy again with Dr. Moran, which I couldn't afford anymore.
Which never happened.
That never happened.
Okay. Representative Fink, were you done?
I'm done. Go
Okay.
ahead.
Well, number one, the county recorder by law can only record documents. They're not authorized to question documents, okay? Number two, the title company rightly refused because there's now a cloud on title for that property.
But their name's on the documents.
It may be
that
on
say
the
they did it.
document, but there's still a cloud on title, okay?
An assessor's office changed the title due to
Well,
these documents.
okay, we're going to get into the culpability of government officials in falsifying documents in just a minute. All right? I'm sure that you have a well-documented record of all of this.
Mm-hmm.
Okay. If you would, please get us a copy of your documentation. Get that to my office. This is one of those egregious cases that we're going to refer you to a civil litigation expert, because we now have, what I've heard you say is you had a writ of restitution that wasn't signed.
That's
It was
correct.
enforced. It sounds like by a non-post certified officer. Okay? There's so many things that are wrong with this that we cannot just let this sit by. All right? So there will be a referral out of my office. Please see to it that the documentation you have goes to the young lady to my right. All right?
I don't have it with me. I
Well,
have to get it.
you don't have, this is not
This-
something
this
that's going to
lady?
happen today. Yes, to
okay.
that young lady. But once you get that documentation together, if you would please hand deliver it here.
Okay.
We'll make a record on your slip so that we can make a proper referral. Now, I'm sorry, the judge again that ordered all this?
There was a couple judges who ordered this.
The one
It
that
was
ordered the sale or?
The one who just ordered the sale was Garbiano. The one who decided to take the home was Kiefer, and the one who told my ex that he could go file and say he was the landlord was Avalar.
The judge told your husband?
A handwritten. First, she wrote an order saying, I don't remember, it was a really short order, but then she hand wrote, I think it was her who hand wrote it on there, that he could go get, because
Okay.
she signed it.
Well,
That.
I think isn't going to cut it, but.
Well, it's she signed it underneath it, her handwritten.
Oh, well, okay, that kind of changes things. All right. We're not going to do the deep dive in the rest of my questions here, because frankly, I think it would undermine your opportunities for litigation. But we've got an issue here with private parties, county officials, and even state officials. So in an expeditious manner, if you would please get that documentation to my office so that we can help you. All right?
Okay,
All right.
thank you.
Thank you, ma'am.
Okay.
Next.
Michelle Fox. Selena Meadows.
Hello.
If you would, please give your name and where you're from for the record.
Hi, yes, I'm Selena Meadows. I am from Phoenix, Arizona, born and raised. I am here more in support. I have, unfortunately, in the past, encountered the horrors of the family courts, and just really here in support of my best friend, Rachel Cardona. That said, hi, I'm Selena Meadows. I am a survivor of domestic violence, and I am now a domestic violence and advocate of crime survivors. I personally know the horrors of family court. My ex-husband was a former Special Forces weapons sergeant, also known as a Green Beret, specializing in weapons. He was trained in psychological warfare and other forms of weapon systems. He manipulated the family court here in Arizona by posing as a concerned father. He refused legal representation after posing as it was a financial hardship, but his attorney refused to participate in putting our children in danger. This man was highly trained and dangerous and fully capable of making good on all of his threats. The abuse left my children deeply traumatized. Our son experienced cognitive regression. Our daughter with autism was told that she had to complete trauma therapy before she was in a state of mind to even finish occupational therapy. In the family court, he admitted to the attempted murder of our son in public place. He admitted to multiple attempts of murders, me in front of the children, killing one of our family dogs, torturing others, and about allowing the children to play with items that he picked off the dead bodies he killed while in Afghanistan. Additionally, I also provided proof that he was a diagnosed psychopath and had failed 2 psychological evaluations while in the military. Our case was early on received a lot of support from Senator the late Senator McCain, who was at the time chairman of Armed Forces, Senator Gillibrand's office. The Air Force actually helped escape while he was in sniper school while he was Army. That said, he was also flagged by the FBI, ATS, Homeland Defense, and the Phoenix PD, and the Phoenix courts were made aware of this. I had proof, and I delivered hundreds of pages to the court that he had explosives and a lot of weapons missing and unaccounted for, and that he had multiple scenarios of mass murder fantasies, some including children, including our children specifically. Because of this danger, the children and I were in hiding for about 2 years. The family court, we were able to be in the ACP, but at this time, we have to make certain that everything stayed protected, because even with him acknowledging the attempted murders and all these things been brought up in the family court, I was told that I still had to provide a pathway to my children Our case was labeled significant domestic violence. I had so much evidence that our case helped change child abuse and domestic violence policies for his Special Forces unit. They modeled that within all of the military bases within the area, and I helped with the 2018 Military Family Protections Act. And I've helped with the Order of Protection law here in Arizona, as well as trauma recovery centers here in Arizona was written into law. That said, it still wasn't enough to make certain that my children and other people's children get some changes inside of the family court. At this point, there is no formula. All of this discretion is insane. At this point, it's no best interest of the children. It's just flat out corruption. At this point, I really want to make certain that I can do whatever I can and really appreciate everything that you guys are doing to make certain that all of our families and our children are provided the safety that they deserve. I know the fear that just even seeing my best friend and her children endure, that my children once lived in fear. That's the fear that we all encountered. And the only reason why my ex-husband at this point in time has not had any contact with our children is because he didn't get the coercive control that he desired. Not necessarily because the family court, because to this day, technically, he has a pathway. So at this point in time, is a lot that has to happen. This discretion and this gray zone that the family court is, even victim rights don't live in these spaces. So even the domestic violence itself, these are crimes. And so I do ask that whatever we can do and however we can support, I am there to do whatever I can and appreciate that you guys are even doing anything to make certain that we are able to make these steps to provide not only safety, but a realistic childhood to children who have been denied that.
Thank you for your testimony, ma'am.
Thank you.
You, ma'am, need to get connected with Master Sergeant Ross, sitting over here, blonde-haired gal. You probably are going to be fast friends, all right? All right, next.
Bandy Lee.
Hello.
Hello.
If sorry, it's been a long day. If you would give your name, where you're from, and you have 7 minutes.
Yes, I'm Bandy Lee. I'm from New York City. I will be speaking as an expert as well as someone with personal involvement in the Family Court of Bergen County, New Jersey.
Could you please tell us your expertise? Your expertise?
I'm a forensic psychiatrist and violence expert with 25 years of experience. I've been in criminal and civil courts as an expert witness in about 200 cases. About 50 of them are in family court.
That'll do it. All right. Please proceed, ma'am.
Just to give a little bit of more background, I am president of the World Mental Health Coalition, co-founder of the Violence Prevention Institute. I was a research fellow of the National Institute of Mental Health, taught at Yale School of Medicine and Yale Law School for 17 years before transferring to the Harvard program in psychiatry and the law. In 2007, I helped co-author the United Nations Secretary General's chapter on violence against children, among other international documents, helping governments to implement prison reform and other violence reduction programs. For clinical practice, I work in maximum security prisons, treating some of the most violent individuals our society produces. Yet, nothing prepared me for family court. We do not ordinarily think of family courts as sites of violence, but by denying, or worse, exploiting the existence of domestic violence and child abuse, family courts have become one of the deadliest places for children and the adults who try to protect them. I commend you for calling these meetings and calling out family court as the national emergency that it is. I have testified before the legislatures of Colorado, New York, Louisiana, Tennessee, and Washington, and I'm very honored to be here. I'll be submitting a more scholarly written testimony for the record, but here I will not mince words. Family courts are a danger to society, and unless dramatically reformed, they need to be abolished altogether for the safety of our children and their loving families. This may sound extreme, but when an institution causes far greater harm than good, indeed sends close to 100,000 children per year to their soul murder, if not actual murder, then such an intervention is necessary. I have the empirical data to back up my claims, which I can get to if there is time. Despite my 25 years as an expert witness for the courts, I did not know about family courts. Since learning about them, I've tried to take as many cases as possible, but while I'm considered a highly qualified expert in criminal and any other court, only in family court have I been unwelcome. In fact, judges often try to find almost any reason not to admit me. This is because they, as a rule, are not looking for qualified experts. They seek poorly trained or compromised so-called experts who will fix the results in the direction they desire. In other words, the opposite direction of which the case should go. Unfortunately, sending children to their abuse, rape, battery, murder, sex trafficking, and pornography production has become a lucrative business. I would not have known about family courts except for my sister's divorce. One moment, her children are thriving under her care with perfect physical and psychological health, and she's praised around the neighborhood for her parenting skills, consulted by other parents and teachers. The next moment, her previously absentee father files for divorce, and her children are seized in a police raid without warning on their legitimately assigned weekend to be together, and the violently abusive father who almost killed each of his 2 children by head injury gets sole custody. And the mother has not seen or heard from them, the children she raised since birth, for the next 4 years. Not even 1 minute. And what is the reason that the family court gave? She was supposedly mentally ill, even though no licensed professional ever raised any concerns. Subsequently, she has been evaluated by 11 world-renowned psychiatric experts, some of them consultants to the United Nations, the US Supreme Court, and the International Criminal Court, who all unanimously said she had excellent mental health and exceptional talent in parenting. But none of this mattered. Only one unlicensed and unqualified associate counselor with a master's degree contradicted them all. And this is the one report the family court judge would accept. In addition to these so-called experts, family courts make use of guardians ad litem. In my sister's case, the guardian ad litem lied or perjured 600 documented times in her case, and even co-conspired with her ex-husband to attempt to cause her demise, putting her in the intensive care unit, but in the end, Judge Jane Galina Mecca only protected her, the guardian ad litem. In fact, the judge now regularly appoints this guardian ad litem, Evelyn Asirios, in almost every case she presides over. For these reasons, we are now pursuing the impeachment of Jane Galina Mecca. But I'm sure this is a familiar story, and it is correct to address this as a systemic problem. After participating in approximately 50 family court cases, I've come to learn that my sister's situation is not at all unusual. Cases may vary widely, but family courts all across the country produce almost the same result when abuse is alleged, which is the vast majority of custody cases. That is, custody is almost invariably taken from the stable, nurturing parent who are well bonded with their children to be given to their abusers. The more clear-cut the case, the more draconian this formula. And the stronger the evidence the good parent presents, the more retaliation they face. I've not once seen supervised visits be applied to the dangerous parent, and if the children resist, as healthy children would, they're sent to reunification camps, which are in truth torture camps, intended to extinguish any drive to resist their own abuse. And the same holds true for reunification therapy. I guess I'm running out of time, so.
Oh, no, ma'am, you have plenty of time. Please proceed.
Thank you. I have often compared family courts to the prisons that I have studied for decades. Medieval barbarism that civilized society cannot imagine happens within them. Those who enter are grievously maltreated, and all manner of human rights violations occur with no accountability because of a lack of transparency. Torture is routine, and even murder goes unpunished. In family courts, judges have the authority to seal their cases, and this essentially gives them star chamber-like secrecy. Without a jury or any oversight, what occurs within is usually unmoored from the law, especially with the exceptional discretion that people have talked about, that family judges have. This was initially granted so that judges could exercise benevolence with vulnerable families, but a 120-year chronicle has shown that it has rather been used for malevolence quite regularly. When tragic deaths happen all too often, the public assumes that there must have been extenuating circumstances or that these institutions are doing their best under difficult circumstances. They do not imagine that family courts actually facilitated the deaths or even forced them on families that mobilized all their resources to prevent. I've come to call family courts anti-courts, where case fixing replaces fact-finding, pseudoscience is given precedence over established science, conflicts of interest replace any semblance of impartiality, and the greatest injustices done to families are committed in the name of justice. If a hospital or clinic were deliberately killing rather than curing people, it would immediately be shuttered. But when courts do this, there's no relief because of judicial immunity, and we have learned that judges cannot be relied upon to hold other judges accountable. Instead, prisons and family courts, because of their secrecy and impunity, have become magnets for violent, sadistic, and psychopathic individuals who relish exercising power over others. Those who do not go along with the culture usually are threatened or ousted. Prison guards may be seen as poorly trained individuals who come from similar backgrounds as the prisoners, but family court players are even more dangerous since they're driven by a $50 to $175 billion industry hidden beneath the power of being called a court. Now there's a bunch of statistics that I could cite. I'll submit it in.
Well, if you would, just get the statistics to our office, and we'll appreciate that.
I will do so. This is all scientifically supported.
Okay.
The public is unaware of the epidemic of violence occurring through the family courts because judges threaten reporters and journalists as well to control their coverage. When a major magazine published an interview with me, the judge in my sister's case issued an order for them to immediately unpublish the article. When their legal department sternly rebuked the judge for violating the First Amendment, she rather returned to her drawing board and issued a second order. It turned out that even the Washington Post had shamed her 10 years earlier for trying to order the takedown of another article, but because of impunity, she remains undaunted and her unconstitutional orders are continue. The end result is that this magazine and others vow never to cover family court stories again. The United
Well, that's
Nations,
a mistake.
Excuse me?
As we've said earlier, Justice Brandeis.
That's right.
How about a little sunshine on this? And frankly, ma'am, you've put more sunshine on this than many of the people that have testified over the last 3 hearings.
Well, I've been in a lot of cases and I've examined all the evidence. It's not insufficiency of evidence, it's not ignorance or incompetence, it's quite despairingly deliberate.
I appreciate that. And we really have run out of time with you. I'd let you talk the rest of the day if I could get away with it. But we do have a couple questions for you, all right? At least I know everybody else is chomping at the bit. One major question for me is, in your professional opinion, with all that you've heard and what you've clearly lived through, and I presume that your sister's case is out of New York? Or
New Jersey, actually, Bergen
New Jersey,
County.
okay. Same to us out in the West. Do you think or believe that judges have been taken in by this psycho, I'm going to call it psychobabble, but you called it pseudoscience, pseudopsychology, almost in a Svengali kind of way where they just totally disregard a mountain of evidence in front of them for the shiny object in the room that has somehow overtaken the thought process of the judge. Could you speak to that?
I would say the direction was actually in the opposite, that judges go looking for experts who will give them whatever theory that will allow them to give the children to their abusers. And, parental alienation, for example, is one which has been used as a tactic to deflect from and deny abuse allegations. I actually say that it's a pretext for predatory alienation of the good parent.
Okay. Have you ever heard of AFCC?
Yes. Unfortunately, they are quite driven by the parental alienation theory, and I believe that is because it brings them profit.
Well, all right, you jumped right to the next question. Good. I'll go ahead and put it out there. It occurs to me that this organization, from everything that I've seen, read, really has a profit motive that it's driven by, not necessarily a best interest of the child. Would you agree with that?
Yes.
Okay.
And actually, very distressingly, not only is this prevalent in all 50 U.S. states, I will say, and I've personally been in cases in about 20 to 30 states, and it has been used as a business model, exported abroad, to the point where the United Nations Human Rights Council put out a major report in 2023 alerting this family court problem as a public health crisis because of the model that's been exported from the U.S. abroad.
I presume that report is online, that we can pull it
Yes.
down?
Okay.
If you would, could you give
Yeah,
us the
I will.
report
Yeah.
title to that so that we can pull that
Yes,
in?
it's by the UN Special Rapporteur on violence against children and women.
Okay, we'll definitely make that part of our report. One last question I have before I turn it over to my colleagues. Have you heard of something called COBE?
Yes.
What's your opinion of court-ordered behavioral intervention?
I find it to be coercive. In fact, I call it torture, and it is intended to inculcate in children that that what they see, heard, and have experienced is untrue, and it's a form of thought reform, in my view.
You know where that comes from, right? COBE?
No,
Phoenix, Arizona.
I see.
Thank you, ma'am.
Thank you.
Representative Keschel.
Yes, thank you, Mr. Chair. So have you ever been called as an expert witness in an Arizona family court? Because I know you said 20-some states.
Yes, in fact, I have.
Okay. With what you're hearing today from these people and your experience with the Arizona courts, do you feel that the judges are considering actual forensic evidence in any of these cases?
In my experience, no. I will have to honestly say that out of 50 cases, only one went the right way after unbelievable amounts of argument and fighting, actually. I usually come in after things have gotten bad, but I have to say that no amount of evidence matters. A 4-year-old who has been claimed to have been raped, a positive rape kit, 3 medical professionals having interviewed her and called her credible, and burn marks, all kinds of injury marks. It was still considered unsubstantial, or whatever CPS says in these cases.
Ma'am, I'm sorry, doctor. Are you now, or have you ever worked with a U.S. attorney having to do with cases related to this? And I'll have a follow-up question to that. Related to your field of expertise.
I have not. I've tried to reach out to a number of authorities, and including law enforcement, and my experience has been that they've been either unresponsive or protective of the judges.
Do you know what racketeering is, ma'am?
Yes, and I believe that a lot is going on with the family courts.
Representative Fink.
Thank you. Dr. Lee, thank you for coming. If you wouldn't mind sending me your testimony, there's a lot there that I need to digest. There's quite a bit there, but one of the things that has gone back and forth is this parent alienation, and there's been they've bankrupted families. What I've heard, yes, they're trying to change the mindset of the children. It always when I first heard of it, I thought of re-education camps like North Korea. The way I was listening to that, but I've had people say, well, no, actually, you need to take that into consideration. No, you don't. For your professional opinion, is parent alienation truly a syndrome or a clinical diagnosis at all?
Not at all. It's not taught in any mental health educational program. It only exists in family courts, and the cases that are labeled parental alienation, if they were to come out of family court, they would just be clear-cut child abuse, domestic violence, without any ambiguity, and they would be adjudicated in a matter of weeks in criminal court.
Mr. Chair, to that point, do you feel, have you ever witnessed in any of the states that you've testified in that there are judges that disregard the whole parental alienation? You know, because I feel like they're taking real physical abuse versus the abusive parent saying parental alienation. Are you seeing, I guess I'm looking for hope today. Have you seen any judges within the family court that see that for what it is, or is it just so much the standard that, do you kind of see what I'm saying with parental?
I've actually seen a lot of judges move away from that phrase because of the stigma around it. Not so much because they denounce it, as all the major health associations have done, but because it was first parental alienation syndrome in the 1980s that got so much criticism and lack of scientific support that it started to be turned into other types of terminologies, whatever they call it. It's a pretext, as I said, for predatory alienation of the good parent.
Yeah, it seems like the squishy balloon. No matter where you grab it, it's always kind of morphing into something else.
Yes,
like
one thing
balloon tie.
I wish to say that in terms of solutions is education of the public is extremely important, and also open courts. But I would not so much emphasize education of judges, because if the incentive to give the children to the wrong parent is still there, then no amount of education, no amount of correction of theories will help.
So 2 observations. One, the court is incapable of being a super parent, yet it has seized that responsibility. The second is, and I know we need to move on to the rest of our witnesses, but it occurs to me that there is quite literally no test right up front to establish, and we've got this in Arizona law, 25403. 12 factors that are supposed to be considered in the award of parenting time and the award of custody. Yet the court took it upon itself under Gutierrez to say, well, the temporary orders don't count because they're just temporary. Yet they can go on for a child's lifetime until they age out of the system.
Exactly. I think that is the goal, that the children are taken for no reason at all. In my sister's case, she was given no reason. They were taken by force by a police SWAT team. And I believe that was to maximally traumatize and maximally incapacitate her and the children's ability to fight back. And then there's
I'm sorry,
no...
did you say that the child was taken by a SWAT team?
Yes.
From a mother?
Who was simply
unarmed,
carrying out her parenting time with them.
Unarmed
with
in
no
her home.
Warning, no concerns about her parenting ability whatsoever. It's only the father who was on a restraining order earlier for slamming his children's, at this point, the 7-year-old son's head against a window, almost crushing his skull. And yet, he was just in the process of regaining parenting time, and that was when the custody was switched.
This is quite an indictment of the system, madam.
And
All
no
right.
plenary hearing for going on 4 years.
All right. Thank you very much for your testimony. We'll be in touch. All right.
Thank you very
Thank you,
much.
ma'am.
Okay, on the next form, I have two names, Bridget Bring and Tiffany Flannery. That- Okay. Okay. Okay, so please state your name for the record, and then you have 7 minutes.
Tiffany Bring. I'm here for my son, who is the petitioner in the family court case, because like others, he has a job and he's not able to miss work. I was urged, I had about an hour-long phone call with Elena Kowalinsky several weeks ago, and I was urged to come and share our story. So, my son, the petitioner, he's been in family court with Paula Williams for the last probably 4 years, establishing parenting time and such. The current issue at hand happened July 21st of 2023. I received a phone call from my granddaughter's mother stating that her little brother of 22 months was found deceased in his bed. And my first question to her was, oh my gosh, has he been sick? And she said no. The kids were playing fine. They took a bath. We put them to bed. I got up in the middle of the night to check on them because I was cold, so I thought they would be cold. And then she goes on to tell her story. This does not make sense to me that a normal, healthy 22-month-old child just ends up dead in his bed. So I took it upon myself to do my own investigation. I asked her where my granddaughter was. She said she was with her and she was safe. And again, it's not adding up. It's not making sense. We spent the whole weekend calling the child abuse hotline trying to find out where my granddaughter was. Because not only has family court failed us, DCS has failed us. The mother lied to DCS when they showed up on the scene and said that my granddaughter's father, my son, was not involved in her life. Therefore, they took no measures to try to contact family to take her. This led into us going that Monday morning and getting emergency or temporary custody orders and removing my granddaughter from that home. It has also led to a year-long homicide investigation of the mother and her boyfriend, who is now her current husband. The original temporary orders were that my son had the full custody and the mother was receiving supervised visits, which Judge Williams also ordered. She stopped the child support that my son was paying, but then she ordered that my son pay for half of those visits, which amounted to probably $1,000 a month that he was having to pay for the child's mother to see her when she's the one in the wrong. Those orders were changed in November, and I'm just going to read you a bit of it because it doesn't make sense to me. The court finds that parenting time that ensures mother will have substantial, frequent, meaningful, and continuing contact with the child would endanger the child's physical, mental, moral, or emotional health because mother and her now husband were investigated for the baby's death. Law enforcement submitted charges to Maricopa County Attorney, which they declined prosecution because they said there is no smoking gun evidence. The child has not spent unsupervised parenting time with mother since August of 2023. DCS conducted a family functioning assessment regarding mother and her now husband during its investigation in the aftermath of child's death. DCS noticed several text conversations between mother and husband in which mother addresses husband's apparent propensity to give the baby whoopings. Baby was less than 23 months old at his death. Further, mother admonished husband because he wanted to kill the baby. Additional information related to mother and husband's conversations show that their relationship was often strained by the rigors of raising 2 young children. The court is concerned that the husband's capacity to help care for the child and for mother's ability to recognize when someone is a danger to her child. Until further order of the court, the husband will not have contact with the child, but she is going to allow unsupervised parenting time with the mother. And in order for her to do that, she was supposed to attend 6 sessions of forensic informed therapy. When her counsel gave us the name of the counselor that she was attending these sessions with, we investigated and we determined that she is not a forensic informed therapist. She is only a licensed professional counselor. We filed a petition. Judge Williams, we feel like, didn't even read it.
I'm sorry, the name of the counselor?
The name, Patricia Elias.
Okay.
And if you Google her, it says licensed professional counselor.
Yeah, don't use Google.
And the judge is Paula Williams.
Paula Williams. And Megan Stillwell was appointed as the best interest attorney. And oddly enough, she recommends that Harley be allowed to be around her husband with supervised visits. So we've gone to, because we know what happened, we know that they're lying. We know what happened to Harley's brother. And we're not just gonna let this go. When the county attorney declined prosecution, we went to the county attorney. We've been to the county attorney several times. They've admitted that the baby was a target child. We know that the boyfriend, now husband, is the one that probably did it. And the best interest attorney is recommending that my granddaughter be around that person. How is that in the best interest of a child? I have police officers, her school teacher, DCS, neighbors, friends. She tells everyone that she does not want to see her mother. And whenever we bring that up in court, they say that we're coaching her. Judge Williams intimidates my son. She bullies him because up until just 2 weeks ago, my son was representing himself because we didn't do anything wrong. We're just trying to protect a child, so we didn't feel like we needed representation. But because of Paula Williams' behavior and the bias that we are seeing in family court, we felt it necessary to get counsel.
Mr. Chair, I have a couple of questions. How old is your granddaughter?
She just turned 6 in April, so she had just turned 4 when her brother passed away.
So I'm assuming there was an investigation into his death.
There was
the
a year-long investigation.
What was the conclusion?
So the charges that were submitted to the county attorney were child abuse and aggravated assault leading to the death of a minor, and then child abuse and neglect. And it should also be noted, DCS substantiated those same charges, and when they found out that the county attorney was not going to prosecute, they then unsubstantiated those charges. And when I questioned them about that, they said that some kind of internal rule had changed and that their proof of burden became higher, and so they were not going to be able to substantiate. We have 297 autopsy pictures of this baby who has 26 injuries to his body. There is a 497-page police report, an almost 500-page DCS report.
And what was the name of the county attorney that did not want to prosecute?
Joshua Clark and Diane Greer.
Okay.
And it's not, and he's told us, basically off the record, it's not that they don't want to prosecute, they just don't have the concrete evidence that they need, and they're afraid that if it went in front of a jury and they were found not guilty, and then evidence comes back later, they can't be tried again. He agreed that the baby was a target child, and more than likely not only was he abused, but he was probably suffocated. And Paula Williams thinks that it's okay for my granddaughter to go spend the weekend with her mother. I've had police, I take her to the drop-offs a lot of times because of my son's work schedule. I've called police to have standby because she gets abusive. She has domestic violence charges on she's assaulted my son. So there are times that I have police come and do a civil standby. They've taken my granddaughter to their patrol car and ask do you want to go with mommy or do you want to go with Gigi? And she says, I want to go back home with Gigi. And then the mother says, I have these court orders that I get her. She forces her to go. And half the time, I feel like the mother doesn't even necessarily want to see her. She just wants that control.
Mm-hmm.
But how many more people does my granddaughter need to tell that she does not want to see her mom, that she is not safe there? I mean, she has told everyone.
Understood. Any questions?
Mr. Chair, Tiffany Brink, thank you for coming on and talking. According to 25-403, domestic violence and abuse is supposed to be taken into consideration for the custody of the child. Has that been, I mean, they know about this, Judge Williams knows about this. Has it been admitted at all in court, or they have not been addressing that issue at all?
We have admitted numerous things, and because my son was representing himself and she has two attorneys, she has a family attorney and a criminal attorney, it turns into a circus and none of the evidence ever gets looked at. I honestly believe that Judge Williams has not read one page of that police report. And that police report in itself is very telling. Even if they did not kill this child, they are not, no child is safe around them based off the text messages and their relationship the two of them have.
So it's a recurring theme. I'm going to ask this question of you as well. Are they currently under temporary court orders?
Yes, we've been under temporary orders since July 24th, 2023. They've changed a little bit. So the most current temporary order, and this can be your copy, was from November, and that's when she allowed the unsupervised visits. That's traumatizing my granddaughter.
Yeah. So once again, we're going to go back to the Gutierrez case. The appellate court in Arizona has said that you don't really have to follow the law if it's a temporary order. So we'll be taking that up in the next legislative session, I assure you, ma'am.
Okay, and I also forgot to mention, just real quick, we also have a juvenile court case. We had a hearing last Friday for severing her rights. Judge Williams believes that we will not be successful in that, but we feel like we will be successful because we feel like the juvenile court is paying much more attention.
Well, it would be interesting to know if she's had an ex parte conversation with that judge.
I don't know if she has or not, but...
Well, you won't know.
No.
That's my point.
Yeah.
All right.
Do you
Thank
want
you, ma'am.
these copies?
Yes, if you would give it to this gentleman and we'll get it in the record. Thank
Okay,
you.
thank you.
Okay, how many more we have? Because ladies and gentlemen, we're way over time. Okay, so we're going to give you your 7 minutes, but we're going to try and get this done before dark. Okay? Next.
Lori Schlinger.
Is she gone? Oh. Hello. Yep, you're a tall one. Okay, if you would please give your name, where you're from, and you have 7 minutes.
Hi, my name is Lori Schlinger, and I'm from Gilbert, Arizona.
Thank you for coming, Laura.
Thank you. Okay. My family court journey began almost
so sorry.
Take your time.
5 years ago, I finally got the nerve to leave my abusive relationship. My abuser himself had 4 boys from another marriage, and I had 3, and then we had 1 together. The boys and I endured horrific abuse. My ex thought that we were all contaminated. We endured hours and hours of Pine Sol and sanitizer showers because he thought, again, we were contaminated. We weren't allowed to touch the floor. We were carried out to the car if we had to go somewhere. We spent hours and hours. He kept the boys in underwear in one room. I finally got the courage to call the police when he left 2 of his boys that he alienated against his first wife. He kept them on my couch for 6 days and only allowed them to get up to go to the bathroom. They ate, they slept, they watched TV on that couch. He didn't want them to contaminate the rest of the house. We had a pathway we had to walk on. No one was really allowed to come over. DCS was called. I called the police. But then the detective, when he called me back, my ex was right next to me, so I had to retract my story. I'm sorry. And that police report has haunted me through the court system because they called me a liar because I retracted it. Once we finally got temporary orders, I got temporary emergency orders because he chased us around with a dart gun, and the judge decided on my behalf. We finally had our court hearing in 2022, and I'm so sorry. And I was telling the judge a situation where my ex kept me in a motel. He took my clothes, my phone, my car keys. He made me swim for hours, and then I had to endure a Pine Sol sanitizer shower, which lasted for a good hour and a half, 2 hours. I wasn't allowed to leave. Finally, after 2 days, mind you, I was pregnant. After 2 days, he let me go. There's just, when I told the judge that story, he turned to me and said, "Why didn't you leave?" And anyone who's been in abusive relationships, no, you can't leave. I was so scared that the judge would give my son to him 50-50. So I stayed. I kept staying. I kept going back. It was dumb. But finally, I filed for divorce the 3rd time. The judge, again, looked at me and said, "Your story is so unbelievable. Not that I don't believe you, it's just that unbelievable." I was just dumbfounded. I've never been, so victim shamed. The judge again asked me why I didn't leave, and I just said I couldn't leave. I wasn't gonna leave. I had to stay and make sure that my kids were safe. My judge heard all this evidence in court, including testimony from his first wife, who endured this for 13 years with her kids. She lived in a house with no furniture because it was all contaminated. The Navajo County judge in her case, she went through 5 judges. No one believed her. And finally, one judge did.
it wasn't until my ex parental kidnapped 2 of her boys, and then finally they gave her an order of protection with the kids on it. In our decree, he did give us supervised visitation, but also gave him joint decision making. So any issue I have to go to my abuser and ask him permission, whether it be educational or medical. And it's very hard because he's going to turn it around and make it about him. I need to get my son therapy because he's having issues because of this man. He hasn't seen him in over 2.5 years, but the man, he's allowed to call on Mondays and Fridays for 30 minutes. He rarely calls, but when he does, my son is very scared. He'll even wet the bed the nights he does call. So I went to try to get him therapy, but they said, you have to get permission from your ex, and I can't get it. So our judge did order a forensic psychological exam, but after the fact that he gave him legal decision making. So make it make sense, because he has mental illness, but you give him legal decision making over my 3-year-old, who is now 6. He doesn't pay child support. I keep having to hire an attorney to get the child support. So I have to pay the attorney to get my child support. I have been awarded attorney fees, which he's never paid, but I yet still have to pay my attorney. I'm luckier than half these people, and I've only been in debt for $50,000 through the court system. Family court is in a crisis. I am asking the courts to stop putting parental rights before the children's. Prioritize the child's lived experience and their voices. Thank you.
Thank you for your time.
Thank you.
And once again, I find myself apologizing for your treatment at the hands of the state of Arizona. This is, once again, an egregious miscarriage. And of course, as the courts would say, we're only hearing one side of the story, but I can't believe that the other side would vindicate what you've been through.
He has been diagnosed in his ex-wife's case and has he's been diagnosed with narcissistic abuse, severe borderline personality disorder, possible bipolar, and severe OCD.
I'm pretty sure Dr. Lee's just cringing right now. Yeah, getting a.
Thank you.
All right, thank you for your time, ma'am.
Thank you.
Next.
Robert Del Garbino.
You know what, Robert's had a couple of bites at the apple, so. Okay, anybody who has not testified yet. Shirley's gone. Is Shirley gone?
Oh, okay. Go ahead and bring that up too.
I'm sorry?
She hasn't testified before, and she didn't know how to turn that in.
Okay. Ah. Got in right under the wire.
Okay. I will use it wisely.
Right. If you would, please give your name and where you're from for the record, and you
My
have
name
7
is-
minutes.
Thank you. My name is Janelle Collins. I'm from Phoenix, Arizona. I wanted to bring to the committee's attention the Sojourner Center. There is an office for the Sojourner Center located inside the Order of Protection office within the Maricopa County Superior Court. And they help people with, they have what are called legal lay advocates that can help pro se litigants as well as litigants that have representation. However, As a domestic violence survivor, a witness of child abuse, and a sexual assault survivor, I always had fears of using their resources for fear of retaliation from my co-parent and from his attorney, which is Cantor Law, Ariel Cohn. Actually, at this time, my co-parent is no longer represented by Ariel Cohn or Cantor Law. He is a pro se litigant at this time. I also wanted to bring to the court's attention the fact that a lot of survivors have fears of using resources such as the Sojourner Center and going to shelters because of how abusers such that are coercive controllers, which is not pseudoscience, will retaliate when they are held accountable for their actions or when the victims and survivors seek assistance. I was threatened that if I had told anyone about the abuse after I had been hit in my stomach, actually bludgeoned in my stomach when I was pregnant, over 6 months pregnant with my child, and after I caught my co-parent suffocating our child, I was told that he would make it, my co-parent would make it so that one day our child wouldn't even remember that I was his mom. He told me that he would turn everyone against me, police, advocates, my family, my friends, anyone that he could, the family law system against me. There has been financial abuse, physical abuse, psychological and emotional abuse, and lawfare as well, vexatious litigation and retaliatory litigation. It is true that there is very limited, basically no judicial oversight. Parents are at a great disadvantage if they are unable to afford representation. We have what is called the PLAP, or also known as FLAP, the Family Law Assistance Program. It doesn't seem to be fully functioning. Back when I had temporary orders for sole legal custody and decision-making and parenting rights, and we had it was supposed to be just an evidentiary, well, we had a hearing coming up with a few things that were going to be covered. I was unable to get a call back from the attorney that the PLAP had provided me. And they put no one else in that attorney's place. So I had to go into court the next day, unprepared. I am not an attorney. I'm an educator of over 13 years. I am a coach. I've had a lot of different professional roles, but I'm not equipped to represent myself in family law, especially with how I saw it went down in the very beginning with the first judge, Michael Rosas. Michael Rosas, I don't know the exact details. He was not voted out of his position. He was recused, or I don't know what the exact verbiage is of his position in family law before he would have been voted out, and he was replaced by Honorable Amy Kallman. I want to commend Honorable Amy Kallman for putting in the orders. One of the things that she put in her orders, her court orders, were no physical or corporal punishment toward our child or threats of physical or corporal punishment toward our child. Since she has put those orders, things have improved greatly for my child when he is not in my care. I have seen a great difference. His therapist saw a great difference as well. I just wanted to say very quickly that I am a descendant of Anastasia Froh-Miller Collins. She was the first woman to run for governor in the state of Arizona. My family owned this land where the Capitol sits today. Her father owned it. She was a state auditor and also county treasurer in a few counties, including Maricopa County and Pinal County. She would be rolling over in her grave if she knew what was going on in this state today. She stood for justice, she stood for truth and transparency, and for reasonability. So I feel that I have a duty as an advocate and as a survivor and a mother to speak today, despite great fear of retaliation. Right now, my court case is going fairly well and reasonably. I have legal representation. I really did want to bring up, though, that part of the order where Honorable Kallman
dictated no physical punishment, no corporal punishment, and no threats of the kind, because not only was the physical punishment and where my son would be grounded for over a month, where he was not allowed to play with a single toy for over a month for very minor offenses, and for slipping up at school, like speaking up without raising his hand at school, very minor things. He was tortured at home instead of held accountable with appropriate consequences for a child his age. So maybe that's something that other judges can do, in the meantime, while they're reviewing evidence, is make that order that will not stop all coercive controllers and all abusers. It could be that more has occurred to my son, more has happened to him, more harm has happened to him, and he's too afraid to come forward, because I didn't win final orders for sole legal custody after the temporary orders hearing. I didn't do very well. I don't do well representing myself in court. My first attorney was Susan Pintel. There was a lot of evidence that she was working with and colluding with opposing counsel. She said that she had submitted exhibits that we had agreed upon. When I checked the ECR system, they had never been submitted.
You have about 30 seconds, ma'am.
Yes, sir. I have concerns about children's testimonies being omitted from reports, not only with DCS, but also with court-appointed advisors, such as Barb Kiffmeyer. I have concerns about Phoenix Police Department and the Goodyear Police Departments assisting abusers and coercive controllers and ignoring, dismissing, and allowing child abuse, as well as sexual assault. Stalking, the order of protection that I had was violated by Phoenix PD. They brought the person that I had the order of protection from to my home because I had decided to stop responding to a barrage of emails at my workplace as a teacher, and my personal email and multiple phone calls from my abuser. So yeah, children's disclosures being omitted. DCS ombudsman does not always return communication when we address concerns with the DCS ombudsman. Delayed medical procedures and surgeries. I have a recalled surgical mesh in my abdominal wall. I have been unable to have the surgical procedure to try and fix that because of this family court case. I need to put that to the side for years in order to protect my son.
Okay, ma'am.
Yes.
What's the one thought you want to leave us with?
We have to protect children. They cannot protect themselves. They are far too vulnerable. My son once said to me, Mom, if they threaten to throw me across the room again or out the window, or they threaten to kill me, or I'm afraid that they're going to kill me, should I run to a neighbor's house in the middle of the night? No child should have to think these things in this country. We can do better. It's not going to be easy, but we can do this.
All right.
Thank you.
Thank you for your testimony.
Mhm.
All right, any questions? Okay, no? Okay, ma'am, thank you for your testimony. Does anybody else that's put in a slip? Ma'am, you're going to have to come up front. We can't have it from the gallery.
Sorry, I misunderstood. Didn't know you both wanted to speak.
It's okay.
You
I'm
need to have a
Bridget
separate
Bring.
slip for both of you, for each one of you.
I'll make another
All
slip.
right, thank you. And your name?
Bridget Bring.
And you're from?
From Glendale.
Okay, you have 7 minutes, ma'am.
My sister went through the horrific parts of our case. I would like to speak more to the actions of the judge, in that I have what we lovingly call been the Google attorney for my nephew for the last 2 years with this case, because he has been representing himself. The mother has 2 attorneys and a criminal attorney. The judge, Paula Williams, in the case assigned Megan Stillwell as the best interest attorney, and she is basically the mother's 4th attorney. And I guarantee you that Paula Williams has not read any of the motions that I've filed. She ruled that a kindergartner needs to spend 8 hours a day in kindergarten, be picked up by her mother, spend 2 hours in a vehicle going 75 miles in rush hour traffic, to spend the night to be back at school the next morning at 8 o'clock. We filed a motion to ask her to please change those Wednesday visits back to a 3-hour visit on the child's side of town. She immediately denied it. She has admitted she does not read the motions that we file. She has basically said, if I see Kyle Flannery's name on it, I deny it. I don't read it. For 2 years, I have provided her with evidence, hard facts, evidence from police reports, from autopsies, from forensic psychologists, from forensic pathologists. She has ignored all of it. She has not read one motion. I finally paid for an attorney for my nephew on May 23rd. It has cost me $31,000 since May 23rd. If I had had an attorney for him for the last 2 years, I don't even want to think about what it would have cost us. She is biased. She tells my nephew, I am having this, because we filed a motion to ask her to stay her family court trial until we could have the juvenile trial, because they were literally a week apart. She set her trial date for June 4th after she knew we had a severance hearing date of June 13th. She said in court, you do not have a chance of winning in juvenile court, so we are having this trial. So we did have the trial, and after we had the medical examiner and the forensic pathologist testify, she came back in and she says, well, 1 day is clearly not enough for a murder trial. No, it's not, and a murder trial shouldn't be happening in family court to begin with. But we're in a murder trial, and she's giving unsupervised visits 3 weekends a month and every Wednesday to this person who married her other child's murderer.
Have you filed a complaint with the Commission on Judicial Performance?
My sister has.
Okay.
Yes.
And, yeah, see no evil, hear no evil. All right, thank you.
So she's done that, and she also, the forensic, she is so unprofessional and demeaning and rude, and I don't even have the words. I'm very very passionate right now, just because this has been a long time coming.
So do you have a copy of the complaint that was filed to the Commission on Judicial Performance?
We can get it for you.
Please submit that to my office.
Yes. And just one last thing, the forensic pathologist we hired is Maricopa County's #1 recommended expert. He has a slight accent, and during his testimony, she said to him, I am an American. Can you speak to me in American?
And has there been a complaint against that?
That was last Friday, so we're in the process of filing that complaint right now, so, yes.
My other recommendation, I'm not giving you legal advice here, file that complaint to the presiding judge over the family court for Maricopa County.
Okay. One other thing I want to talk about on the I've heard a lot of people talk about the forensic therapist that they've been involved with. Ours kind of went the other way. She ordered it, but then never followed through with it.
Mm-hmm.
And when we brought it to her attention that her court orders for unsupervised visitation are based on this forensic therapy assessment, which never happened, she completely ignored it. She's told her attorneys 3 different times to file proof with the court of the provider's qualifications and of the assessment. That's never been done. She doesn't do anything for them.
Okay.
The court-appointed attorney, the best interest attorney, has now inserted herself into the juvenile trial by having the court-appointed attorney in the juvenile case make a motion to provide her reports as evidence. So she's now trying to insert herself in the juvenile trial as well. So
Do you, if you don't mind, for this particular judge, where those comments were made, if you could request from the clerk of the court the
audio recording,
the transcript for that court proceeding, and forward it to my office, please.
Okay,
All
absolutely.
right,
Thank you so much.
thank you very much, ma'am. Okay, we got one left. Rachel Cardina Merritt. How are you doing, Rachel?
I'm well.
I
I'm
gotta
gonna
give,
be.
I
I'll
gotta
be.
give you the same treatment. Give your
Nice.
name, where you're from, and you got 7 minutes.
I won't even take 7 minutes up.
All right.
Well, good afternoon, Senator Fincham and Representatives Cashel and Fink. Since we last met a month ago, at least 5 children have lost their lives due to family court's refusal, not failure, refusal to protect them. In the last month, in my personal case, it was discovered that the physical abuse of my own children had continued and intensified, with my 12-year-old son being strangled by his 6'5", 450-pound father. This attack occurred in the presence of his 11-year-old brother, who stood paralyzed with fear as his older brother, best friend, and confidant gasped for air. As he was strangled with one hand, he was poked in the eye with the other and told, "You don't control me, I control you." My son is now being assessed for thyroid issues that are potentially related to prolonged strangulation over an extended period of time. My ex-husband openly admitted to regularly strangling our 4 boys, calling it chokeslam, trivialized the pain of the children and their injuries simply by saying it's a game that he enjoys playing. When I learned of this, I immediately took action to protect my children. I took my son to the emergency room. The ER staff thereafter repeatedly contacted DCS and the police. My boys underwent forensic interviewing, and they were found to be credible. I am extremely grateful to the Peoria Police Department and to Detective Hudak. I then filed for the emergency custody of my children, which Judge Melissa Zabur declined to rule on. The guidelines in court state that if you submit the petition before 4 p.m., the judge is to rule that day. If after 4 p.m., they have until noon the following business day to rule. Nearly 2 weeks later, Judge Melissa Zabur hadn't even made a ruling. Last Thursday, I participated in what was called a status conference, in which no one is allowed to participate. Not even my DV advocate was let into the call. There were approximately 17 people who tried to log into that call. All of them were declined, including my domestic violence advocate, who was listed as a domestic violence advocate pursuant to my ADA requirements. She was not even let in as either. I was maligned and lied on. Facts related to the history of our case involving myself were misrepresented, and I was told that because I hadn't requested an emergency order, an order of protection, instead I requested an emergency motion, my fear for my children was invalid. For context, in 2021, I was admonished by Judge Como in the same courtroom for seeking an order of protection instead of an emergency order when my ex-husband chased me into our children's school building and was thereafter found waiting for me outside the school with a loaded gun. So they contradict themselves. A few years ago, because I got an order of protection, I was admonished, and not only was I admonished, I lost contact with my children for 3 weeks. I missed Christmas of 2021 and New Year's of 2022 because I was being punished because the judge said, and I quote, "You went behind my back and got an order of protection. You should have came to me." So this time I tried to do things differently. I went to the court and I was admonished because you should have got an order of protection. You shouldn't have came to me first. So I don't know which one it is. This is a constant thing. I was ordered to hand over my children an hour after the conclusion of that status conference. And it's important to know that orders are not supposed to be issued during status conferences. They're supposed to be just a 30-minute, what's going on with the case. I was ordered to return the 4 children an hour and a half later, 45 minutes away from the house, to their father who had strangled them and who admitted to strangling all of them.
Did you have counsel present?
I did.
And counsel said what to that in a status conference?
My counsel was shocked. He had never, I had explained to him, expressed what had happened with his judge. He didn't believe it. He was completely, the rug was pulled from underneath him. So he advocated for me. He reiterated to the judge, this is not the process of court. You are not to order during the status conference. She said, well, I'm not ordering. I'm just saying she needs to follow this order, and if she doesn't, she'll be held in contempt of court. So she pretty much was saying this. They explained to her that she's doing this for the sake of her children's protection, and it's important to know, and I'm so glad you asked, the Peoria Police has moved forward. The investigation is over. It has been transferred over to the prosecutor for charges.
Okay,
So
if you would, Could you get me the transcript of that hearing, that status conference?
Yes, sir, I'll get that to you.
All right,
I
thank
just
you.
had one more thing quickly, just for context.
All right.
According to the National Domestic Violence Hotline, strangulation is a significant risk factor for homicide, and it increases it by 700%. So when someone strangles their child, the likelihood that that child will go on and be killed by that parent is 700%. Children who experience physical abuse, including strangulation, are at a higher risk for developing mental health issues such as anxiety, depression, and PTSD. All 4 of my children have been diagnosed with PTSD and are not allowed to get treatment pursuant to court order that says their father has the right to make those decisions.
He has sole
No, sir.
authority over decision-making.
No, sir. He's given final say, so my children cannot go to the dentist if he says no.
Well, that's what I'm saying.
Yes, sir. Final say
Oh,
with a history of abuse.
so, court-sanctioned child abuse.
Yes, sir. Exactly.
Okay, all right, I get it. Yes, that's a message direct for the court.
Yes,
We're paying attention to what you're doing, or not doing, okay? All right, thank you, ma'am.
Thank you.
Good to see you again.
Good to
I
see
wish
you.
it wasn't under these circumstances.
Thank you.
Dr. Lee, do you have a moment? Could you come up again?
Yes, Your Honor.
Yeah, I'm going to use you as much as I can while you're here. Thank you very much. We just heard the testimony of a mom talking about strangulation of a child and the damage that that does to their psyche. And just as a retired law enforcement officer, I'm very in tune with crimes against persons, especially those that are up close and personal. Stabbing, strangulation is far different than a firearm or something else. Could you just for a moment opine on the psychological damage that is done to a child when a trusted individual, a parent, a co-parent, when there's that kind of a personal attack against this little human, the damage that does? Could you opine on it for a moment?
Well, just psychologically in general, when there's, especially when it's something that could be life-threatening, then the damage is...
Can you get a little closer to the microphone? We can barely hear you.
Yes. Usually for children, they dissociate from reality, and it becomes much harder to engage with reality. And that could, over time, settle into a kind of traumatic response that will make them be unable to engage with other people, to form the relationships and the bonds that they need to grow. Human beings are hugely social animals. Our overgrown forebrain is meant for social interaction.
Mm-hmm.
And there's an entire segment of life that one will no longer be a part of because of that trauma.
What is your opinion of this concept of therapeutic interventionist?
I'm actually not very familiar with that term.
Well, allegedly, it's a forensically informed psychologist, whatever that means.
And I encounter all these terms and seemingly psychologically related qualifications that I've never heard outside of family court. Either one is a forensic psychologist or...
Well, that kind of makes me think that it's on the fringe if it's not widely accepted within
I have never heard
accepted
of it.
psychology circles.
It's you're either a forensic psychologist who goes through extra training apart from...
And that's a specialty field.
Yes.
Uh-huh.
But forensically informed psychologist, I would just count as a psychologist.
So that's kind of like, I am because I say I am. All right. Thank you very much, ma'am. And I really do appreciate you lending your expertise today.
Well, thank you. I appreciate you.
Okay, I think that's it. All right, ladies and gentlemen, thank you very much. We appreciate you participating today. This will be archived with the Senate Video Library. We will have another hearing. It'll be number 4 of 5. We do not know yet what that date will be, but the primary focus of that hearing will be DCS and CPS. With that, we are adjourned.
over the years has been